Morning, people. Morning. I'm over here trying to make I'm making a banner. Trying to make a banner for this stream, y'all. Not a banner. It's called an overlay. Trying to put an overlay of our logo here on the stream. And so y'all are gonna see this overlay up here, this live with StreamYard. I'm gonna be changing that up. So you're gonna be seeing different overlays come up. Let's see. Let's see how this one works. Yeah, that's not bad. Parrot, let's see. Let's play a video here and see how it looks. How about this video?
Would like to ask you, after the two occupants of the vehicle were
Y'all bear with me. I'm trying to get this right. So it might be a little bit of technical back and forth. Don't worry about it. Don't worry about it if we have a little bit of back and forth. All right, so this
the vehicle had been sent to impound.
Morning, everybody. Morning. I'm over here doing some technical stuff with the StreamYard, so y'all work with me here.
They would be transported by myself.
Trying to get
Officer Munson
our overlay
the
onto
city annex to be put into
the
evidence.
screen.
with incidents that happen at the APD, that APD responds to, are they giving?
Let's see here. That takes me off.
Yes.
And do you know the APD case number associated with this incident?
Yeah, it'd be right here on the report in front of me.
Tell the ladies and gentlemen of the jury.
That overlay's not half
Read it
bad.
right from there.
You can look at it and
Okay.
recall it.
All right.
Morning, Hayden. Morning, LaDonna. Morning, Dav. Morning, Paulette. What you worried about, Dav? What you worried about? Morning, one Lola with the info.
Okay, what is that?
Morning, Carlisha.
274-0150.
Vanessa, morning. Dav, what you worried about?
It stands for case
Oh, I said that word.
to your
Yeah, you know, it's funny because like you have like one little hiccup. It's because I maybe I shouldn't look at the number of people who are watching, because you have like one little thing happen and you see the number drop by like 50 people. And it's like, was that a coincidence, or are people that sensitive? This overlay is not half bad, is it? All right, so this shows only me. Can y'all still hear the sound?
Good morning. Is it
While you're seeing me, can you still hear the sound?
Agent Doherty, yes.
Agent Doherty? Good morning, Agent Doherty. My name is Doug Weinstein. I'm the
This
attorney
doesn't
for
change
Devontae
anything.
Kendrick.
This
So I have
doesn't
a few
change
questions.
anything.
You
This
were-
makes me big
you testified
and puts
that
the
you are
video
person that
small.
apprehended,
This puts me to the side. I like
Mr.
this
Arnold,
view the
correct?
best.
Yes, sir.
and you tased Mr. Arnold.
Sound
in
is
order to
low.
Apprehend him, correct?
Yes, sir.
Did you knee Mr. Arnold in the back?
Oh yeah. This
Is it-
where
is
Doug
it Agent
Weinstein
Doherty?
comes and y'all gotta line this up.
Is it okay if I read it right from there?
You can look at it and
Okay.
recall
All
it.
right.
Okay, I just increased the sound, so yeah, okay, cool. All right, so we have our overlay here, which is Paralegal Institute, which is not bad.
Okay, what is that?
15274-0150.
You know what I was thinking? That's kind of
And
embarrassing yesterday when y'all heard me, like, I was actually just chopping up my eggs, you know, but the plate was like right by the microphone, so it sounded like ding, 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 ding. It sounded loud. But I was like, you know what? I don't care. First, I was like, ooh, that's kind of embarrassing. But then I was like, I don't care. this is gonna be a stream where that kind of thing happens. So if you like me, you like weird stuff
with
happening
respect
every
to
once
your
in a while,
involvement, did
y'all
that
just on the stream. If you want to professionally
conclude your
produce
involvement
stream,
with this matter?
well, this is probably just not going to be that. Too much stress.
State
Trying to
has
make
no further
things
questions
too
for this witness.
professional.
All right, are there defense questions for this witness?
So we just a little bit unprofessional around these parts. Okay, I'm wearing a hoodie for goodness sake. I'm wearing a hoodie every day for goodness sake. So it's gonna be a little bit. Yeah, okay, let me pause for a second. That's the funny thing. Because this is the thing that I gotta tell you this. When I'm watching, so usually I'm watching this on my computer, which is right here. So I can't hear the stream. I can only hear the audio from the video, but I don't hear my own voice coming back to me. So it just so happened because I was going to the kitchen, I put the stream on my phone and my headphones. So I was listening to my own, I wasn't talking obviously, but I was hearing the stream. I wasn't saying anything. So when I sat down and started chopping up the thing, I'm hearing this in my earphones and I'm like, yo, are they clanking in court? Like, what's going on? Are they clanking over there? And then eventually I hear it real loud. I'm like, what's going on? I was like, is that the sound from when I was just in the kitchen? Is it delayed? And then I was like, oh, I'm chopping these eggs up and I still have my microphone on. I would have never known if I didn't have the earphones on because I don't hear my voice. Like right now, I don't hear my voice in all the sounds from my house. I don't hear it come back. But because I had the headphones on, it was looping back. And I was like, oh my gosh. Look, I appreciate all the supers. Clizzle, you are almost single-handedly keeping this whole thing going. Like you're the patron of the patrons. But I need one thing from you. I just need you to tell me, is it C-Lizzle or Clizzle? Okay. Hit that like button. Yes. I wonder if SlimeLife going to be there today. Is it possible jury hears all this doubt? They still say guilty in your opinion. So, yeah, I put that on the thumbnail. They were talking about Winnie Lee yesterday. I do expect that we expecting him to testify at some point. But remember, there were two. Miss Sylvia said there are two witnesses who are not being cooperative, one of which is called Obama. He is in a probation violation situation, kind of like Montonk, but not because of his testimony, because he hasn't testified yet. Obama is in probation violation due to some kind of shoplifting or theft, apparently. Okay. So that was one of the two. The other one we don't know. Is it Winnie Lee? Apparently he has the least stringent plea deal, meaning it seems this is just what people are saying, that he has like the most liberty to not cooperate, I guess, if you want to say it that way. Like Montunk had very little liberty to not cooperate. So what does that mean? That's a double negative. You can't not. What does that mean? That means if you do, you get in trouble. As we can see, Montunk did very little and he got in a lot of trouble. We would all agree with that, right? He did a little bit, but he got in a big amount of trouble. He did a little, got in a lot of trouble. So that's Montunk. Winnie Lee, apparently he can do a lot and still not get in trouble, meaning he can do a lot of uncooperation and still not get in trouble, I guess. We'll see. Is it possible jury hears all this? Doubt they listen, y'all. Pause the video, bro. The video's paused, man. The video's paused. What are you talking about? What are you talking about, Andre? The video is paused in the background. Can't hear me clear. I can hear him perfect. Andre, it might be something on your end. Dav said Dav can hear me. It's C-Lizzle, it's not C-Lizzle, it's Clizzle. Okay, Clizzle, got you. Thank you, Clizzle. Thank you for the super. So back to your question. Y'all, we should all be prepared because we're kind of invested attention-wise, emotionally in a sense. We're a little bit invested or a lot invested in this trial. There are going to be some guilty verdicts, y'all. Okay, so just there's 56 counts. Somebody gonna be found guilty of something. So I mean, the idea that it's gonna be not guilty for all 6 people for all charges, I don't think that's realistic. I don't think it's realistic to expect it. It could happen, but it would be an outlier. It would be a a miracle for them, frankly. So somebody's going to get found guilty of something. Now, remember, I'm not saying this person will get found guilty of that thing. I don't know. But the only reasonable expectation is that they can maybe get off, that maybe some of them can escape some of the major charges and some of the major penalties. But the idea that the jury's just going to say, we're going to find all 6 people not guilty of everything, of all 56 counts, I don't think that's realistic. So again, don't misinterpret me as to thinking I'm expressing my personal opinion of people's guilt. That's not what I'm saying. What I'm saying is the vast number of charges with 6 different defendants, the law of probability says the jury's going to find somebody guilty of something. We just don't know who it will be and what they'll be guilty of. I think a win for the defense would be having most of the defendants not guilty on most of the charges. And that's looking at the defense as a group. Because remember, Brian Steele does not represent the group. He represents Thug. So frankly, and honestly, I would say the prosecution has done a poor job of dividing the defense. Frankly, the defense, each of the defendants is working together in a sense because they're all on the same RICO, but it really is every man for himself from a perspective of I can get off and you can go to jail. So I don't necessarily know if we should look at it as how can the defense win? Somebody's going to get found guilty of something. Okay, so that's just the law of probability. But will Thug get found guilty of something? Maybe not. Will Shannon Stillwell get found guilty of, he's facing, I think, 2, offings of people? Maybe not. So we have to see who's going to get found guilty of what. And I think if we say the defense in a different way from how they say it, at least in the long run, we're looking at them as a group, and in a sense they're working as a group, but the penalties are individualized. They're not like a basketball team where they're all going to get a championship ring or they're all going to go home sad. That's not how it is. They're more like, kind of like, I guess, people in a war where your boy can literally get off right beside you. He lost the war. Your team could win the war. Your country could win the war. There's a bunch of people who are not going home. So we don't know. So we don't know. We don't know if so. Clizzle, when you say, will the jury say guilty or not guilty? We really want to talk for whom, right? Because we see them as a group and they are being treated as a group. But at the end of the day, just like at war, at the end of the day, they will either go home or not go home individually. Does that make sense? We have a new member, Roxy Louise. We definitely appreciate that. We have a new member, Roxy Louise. Thank you. Roxy Louise, you now have access to all of our emojis. I'm gonna see y'all once trial gets started today. I'm gonna see if once trial gets started today, I will see if we have new emojis opened up and we can get some more. Donna Hamilton or Hallman, excuse me. Good morning to you. If Obama already in jail, why come out? So is that UNITA? Yes. Very interesting strategically to violate Obama while you want him to testify. Very interesting strategically to violate Obama while you want him to testify. But UNITA, I've heard people say that, but think about this. Think about this. violating Obama, there's two ways to look at it. You can violate Obama. So Obama is now being violated. When I say that, I mean that the prosecution, the DA's office is looking to, I guess, revoke his probation or part of his probation, just like what happened with Moncton. But this is a question. Could they be playing a game where they revoke some of his probation, UNITA, but maybe not all? And they say, no, but you're still under this testifying thing. I don't know. I'm just speculating. I'm not even speculating. I'm theorizing here. This is not even speculating. It's a question. Could it be that they're saying, no, you're still under the duty to testify, and if you don't testify, we'll revoke more of your probation, or we'll request an additional revocation. We'll, for the shoplifting thing, we're looking to revoke 2 years, but if you don't testify, we want to revoke 8 more years to give you 10 years revoked. I don't know. It's not even speculation. It's just a question. Making you jump through hoops for this. Listen, y'all, the main reason I'm doing these lives, y'all, I'm telling you right now, the main reason I'm here on live every day is because I want to build a community. I want to build a group of people who like me, who like what I'm doing, bring on some other people on our team so that after this trial is over, we have a group that can continue to just roam around YouTube, roam around the internet, find cases, find interesting things to talk about, and just continue to be together. So that's why I'm here every day. Like this, it's not difficult, but it is very, 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 very time consuming. That's why you see me turn off my camera. Sometimes I'm just doing other things. So this is very time consuming, y'all. But I'm trying to build a community. And that's why I'm committed to doing this every day. Okay. Hello, Leah. Worried about the jurors because pretty sure Glanville assembled or selected them. Y'all, somebody's going to get found guilty of something. Probably. Okay. Again, not expressing a desire or a wish, more expressing just my opinion based on the law of probability. Good morning. Miss Lily is Slimer. Miss Lily got the Slimer up. All right. Miss Lily got the Slimer. Looks like we're ready to go, y'all.
Because when you left court, you did not ask that request, you did not know that request was made. And so,
Okay, this is just about scheduling.
All right. Volume's all the way up. Oh.
Well, it had been the understanding, I think, of the sheriff's office that y'all weren't going to use that witness at all. So, I mean, I don't know.
yes, Your Honor.
Yeah, we had an issue come up, Judge, so we can address.
Okay. Do y'all want to approach?
Sure.
All right. They're already. So they're talking about a witness in the sheriff's office. So this would implicate somebody who is probably either in jail or in prison right now. They're talking about a witness in the sheriff's office. So that would indicate, somebody who's in jail or in prison. The best witness, everyone goes home and looks after themselves. I agree from the perspective of the defense, that would be the best. I was just saying, I don't think it's likely based on the law of probability. If it was one person facing, even if it was just one person facing 10, 20 charges, you could reasonably say somebody may go home, he or she may go home not guilty of all charges. But when we have 6 people facing a variety of charges, the law of probability says somebody's going to get found. I think the Thug will get through this with a not guilty. So I think if you had to place your money on one thing happening, one person getting found not guilty of one thing, it seems like there's been nothing to show Thug was involved in a RICO. So I think Taylor Dutton, I agree that seems to be the most reasonable thing the most reasonable idea, the most reasonable thought. But let me ask y'all this. How would you feel if Thug got off on everything, but the other guys went to prison for lengthy sentences? Like, what if Thug gets off on or is found not guilty is a better way of saying it. What if Thug is found not guilty, but the other guys are found guilty of various different things? Would that be satisfying? Would that be a satisfactory way of resolution to this case? Or would it, again, I'm not speculating that will happen, but just following up on what Taylor says. Miss Lily, hey, top of the morning to all of our chat peopleses. Slimer, Miss Lily's now Slimer. The defense, yes, the defense is unified. I said to you all earlier, and maybe this is what people I said earlier that the prosecution seems like they would try to break them up and try to divide them, but they haven't been successful with that. Morning. Unita, I don't think none of them is guilty of RICO. That's BS. And if they already did their time for what they were caught doing, let me go. I agree with that. So far, and I don't know the prosecution strategy, but so far, whatever they've shown, it does not seem like. So this is the thing. Does it seem like they could make a reasonable accusation that YSL was a gang? I think they are a lot closer to showing that YSL could be considered a street gang. That is a conversation and a debate. I imagine most of you would want to say no. But you have to at least be able to say, if you're reasonable, you have to be able to say it's debatable. I know it's a record label. Okay, it's a record label. We all know that. So let's not say that just because it's a record label, it couldn't be something else as well. So I think if the charges were somehow criminal street gang only, then at least people who are reasonable could debate that. Right? Some people might say no, some people might say yes. But at least if you're an honest person and you're reasonable, you could say, I think there's a debate here. Even though I fall on this side or that side, I could see the debate. The problem with the RICO is that I have not seen evidence that this record label, well, it would have to be a criminal organization. So if we were to say it's a criminal organization, even though it's a record label as well, if we were to agree that it seems to be a criminal organization, it doesn't seem like there's any profit or gain that comes out of it. It just seems at the very worst that you have a group of people who are criminally inclined, who form a group, give it a name, and just continue to commit their individual crimes. So at the very worst, it would be a criminal street gang or a criminal gang who is associated due to this reason or that reason, but they tend to commit individualized crimes, not a crime in furtherance of anything. That would be the worst case scenario for me. The worst case scenario would be this is a criminal gang.
So you want to buy a house using your...
Oops, I got to change my YouTube. Give me a sec, y'all. Got to change over to my other YouTube channel because this one plays ads. So at the very worst, it would be a criminal street gang. It would be a criminal gang that does not that does not have, they're not working together for any kind of gain. So therefore, I still don't see how we come to the point where, let me put it back. I had to change to my non-commercialized channel. Sorry about that. So I still don't see how we get to the point where we call them a, now why is it showing up like that? Okay, there we go. So I still don't see how we get to a point where we call this a Rico. Sorry about that. Nintendosa, how you doing? It's been a while. I've been watching merchant videos when she's drilling that public records office last month, and the head records custodian, Mr. Bondo. You know, don't people know that they're on camera, y'all? Don't people know they're on camera? Grand Rising. So are y'all with me? Yeah, he might get sanctioned, but he gonna do something. Who you talking about, Carlisha or Carlisha? Who you talking about? If the defendants are found not guilty, what happens to all the people that got their probation? Oh, it's over for them. It's over for them. Well, let's talk about Monk. Monk is going to prison, barring some kind of miracle, basically. He's going to prison regardless of what happens with this trial. Okay? Monk is going to prison regardless of what happens with this trial. It does not matter for him.
Does anybody have a proposed instruction to submit? Or comments about the one that the court drafted?
I do, Your Honor.
All right.
Good morning.
Good morning.
I just pull it up for a second.
Sure.
Good morning, Your Honor.
Morning.
On paragraph, it's in the alternative wording for Mr. Kendrick. It states, hold on, I've lost my place.
And it, honestly, I'm looking at it now, and it may not even be 100% applicable. That second sentence in the alternate wording, I had just noticed that in the other guilty plea limiting instructions, that was more the language. So I was throwing that in for y'all's consideration as to whether anybody would prefer wording of that type to the couple of paragraphs above that. But yeah, I mean, whether another person has been convicted of the same charges isn't necessarily applicable anyway.
So, and my concern is that the Honorable Court's not addressing, yes, I understand that something could be used against, I'm just using his name, but Mr. Kendrick, not against the others, but
Right.
but then it says that you can use the other evidence, and there's no instruction that's only if the jury finds beyond a reasonable doubt that one or more of the persons entered into a willfully and knowingly. And
Right, but we're talking about overt acts. I mean, they're going to have to, that's another step or portion of what they're going to have to decide. And obviously, they're going to get full instructions at the end of the trial. So I'm not going to get into, here's how you're going to consider all of these different parts of the RICO count, you know?
I do understand, but as a listener, I guess, for a juror, they don't even get to decide the acts unless they first find it. They could do it any order they want, I guess, but they first find that there was a willful and knowing joinder of the conspiracy.
Sure, that's a part of what they're going to have to find as to each defendant before they can convict anybody.
And I'd like that language in any instruction, because otherwise, let's assume that this trial ends, the state rests in December. That's approximately a month and a half, maybe 2 months from right now. Meanwhile, the jurors are being conditioned, in my words, from the Honorable Court's instruction that, hey, yeah, we can use evidence against everybody except certain evidence. So I'm going to realize that this is against everybody before there's been no instruction to my knowledge in this entire case that they have to first find that there's a conspiracy, that a person joined the conspiracy. So
They're not supposed to be deliberating until the end of this case, the close of all the evidence, all of the jury instructions. So there isn't a danger of that.
okay, well, that's my problem.
All right.
Because
Well, I'm not going to give them a full kind of mid-trial mini instruction on how to consider RICO. They're not
Okay.
supposed to be doing that yet.
Okay, I'm not trying to say a full instruction, but just a line, maybe. I put it in.
I mean, I can say, I'll give you further instructions later
on
how to consider all of this.
and whether a conspiracy even exists or a person joined a conspiracy. That's what I'd like, because I do find, and yes, I understand that they'll be instructed later, but I do find that it is, jurors should have some context of this instruction. This instruction standing alone seems like it's already, that there's a suggestion. I'm not saying the court's doing it on purpose, by the way, but there's a suggestion that other evidence can be used against everybody. Well, that may not be true.
I'm only saying it as to if the state presents evidence aside from the guilty plea as to overt acts 56 through 59, and then aside from Mr. Ryan's trial conviction as to overt acts 79 through 81, which, I mean, they're certainly doing that for the murder of Jamari Holmes. They're doing it right now. So I guess I don't believe that it is broader than what this is saying, which is specifically as to those enumerated overt acts.
Now, I would like something, if you, ladies and gentlemen, find, based upon my instructions that will come at the end of the case or at an appropriate time, that one or more of the people on trial knowingly and willfully joined a conspiracy, then go into something about then you may not use the guilty plea or verdict, whichever.
All right, well, I
against anyone
appreciate
else.
that, but I don't think that's necessary,
Okay.
and I don't think that this misleads them into thinking anything at all
Okay.
wrong, really. Okay.
And
So,
I still believe my original that the evidence shouldn't come in at all, because I'm struggling with the instruction. So,
all right, well, I
with that
think
being said.
in terms of if anybody would prefer the language, you may not use this conviction in your consideration or deliberations against any of the other defendants in this case. It is not evidence of anything against these other 5 defendants. Each defendant has a right to have his guilt or innocence determined by the evidence presented against him, not by what happened with regard to a criminal prosecution against someone else. That's one version. The alternate version is you are not to consider the co-defendant's, whatever it is, conviction as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of, charges or something. I don't know what that language is, but any preference as to which of those two the court uses? No, nobody cares. Okay.
I don't want either one. Sorry.
Well,
either one. and I'd
I'm
like to-
definitely going to give one or the other of them, because if I don't give one or the other of those, then it will be reversible error in the event that there ever is a conviction in this case, which of course would be ultimately a benefit to your clients to build in reversible error. But I would prefer not to do that, because the court's job, to the extent I can, is to avoid any error at all, much less reversible error. So I'm going to give one or the other versions of that language. Does anybody have a preference as to which version of that language the court will give?
Your Honor, can we, since I have a preference, I still maintain my objection. I don't think it's reversible error if you keep out these pieces of evidence, and that would be my preference.
No, I don't think so either, but that's also not fair to the other side.
Can we just huddle for a minute
Mhm.
so we may have
And
a split?
y'all don't have to tell me right this instant. I just need to know before the conviction is going to get introduced, which may be sometime today.
Yes.
Okay.
And if they're huddling now, once they're finished huddling, we just have another announcement to the court.
All right. How about announce, and then if they want to huddle, they can huddle.
So- And good morning, Your Honor.
Good morning.
The state does intend to call Mr. Lee this morning.
Okay.
He will probably be our third witness this
All
morning. I know Miss Abbasi and I were supposed to speak very briefly after they're huddling. We can have just 2 minutes to speak.
Well, I may have them huddle later
Okay.
because the Wooney Lee stuff's more pressing, because you can tender the conviction, in any order.
Yes, Your Honor.
So on the Wooney Lee evidence, is there any objection that still needs to get hashed out?
Yes, Your Honor.
All right. Okay, and then if so, where's the easiest place for me to find the
Your Honor,
evidence?
if I may, there's something we wanted to address first.
Okay.
Your Honor, I've got some members of the defense side here taking a look. Our understanding, and if it turns out to be wrong, it turns out to be wrong, was that the state was undecided yesterday as to whether they were going to call Mr. Bernard Mitchell. I know at the lunch break, Mr. Hiles was on the stand. His text messages had already been admitted. We went back to speak with him. The state went back and attempted to speak with him. So at that point, my understanding was it was still up in the air. I can be wrong. My understanding was it was still up in the air. Per Your Honor's request, we had discussed as many things ahead of time as possible. The discussions with the state were, and it was very clear for both sides, that we were not going to be objecting and not asking this court to litigate Mr. Mitchell's Instagram records because the state was going to call him. Yes, with them coming in, there were portions that we intended to use with the understanding that that is what would come out in terms of evidence. His messages would come out, so we would want another section in there. If the first section is in there, we would want the second section in there. But he's certainly not our witness. The evidence he presents is not a theory of the case that we would have brought to the table. And so now the state does not want to call him. And I think we're faced with a confrontation clause issue because we relied in good faith on our discussions with the state. We didn't go through and take the court's time to say this is conditionally admitted based on this happening. So we simply relied on what they represented to us. We had the evidence, came in, it was read out. I contacted the state last night to say, hey, I'm not sure what you want to do about this. We feel in a position that we are forced to ask for a mistrial. We really don't want a mistrial. We'd like to be able to rely on what we were told. And like I said, we're checking to see if there was something definitive on the record. But if Mr. Mitchell is not testifying, then we feel we have no option but to ask for a mistrial.
Would the state like to be heard on that?
I guess the state's response, Your Honor, is that the state, after the lunch hour, indicated to
Talking to the mic, pick one up maybe.
the state after the lunch hour indicated to the court, as well as counsel, at least for Mr. Ryan, indicating that we were not going to call Mr. Mitchell, basically because he told not only the state but defense counsel that he wasn't going to say anything when he came onto the stand. That was the same thing that was told to us by Mr. Uten. And my recollection is that it was an either or is what the understanding was. It was we were going to maybe call either Mr. Uten or Mr. Mitchell. And yesterday we decided neither. So I don't know how there could be a confrontation issue that's being claimed today. If we decided to put Mr. Uten up yesterday and not Mr. Mitchell, the records would have still come in the same fashion without Mr. Mitchell testifying. More importantly, before any message came in as it related to Mr. Mitchell, the state indicated to defense counsel that we were not calling Mr. Mitchell. We indicated that to the court as well.
I don't remember y'all indicating anything to the court until the end of the day, y'all. But what I was told by the deputies was that the state had very clearly said they can be transported back. We are not calling either of them. And that was right after the lunch hour that I was told that. I asked yesterday morning, is this an either or? And yesterday morning, the state was definitely indicated, you know, it might be one, it might be the other, it might be both. We don't know yet. We still need to talk with everybody. And then we just went on with the trial, and they didn't, you know, after lunch, they went back because y'all had made that determination, and you certainly communicated that to the deputies with regard to transport. And you are making the representation that you also let the defense know that. Did y'all disagree that the state let y'all know they didn't intend to call either witness?
Excuse me. At the very end of the day, I had inquired to the court, said, you know, discuss what's going to be the order tomorrow. And I said, well, Mr. Mitchell, Mr. Uten, checking, Mr. Kokomo took a look, and before lunch, what was represented to the court said, you know, who are we going to get to? And they said, we may not get to him today. So
that was before lunch.
That was before lunch. And then we came back in and everything was published.
And everybody I mean, not everybody, but counsel for Mr. Ryan and counsel for the state spoke with, I guess, Uten and Mitchell over the lunch break.
We went back. He didn't want to speak with us. That's fine. We went separately from the state.
Right.
We didn't discuss anything with the state about who would or wouldn't be called at the lunch. And I don't believe before we started in the afternoon. That's not my memory. The announcement before lunch was we may not reach him today. They spoke with him. Obviously, at the end of the day, I still thought they would be called.
My recollection is after lunch, I was sitting there. Ms. Abbasi said, so you're not calling Mitchell? And I said, no, we are not calling Mitchell. That's my recollection before Mr. Howes began testifying after lunch. And we didn't call Mitchell. And the messages came in unobjected or not objected to. And there's been no conditional admittance of evidence that's been permitted or agreed to by any of the parties during the trial of this case, at least the time that I've been here. So it's my indicator, be the state's opinion that any objection to the messages that came in are waived at this point.
Your Honor, our response is, we have difference of memory. That's fine. It is what it is. If the state knows they're not going to call him going into it, I don't think it's fundamentally fair for them to publish and then say, haha, you missed it. I don't think that's that's good faith. As far as, no, we didn't conditionally admit it, because we've done everything we can, at least for Mr. Ryan, to avoid taking up the court's time. This is what it was. We all agreed, we all understood. So that's how we proceeded. And now here we are, and we're stuck in a position we don't want to be in.
Well, I'm not quite sure what to do with this. I have a representation from Mr. Abadi that the state communicated to defense counsel that they were not intending to call Mr. Mitchell or Mr. Uten, and that was communicated prior to Mr. Hiles' afternoon testimony in which this evidence came in. And Ms. Abbasi, you're saying, well, it's not my recollection, but I could be wrong. That might be. So
I will not say my memory is perfect. I have no memory of having that conversation after lunch. I'm not going to say, Mr. Abadi's, I can't promise you my memory is 100% accurate. And I'm certainly not getting up and saying that Mr. Abadi's lying. I'm not going to do that. But I have no memory of that conversation at all. And, as I said, I brought up at the end of the day, what's the order of the witnesses? When are Mr. Mitchell and Mr. Uten coming in?
I don't remember that.
I had brought it up when we were asking about witnesses because I didn't know if the sheriff needed to bring them over. And that's what was coming up.
Are you saying that you on the record asked when Mitchell and no, you didn't?
That was at the very end of the day. We were just
Amongst counsel?
I believe Your Honor was on the bench when we were discussing just who are we getting to tomorrow.
Yeah, I asked who we were getting to tomorrow. I don't recall you saying, when are we getting to Mitchell and Uten?
Well,
I don't recall the two of them being mentioned at all at the end of the day.
I know I asked the state at that point, oh, you're not calling him? No. And at that point, the evidence had already been admitted.
I'm asking you, did you make that statement on the record?
I don't believe so.
I
We can
don't
check the
either.
record, but I don't think so. I think the last statement on the record was we may not get to them today.
I don't recall that statement on the record or off the record. This is all a surprise to me this morning that now there's some debate about it, because everything I knew post-lunch yesterday, although through the sheriff's office, not through the state or the defense, was that a decision had been made and communicated that neither of them was going to be called. I mean, can't really do much else with I don't see a basis for a mistrial. So we need to deal with Wooney Lee's evidence. And y'all are just going to have to communicate or put more things on the record or something if you want to avoid misunderstandings in the future.
That's fine. We'll litigate everything forward.
Or just put on the record your understanding.
Yes, Your Honor.
So if the understanding was these will come in if Mitchell testifies, just say, we talked about all of this and we don't have any issue as to, X, Y, and Z. And these things we've agreed are going to come in if Mitchell testifies. And then there'll be a record of it and everybody will know what they're dealing with.
I mean, I guess the state can make the suggestion. I mean, we can call him and the state will have no questions for him, and then defense counsel can cross him if that will solve the issue. But
I mean, at this point, he might have yet again been sent back, even though my staff was making Herculean efforts this morning to try to get him over because somebody wanted him. At the bench, y'all said, nope, that's fine. We don't need him. And by y'all, I mean you, Miss Abbasi, said, that's fine. We don't need him. If y'all aren't calling him, fine. So we just communicated to the sheriff's office. They don't need him. I don't know where he is at this point.
Okay. And Your Honor, Mr. Kokomo checked at the end of the day. I did inquire for the court, who do we need tomorrow? And gestured over to the door. And then that's when Ms. Love said, we've talked about it and we're not calling him.
All right. Well, then that's even more of a record against your recollection.
I guess I don't understand. There would not have been any reason for me to ask about whether people were coming from the back after the evidence had already come in if I knew he wasn't going to be testifying.
So you're saying you pointed towards the holding cell doors?
Right, asking about witnesses for tomorrow.
All right, well, that is no record upon which to grant a mistrial. So let's get to the Wooney Lee evidence.
What a mess.
Yes, Your Honor. We sent it.
Now, that attorney needed to have all of her facts ready before she
Sent
went.
the email on yesterday at 9 a.m., Your Honor.
To whom?
Well, you know what? I don't think Ms. Percival is on it, so let me forward it to Ms. Percival. I'm sorry. We're forwarding the reduced.
We're just trying to get the whatever evidence we're going to litigate now up.
All the attorneys should have received it yesterday at 9 a.m.
Right, I'm just saying the court doesn't have it.
Yes,
so.
I just forwarded it.
Yeah, little Woody. I think she probably had a real shot there. But
Can counsel approach for a minute, please?
approach counter number 2. Let's update it. So we're going to count that as mistrial counter number 1, y'all. She did ask for it, but she was very tender with it. Y'all, I'm going to try something real quick. Don't freak out if it doesn't work. I'm going to try putting a different overlay on. Oh, there we go. That did work. Oh, but it's not spelled correctly. So I have to go back. So yeah, y'all, it looks like that attorney just now kind of messed up. She did not know. I shouldn't say she didn't know. She should have had the timestamp and the entire thing that she said yesterday. And again, she might not have been thinking about this when she was coming into court. But if she had had that all ready to explain, yesterday I did this, I gestured that, blah, 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 it would have come off a lot different. Ms. Gemini Night Owl. Man, what's wrong with this judge? I'm sick of her attitude. She's so unprofessional. Yeah, I think judges in general have a kind of, they kind of have a parent controlling the child type of vibe to them. I've noticed that, a little bit of a parent controlling the child vibe. Mr. Weinstein is out. He mentioned that on Twitter. He's still on Twitter or X, y'all. So if y'all want to get your daily dose of Weinstein, he's on X tweeting. Never know what this approach is about, though. Y'all, Judge Whitaker wants this trial to continue. Judge Whitaker wants this trial to continue. So this approach is definitely not about a mistrial.
We've got the jury, and they've been waiting for 20 minutes already. And I just think it's not considerate of any of us to litigate things that they can't hear and just make them sit around. So we'll just do if y'all have to take somebody out of order, you have to take somebody out of order, but I'm not going to have them wait anymore. Call your next witness and we'll get to the Wooney Lee evidence when we can get to it. Okay. All right, I'm going to get the jury out. Who's your next witness going to be? Okay. Thank you. Go ahead.
Sure. My name is Al Hogan, ALHOGAN, and I'm a detective with Atlanta Police.
Good morning, Detective Hogan.
Good morning to you, sir.
Can you tell the court how you are currently employed, sir?
I am a detective with Atlanta Police. Currently, I'm assigned to general investigations out on Fulton Industrial, but prior to that, I was a homicide investigator for about 10 years.
And Detective Hogan, can you tell the jurors how long you have been employed with the City of Atlanta Police Department?
I have been certified police officer since 1987. Had a couple of different jobs with the sheriff's departments and with the air marshals, but anyway, I landed in Atlanta about 15 years ago.
And you said you had been a police officer since 1987. Prior to working with the City of Atlanta Police Department, where were you in law enforcement?
Started in the jail in Fayette County, was there for a few months. They put me on the road, was certified then in 1987. I worked as a road deputy in Fayette County. I was promoted to detective, worked undercover narcotics locally, and then I was assigned for a good many years, 10 years or so, to the DEA task force at the Atlanta airport. We did drug interdictions there. In between there, I spent a brief period of time as a federal air marshal. This was before 9/11, and that job wasn't for me, so I came back. And that's when I went on through with DEA and then eventually landed in Atlanta about 15 years ago.
Now, you a few minutes ago told the jurors that you were assigned with the homicide department for 10 years.
Yes,
And can you tell the jurors, were you assigned with the homicide unit here with the City of Atlanta Police Department back in February of 2019?
I was, yes.
And can you tell the jurors a little bit about, I guess, how you're assigned specifically to any homicide case that you're working here in the City of Atlanta?
It is the luck of the draw. We're all in a rotation. There's a big board in the office. There's about 17 of us that are in the rotation. About 6 of us that work cold cases. At the time I was in the rotation, and your name is on a magnetic strip with a label on it, and everybody's name's in a row or in a column. As murders occur, the person from the top catches the murders, that he's the lead, he or she's the lead investigator, and they go to the bottom and everybody moves up. On this particular day, I was at the top.
Okay. And can you tell the jurors on February 23rd of 2019, were you dispatched or called to come out to the location of 50 Mount Zion Road?
Yes, I was.
And can you tell the jurors what was the reason you were dispatched to that location?
There had been a homicide, a criminal homicide. What they suspected to be a criminal homicide, and they asked homicide to come. That's to work the case.
And is that address 50 Mount Zion Road? Is that here in the City of Atlanta, Fulton County?
It is. It's in Southeast Atlanta.
Okay. And when you, I guess, can you tell the jurors, we've heard about different zones that are within the City of Atlanta. Which zone does this location fall within?
Zone 3.
Okay. And the Zone 3, does that include the area of like Cleveland Avenue?
It does, yes.
Okay. Now, can you tell the jurors when you arrived to the incident location, can you kind of describe for them what kind of property it was? Was it a business? Was it a residential location?
It's an apartment complex.
Okay. And were you the first to arrive on scene?
No, sir.
Can you tell the jurors? Now, with not being the first to arrive and being, I guess, assigned as the lead detective because you're number 1 in the rotation, can you tell the jurors a little bit about the first things that you do when you interact with other first responders who arrive before you, other officers and detectives?
Sure. So they, just by the act of being there and doing their job, they've gathered some information that may be interesting to me or help me with my investigation. So of course, I get there, observe how things are laid out. They have delineated the crime scene and what they think the crime scene is. So they mark that out with yellow tape, trying to make that a pretty big area. This particular one was a fairly big crime scene. So I could see that when I pull in, and then I speak with the 2 officers that are watching the crime scene log. I speak with the general investigator who has started the crime scene drawing. I talk with the ID technicians that are there that are, and I assist them and make sure that any evidence that I see on the scene that I'm interested in or like for them to gather or document, I make sure they do that. And I just try to glean as much information from what they have from them so I can help me further my investigation.
Now, after speaking with other members of law enforcement who are on scene before you, can you kind of describe, I guess, the layout? You said that this was an apartment complex or a residential complex, a little bit about the layout of the complex as you first observed it when you arrived.
Yeah, it's a large complex. It's in 2 phases. There's a Mount Zion Road. Obviously, it faces Mount Zion. The address is 50 Mount Zion. Then there's a phase, I'll call it phase 1, which is in the front that's up closest to Mount Zion. There's a creek that runs behind that phase 1 is a creek. So there's a bridge and an access road down one side of it. I think it's the east side of the property that goes over the creek. And then there's a large recreational area, a big grass field, and then the playground for kids. And then the second phase is in the back, but there's only one way in and out to get to the second phase. And it's in the back of the property across the creek. This crime scene encompassed all of the access road to get to the phase 2, and all the way up into a pretty good portion of the phase 2 where the road runs up into the parking lots, the access into the phase, the buildings in the phase 2.
So in the second proposal, we're going to put up State's Exhibit 11NN, which was previously admitted into evidence.
Yes, sir.
Can you see it on the screen?
I do.
Okay, so do you see at the top of State's Exhibit 11NN, there's, I guess, a red line that's drawn. It's right by where actual the time is, where it says 9:33 a.m.
Right there, you're talking about?
Yes. Can you tell the jurors, is that building that you can kind of barely see at the top of State's Exhibit 11NN, is that the first phase or the first building of the complex?
That's correct, yes.
And then do you see in the middle of State's Exhibit 11NN, it looks like something, looks like a brown kind of something that's separating the grass in the middle of State's Exhibit 11NN?
Right here.
So in the middle of State's Exhibit 11NN, you see trees, and there's this.
Oh, that's the creek. There's the bridge.
And then it's the area you described, I guess, where the playground and things, the recreation area.
It's under here, under the trees back over here.
Okay, so it's towards the, I guess, the left side, kind of middle of State's Exhibit 11NN.
That's correct, yes, sir.
Okay, now you described to the jurors briefly about the second phase or the second half of the apartment complex. Do you see that phase in a State's Exhibit 11NN?
I do. It's this phase here.
Okay. And can you tell the jurors what areas in State's Exhibit 11NN, if you can see it, I guess, were pertinent to your investigation in relation to the crime scene?
Immediately when I pulled up, I parked in the parking lot up here, if you can imagine the face, goes up Mount Zion Road would be up here. I parked my car on outside the crime scene tape and walked in. I checked in with the crime scene technician. Immediately I could see that there was a blue car resting against the fence, and I think there was a big rock there it ran into right here, where there was some stuff on the ground and stuff on the car. And as I walked up, of course, that's going to be pretty interesting. It's not supposed to be there. So as I walked up, I saw that it was part of the crime scene. There was blood in the passenger seat. There were bullet holes in the car. There were shell casings on top of the car. Items of clothing were on the ground and on top of the car. And then as I walked further past, I could see there were some tire tracks that were through the grass here, beside the building here, as well as more shell casings that were kind of scattered out in this area over here. And then they had crime scene tape stretched out across here and across there to deny any access into the crime scene.
Now, you talked about crime scene tape and things of that nature. When you arrived, had the crime scene been fully secured?
Yes.
Okay, can you tell the jurors a little bit about how that's done and why that's done?
Yeah, well, we're trying to preserve evidence. Everything in there may have something of value to us that we could use to further investigation. So obviously we don't want anybody to tamper that either on purpose or by accident. So we try to protect it. We try to make it as big as the officers that responded made it as big as they thought they needed to protect everything that I just described to you. The shell casings are easily kicked or moved. We don't want to touch anything that may have DNA or fingerprint evidence on it. There's just lots of things we need to try to protect so we don't damage our own investigation.
And Your Honor, can I approach the witness?
Yes, you may.
I want to show you what's been marked as State's Exhibit 48NN through 67. And then if you'll just flip through those, have you had an opportunity to go through those prior to your testimony here today?
I've seen them before, yes.
And as you're flipping through them, I guess, what are State's Exhibits 48 and through 67 and N?
These are all crime scene photographs from the scene.
And do the photographs in State's Exhibits 48 and N through 67 and fairly and accurately depict the crime scene, 50 Mount Zion Road, when you arrived on February 23rd of 2019?
Yes.
Around at this time, the state would tender what's been marked as State's Exhibit 48 and N through 67 and N.
Those are admitted.
Now, you talked about the area of, I guess, where you said it was a blue vehicle,
Yes.
and in your investigations, did you determine what type of vehicle it was?
I do. It was let me look at my notes here for the year model, but it was a Dodge Charger.
Just looking at your report.
Yes.
Help refresh your recollection?
Say again?
Is reviewing your report, will that assist you in the refreshing?
Yes, I'm just trying to get a 2014 Dodge Charger.
Okay. And can you tell the jurors, when you arrived and began to investigate and look around the Dodge Charger, was it occupied? Was there anybody in it?
No, sir.
Okay. Can you tell the jurors, you talked about the tire marks that you had seen. Can you describe the condition of the vehicle as you began to investigate and process the vehicle?
Well, we had run the tag, or somebody run the tag, and it came back stolen out of Cobb County. It did have some defects in it. It had several, which appeared to be bullet holes to me, from my experience. And there were 12 of them total. Again, there was a large amount of blood in the passenger seat, front passenger seat, and some clothing. A baseball hat was on top of the car. There was a projectile that fell out of the hat when we picked it up. And then there was, other items inside the car that were gathered and documented.
In a second, Ms. Knight is going to put up State's Exhibit 15 and N, which has been previously admitted into evidence. My apologies, 16 and N. And in 16 and N, Detective Hogan, can you kind of point out for the jurors the areas in which you just described as defects? I think you said 12 in the Dodge Charger.
Yep. You can look pretty close. You can see whatever's kind of out of place. In this particular image, my memory serves right. This white is a defect. You can see the different whites that stand out pretty readily, and you can see why I'm assuming they're bullet holes. But in that particular picture, I see four defects.
Okay. And you said that around the car, was there, I guess, ballistic evidence also located, I guess, on the car and surrounding it?
Yes, there were shell casings. Off the top of my head, I don't remember how many, but there was 2 or 3 on top of the car. I think maybe that's what that is. But there was up here were spent shell casings. They'd been fired and ejected out of the car, out of the gun, and landed on top of the car.
And can you?
Objection, Your Honor, that's speculation. Sustained.
Well, you said they were spent shell casings. How did you know that they were spent?
They didn't have a bullet in them anymore.
Okay. Now, can you tell the jurors, as you're kind of walking around and observing and processing the scene, are you being assisted by members of the Atlanta Police Department's crime scene tech unit?
Yes, and they were there before me, and they started working the crime scene, so they were really very familiar. They showed me a lot of stuff, and then I just went in behind them and made sure that everything they showed me I was interested in, and make sure that if there's anything that I saw they didn't know about, and make sure they knew about it to gather it.
And can you tell the jurors, as it relates to your working in conjunction with the crime scene techs that were present that early morning, what type of shell casing do you remember was identified as the shell casings found around the car and in the general area?
On the car, and then a little further up on the crime scene, they were all smaller caliber shell cases, like 9mm.
Okay.
Later on, we did find some 7.62 as well, some larger caliber.
And you said around the car, and then I guess a little bit further up from the car. I'm going to show you what's been admitted as State's Exhibit 52NN. Can you tell the jurors when it comes up what to your recollection, the yellow placards in this photo are marking or representing?
Sure. You can barely see them on this one, but there's a little yellow square there and another one up around the corner. Those are placards. They have numbers on them. ID techs, when they document stuff, they document it right where it says. So they put the placards up next to or adjacent to the pieces of evidence, and then take pictures and document where they found it. Later on, after they do that, then they'll gather that, and it will be delineated on their report by that number, whatever number it was nearest to the piece of evidence. But this, if you can imagine, if you were in this picture, if you turned around directly 180 degrees, that's the access road that goes out to the front of the property, and then the blue car is down right behind you.
Now, if you are looking at the right side of State's Exhibit 52NN, and it looks like a raindrop that reflected off from the photo, if you see where there's a vehicle or a red car kind of in the middle right-hand side of State's Exhibit 52NN?
Yes.
Can you tell the jurors, if you continue to go straight down the access road and take a right where that red vehicle is, can you tell them where would that take you?
That takes you into the parking lot in between two of the buildings in the complex.
Okay. And is that the buildings that I guess would be the front buildings, the first one we saw that was closest to Mount Zion Road, or the back set of buildings?
That's right.
That's what?
The back set.
Backside. Okay.
Phase 2.
Now, you reference or talk to the jurors a little bit about the fact that there were additional shell casings that were found in a different area in relation to the vehicle.
That's correct.
Can you kind of describe to the jurors? I'm going to show you what's been previously admitted into evidence as State's Exhibit 10NN. And using State's Exhibit 10NN, Detective Hogan, can you kind of orient the jurors as to the area that you described that you found the second set of shell casings?
Sure. Well, I told you about the shell cases that were on top of the car. Those were 9mm. There were several more that were scattered around in the roadway and the grass over here in this area. And then there were several that were found in the grass. These are the larger caliber shell casings over here. Over here at the corner of the building and around and on top of the car were the 9mm. The larger caliber 7.62 were in this area.
And if you can recall, in that area that you just kind of described and oriented the jurors to, where the second set of shell casings you found, how many did you find? If looking at your report will refresh your recollection,
Yeah, let me look and see. I
Just,
don't
af-
remember.
if and when your recollection is refreshed, just look up and I'll re-ask you the question. If it helps, I can direct you to maybe page 4.
Yeah, if you would, because it's not jumping out at me.
Yeah, if you look to page 4 of your report, and if that helps refresh your recollection towards the bottom.
Oh, 15. Thank you.
All right.
15 7.262 caliber shell casings.
So it sounds like after looking at page 4 of your report, your recollection's refreshed?
It is refreshed.
Okay. And you described them to be a larger type of, or larger caliber of ballistics or shell casings. Can you describe to the jurors a little bit about that?
Sure. Well, a handgun is a smaller caliber, usually somewhat smaller caliber. Police carry 9mm or 40 calibers. Each caliber is a different size. So each shell casing is going to be a different size to accommodate whatever size bullet it shoots. For example, the 9mm the bullets are about as big approximately as into your pinky finger. So the shell casing has to be the size for that to fit in. A 7.62 is normally associated with a long rifle, like an assault rifle. And it's a much bigger bullet. It has a lot more gunpowder behind it. It shoots a lot faster and longer. So the shell casing for that is going to be larger and distinctive for that caliber of weapon.
And based on your investigation, is it, or based on what you saw and observed, were, I guess, all of the shell casings that you saw as larger, the 7.62, kind of grouped in one area?
Yes,
And
they were all
then
found in one area.
The shell casings that you described earlier, a few minutes ago, that you said were smaller caliber or 9mm, were those all kind of grouped within, one small area, separate and distinct from the 7.62?
The majority of the shell casings, the 9mm were discovered here. The only exception to those would be the ones that were found on top of the vehicle when it was abandoned.
Now, can you tell the jurors, do you see the red line that kind of travels throughout State Exhibit 10NN?
The long one?
Yes.
Yes.
Can you tell the jurors, based on the investigation at that point, the shell casings that you had found in different areas and the tire marks that you described, why, I guess, that red line is there and what it represents?
For me, that was, I created this. So I know it's pretty rudimentary, but I'm not a computer guy. The little red dots it's not accurate, but it just indicates where the shell casings were found. This is a line based on my investigation of where Richard said they had parked. And this is the access that they took trying to get out when the shooting broke out. So there was a shooter that came out here when it started shooting. They drove out. Another shooter down here drove past, walked. Well, you can see the tire tracks in the grass. Drove off the road, back on the road. The car was not functioning, so they rolled to a stop here in the negative. It's just a line to kind of show where I thought they went when the incident happened.
And I'm going to show you what's been marked and tendered and admitted into evidence. It states that it's 59NN. And in this photo, do you see kind of the grouping of the yellow placards that are seen within State Exhibit 59 and N?
Yeah, same procedure as what I described earlier. Where there is a shell casing, they put a placard, and next to it is a corresponding number that indicates that particular shell casing. This is coming out from the Rick Breezeway, and this is where they, all the different placards indicate the different shell casings that were found.
And do you see kind of in the middle of State's Exhibit 59 and then towards the, I guess, the breezeway? Let's see if we get this up your way. There we go. In this area right here?
Yes.
Are those placards, are they also the larger caliber shell casings?
Yeah, they were all the same shell casing.
Okay.
Caliber.
And are photographs taken of each placard from, you know, a far away distance or a full range distance, mid range, and then close up?
Yes.
Okay. To your recollection, was that done in this case?
I wasn't present, but I'm assuming they do it the same way every time.
Okay. And for time and efficiency, is that what we see in State's Exhibit 60 NN through 67 NN?
Yes.
Okay. Now, after you completed kind of walking through the scene with members of the City of Atlanta's crime scene unit, while on scene, did you get information that two males had contacted 911 indicating they had witnessed what happened at 50 Mount Zion Road?
I did.
Okay. And I don't want you to tell me what anyone said as I go through the next questions. As a result of that, did you go to APD headquarters just down the street here off of Peachtree?
Yes.
Okay. And can you tell the jurors when you arrived, did you speak to the two males?
I did.
And without telling me what they said, can you tell the jurors who you spoke to that early morning?
Sure. Is Bernard Mitchell and Rodney Uten.
Okay. And can you explain to the jurors, without telling me what they said, kind of the circumstances and of the setup of the interview? Let's start with that.
Oh, it was just an interview where there's two different areas at headquarters that we speak to people in. One's the interview room. It's just like if you guys came in and had something to tell us, we put you in an interview room and we speak with you. The other is what they call interrogation, or when they're in custody. In those rooms, you're secured, chained to the floor, and both rooms are audio and video recorded. Both types of rooms.
And you said they were in the first room, the interview room that you described?
They were in yes, witness room.
Can you tell the jurors, do you interview them together or do you interview them separately?
They were done separately at different times. Same, one after the other.
And after speaking with both Mr. Uten and Mr. Mitchell, can you tell the jurors, do you speak with a female, Miss M. Smith, after speaking with both Mr. Mitchell and Mr. Uten?
That's correct, yes.
And can you tell the jurors, do you speak with her that same day, later on February 23rd of 2019, or at a later date?
It was on the same day, on the 23rd.
Okay. And can you kind of explain to the jurors in relation to when you arrived to the scene and kind of worked and processed the scene with members of the police department, about how long after you arrived did you begin to interview people in relation to your investigation?
Multiple times in the report. It all came together fairly quickly once it started rolling. Let me see if I denoted notated in my report. Do you know specifically in the report where I need to be looking?
Let me ask you generally this question based on your recollection. Was it a matter of hours that you began speaking with witnesses, for example, Mr. Uten and Mr. Mitchell?
It was all in the morning time. Yeah, it was like 6 in the morning when I got to the crime scene. It was well before lunch when I was talking to Mr. Mitchell and Mr. Uten.
Okay. And when you spoke to Ms. Smith, can you tell the jurors kind of the setup or the arrangement for that interview?
That was in the witness area. It was later on in the day. I think it was after lunch, thereabouts. But same, voluntary. She came in and I spoke with her.
And when you're speaking with Ms. Smith, is it just you and Ms. Smith, or are there any other members of your team that are also present?
Detective Casey was with me.
Okay. And can you tell the jurors, as you began the interview
You're talking about Mariah, right? With Ms. Smith, or with the other two?
So I'm talking about Ms. Smith.
Okay, yeah, Ms. Smith.
Yes.
Detective Casey was with me. Yes.
Yes. So can you tell the jurors, when you began the interview with Ms. Smith, can you kind of describe for the jurors her general demeanor that early morning?
Sure. Yeah, she was upset, nervous, crying, young girl, and you can imagine. She said she was a witness to a shooting and a murder, and she was upset.
Now, as you began the interview, can you tell the jurors, how did you start?
Sure. Well, I started all the same way. I introduced myself, and we start talking about, and I asked, talking about the situation that they witnessed, and I asked for their statement. And she began by telling me a series of events that she relayed to me at that time that I knew were not to be correct based on what I knew from the crime scene.
Okay. And when you say knew what not to be correct in relation to the crime scene, can you explain to the jurors, I guess, what you mean by that?
Yeah, she was saying that this victim had been shot by one of his companions. The way she described it, it was not possible based on what I knew from the crime scene. So I brought that to her attention. After some consoling and some speaking with her by me, she realized that she changed the story to what the truth was, which we knew that she was not telling the truth.
Okay. And as you continued, I guess, to confront her with the physical evidence that you had located on the scene and through your investigation while on scene, did she provide you with names or nicknames of individuals she knew to be involved?
Yes, she did.
Okay. And do you recall, or can you tell the jurors the nicknames that she told you of the people she saw shooting that night?
Yes.
And if referring to your report would help refresh your recollection, by all means.
One was Little Rod and Bali.
Okay. And can you tell the jurors, as she described what she saw, did she tell you, or tell the jurors what she told you about the firearms that she saw Little Rod and Bali having?
Judge, Your Honor, I'm going to object that this is improper bolstering. She's already testified to this.
This is impeachment, Your Honor. She testified she couldn't recall at times during her testimony as it related to the firearms, what they look like.
All right. So we have another approach. Congratulations. I think that means we are up to what? Let's take a look. Approach bench counter number. We're on 3 now. Bench counter number 3. So we have somebody in the chat. 27 years. 27 years exonerated. We need to get some. We need to connect. Hit me up. How do I get in touch with you? How do I get in touch with you? Thank you for coming to the chat. By the way, thank you for a super chat from Clizzle this morning. Thank you for our new members, Roxy and Louise. As always, shout out to our mods. We have Andre and Miss Lily. We have another mod, but she only comes once in a while. I'm not sure what happens with her. Might need to get a 4th mod to fill in. But so far, Andre and Miss Lily are holding things down really well. Patron Gold, you're here every day. You want to be a mod, Patron? Am I saying that right? Or is it patron? I think it's going to be Patron. Patron, you're here with us rocking every day. Amy, you're here with us rocking every day. Even if either one of y'all want to be a mod, let me know. And I'll put you on the mod team. Just let me know. Sir Montre, well, I would say every day, right? Be here every single day.
When you described, you've been describing the fact that the first part of the interview you had with Ms. Smith, she gave you a number of facts and scenarios that were not aligned with what you knew to be consistent with your investigation of the crime scene, correct?
That's correct.
And as your interview with Ms. Smith continued, I believe you indicated earlier about the statements that Ms. Smith made going forward about what she observed on that early morning of February 23rd of 2019 as it related to the shooting. The facts that she relayed to you after you confronted her with what you knew to be true about the physical evidence on the crime scene, the facts that she was giving did they become consistent with what you knew through your investigation at the crime scene?
They did become consistent, yes.
Okay. And as you continued to interview Miss Smith, did she continue to provide you statements as it related to what she saw and heard that were consistent with what you've described to this?
Your Honor, leading the witness.
Ruled based on our discussion at the bench.
So let me see if I can remember what I was asking you. So as she continued to describe things that she saw and heard and observed on the crime scene that early morning when the shooting was occurring, were those statements consistent with what you knew that you found on the crime scene earlier during your investigation?
Yes, sir.
Okay. Now, can you tell the jurors, we talked a little bit about she was able to provide nicknames. Can you tell the jurors, without telling me what she told you, but was she able to provide you with Instagram handles or usernames for the 2 people she gave you nicknames for?
Yes.
Okay. And as a result, I guess in conjunction with that, was she actually able to pull them up and show you photographs as it related to the person she knew as Lil Rod?
Yes.
Okay, and I want to show you what's already been admitted into evidence as State's Exhibit 23NN and 24NN. While she's pulling it up, I will give you a physical copy so you can see it.
Oh, yeah.
And while Ms. Knight is pulling it up, if we can get the technology to work, are those the photographs that Ms. Smith was able to provide you in relation to the person she knew to be Little Rod?
That's correct, yes.
And can you tell the jurors, do you see her signature on those photographs?
I do.
Don't pull it up. And can you tell the jurors what date is her signature on those two photographs?
The 24th of February of 19.
Okay. And was Ms. Smith able to do the same thing as it relates to the person she knew to be Mr. Bali?
Yes.
Okay. Now, can you tell the jurors, after receiving this information from Ms. Smith as it related to who she saw shooting, can you tell the jurors, were you able to determine the identity of the people she knew to be Bali and Little Rod?
Yes.
Okay, and who were those people?
Little Rod's name is Rodelius Ryan Jr. Bali's name is Damon Blaylock.
And let's see. Now, before we move on from Ms. Smith's interview, can you explain to the jurors, so during Ms. Smith's interview, you described how you confronted her with the physical evidence as it relates to the statement she made initially at the beginning of the interview. Remember that?
Yes, sir.
And can you tell the jurors, when you confronted Ms. Smith with the fact that what she was saying didn't make sense with what you already knew, did you tell her the identities of the people who were shooting?
No.
Did you, before speaking to Ms. Smith, have any idea who they were?
I didn't know him from a can of paint. No, sir.
And was that something she was able to tell you based on what she described as what she saw and heard that early morning on February 23rd of 2019?
That's correct. Yep.
And while you were interviewing Ms. Smith, did you provide her with any facts as it related to the identities of Mr. Ryan or Mr. Blaylock during that interview?
No, sir.
Okay, and was that information that she was able to provide, or did she provide you information that assisted in your investigation in identifying both Little Rod and Mr. Blaylock?
That's correct.
Now, after speaking with Ms. Smith, can you tell the jurors, did you attempt to identify another female described to you during Ms. Smith's interview?
Yes.
And can you tell the jurors, who is that?
Her nickname was Brazen. She was with Miss Smith.
Your report.
Tyhera Hartfield. Oh, excuse me, that's her mom. Oh, yeah, Tyhera Hartfield. That's right.
So it sounds like using your report refreshed your recollections?
Yes.
Okay. And in your identifying Ms. Hartfield, can you tell the jurors, based on your investigation into Ms. Hartfield, what her living situation was?
She was a runaway, listed as a runaway at the time.
And ultimately, let me ask you this question. Based on the information that you've talked about here today, can you tell the jurors, did you make charging decisions?
I did.
Okay, and can you tell the jurors, did you swear out warrants for the arrest of Mr. Ryan and Mr. Blaylock?
Eventually I did, yes.
Okay. And can you tell the jurors, did you ultimately get to speak with Ms. Hartfield?
I did.
Okay, and without telling me what she said, did you, I guess, speak or interview her in a similar fashion that you've described as it relates to Mr. Mitchell, Mr. Uten, and Ms. Smith?
Yes.
Okay. And during your investigation, can you tell the jurors, did you also receive a social media posting as it related to Mr. Ryan hours after the homicide?
Yes.
Okay. And was that something that you used and utilized in your investigation in taking out the warrants that you've described?
Yes.
One moment. Aaron, I don't have any further questions pending redirect.
All right, are there defense questions for this witness?
There are, I just want to make sure I can get a hold of at least one of these snippets.
Okay.
Maybe it's 10. I cannot find it anywhere. It doesn't find. All right, good morning, detective.
Good morning.
Coming into today, have you had a chance to review the interviews you did with the witnesses you spoke to?
Not all of them, but yes.
Okay. You haven't had a chance to review them?
I haven't reviewed, I reviewed Mr. Mitchell and Mr. Uten's recently. The others have not.
Okay. All right. So I want to start. You've been an officer for quite a while, yes?
Yes.
And so you know that when you are getting information from people, it is of the utmost importance to make sure it's accurate, right?
Yes.
And that's one thing you were doing with Ms. Smith, is confronting her with facts to test whether what she was saying was accurate, correct?
That's correct.
All right. And especially in a situation kind of with young people, they may not always be fully forthcoming in the beginning, correct?
It's not limited to young people, but yes.
Right. Especially if they think there's something they could get in trouble for, correct?
Yes.
All right. And the folks that you were speaking with in this situation, they were not, well, the two young men you spoke with, they were not lawfully allowed to have weapons, were they?
No, I don't think so.
Okay. So that's something they theoretically could get in trouble for if they admitted to it.
Yes.
Okay. So when you're speaking with them, when you're speaking with Ms. Smith, you're asking questions to make sure you can verify things. One of the things you told Mr. Mitchell you would do was get his Instagram records, correct?
I may have, that doesn't come to mind off the top of my head, but it would be something I would do, but I don't remember if I told him that. or
Would
not.
it help refresh your recollection to see a copy of a transcript from that interview?
Sure, yeah.
One moment. Here we go. All right. I'm going to direct your attention to page 19 here. If you could quietly read that to yourself. Let me know when you've had a chance to refresh your recollection from that.
Your Honor, before he answers the question, I'm going to object to hearsay what Mr. Hogan said during the interview to anyone would be hearsay.
He's-
Out of court statement.
He's on the stand. He can repeat what he said.
That doesn't make it not hearsay, but
And I can ask whether he asked somebody.
yeah, I think it's not hearsay in this circumstance, so overruled.
I mean, in this circumstance, it would be being,
That's overruled,
Okay.
so.
so were you planning on getting Mr. Mitchell's Instagram records?
I may have been. It's hard to say. This is a lot of years ago, so it's part of my tools that I use for in each or any case that I have that I work. If there's an opportunity to pull those and I need those, then yes. But I don't remember if I wrote a warrant for his Instagram or not.
Okay. You said if you have the opportunity, you certainly had the opportunity, right?
Yes.
Okay. And with those, if you had them, you could come back to him and say, hey, was this true? Was this not true from what you told me, correct?
Yes, I could. Yeah.
Okay. And Mr. Mitchell and Mr. Uten, they were both cooperative, correct?
Yes.
So if you wanted to follow up with them, they gave you no indication that they wouldn't speak to you or anything like that. They were readily available.
Yes, not at the time they were cooperating with me that day. Yes.
You didn't attempt to contact them any other times, though, did you?
I don't recall doing so. No.
Okay. So in this case, do you recall what search warrants you did take out?
No, not all of them. No.
Okay. Do you recall taking out warrants for Instagram records?
I do.
Do you recall whose records you requested?
No, I got little rods. I got Bally's. And without going through the index on my report, I can't tell you exactly, but I know I got little rods and I got Bally's. I got Rodelius Ryans and I got Damon Blaylocks. May have gotten Mariah's and Brazy's as well, the Tyara Hartfield and Miss Smith.
Okay. What was your purpose in getting those records?
It's any information there that might help with the investigation.
Okay. Did you look at those records?
Not personally, no. I looked at some of the pictures. It comes in a format. Again, as I indicated, I'm not a computer guy. I'm not even on social media. I gave that information to somebody who could put it in a format that was easier to read, and then those people looked through it and they let me know what they found.
So it wasn't for you to get more information. Someone else was supposed to get more
The
information.
information is going to come to me. It just didn't come through me.
So at what point did you get the information of what was contained in those Instagram messages?
When they gave it to me, I don't know what day it was.
Who's they?
I don't remember who the analyst was that did the examination of those records.
Okay. And the examination of those records, I would assume you included in your report?
Some of them, yes.
Some of them. Could you let me know then when? I assume if you put them in your report, it says then when you got them, correct?
It says when I put it in the report. Let me see.
I mean, that's something you would put in the report, right?
One that jumps out at me was from February the 26th of 2019. Somebody sent me an Instagram post on that day, and it was a short video that showed Mr. Ryan riding in a car.
Okay, but that's not the Instagram records, right?
It's from Instagram.
That's not the Instagram records for which you obtained a search warrant to get so you could get more information, correct?
I haven't verified it, but if it came from his Instagram and I got a search warrant for his Instagram, then yes, it would be in there. I
Right.
just got it before I got the search warrant records back.
I'm sorry, if you could
It was
repeat that last
posted.
part.
It was posted. Somebody saw it. They sent it to me. If my search warrant had not been executed and the information sent back to me at that time, it would be included in both records, but I got it before the search warrant records came in because somebody sent it to me right after it was posted.
Okay, I think a second ago, because you said you didn't confirm it, right?
You're gonna have to, I don't understand what you're saying. I've confirmed it. Yeah, what are you talking about?
Well, I think about the content of the messages, you said you did not confirm with the records.
I just said I'm assuming.
Right.
If it's in his Instagram records, I received it before the records came back from the search warrant. I'm assuming that that information that I received that day before the records came back would be in the records when they arrived to me.
Okay. So without those records, having looked at them, there was no way for you to go to Ms. Smith or Mr. Mitchell or anyone else and say, hey, you told me X, Y, Z, but your records say something completely different. Right?
I did not do that. No.
Okay. You could have done it though, right?
Yeah, sure.
And that would have been confirming, right?
Sure, yes.
I want to ask you about what you testified to earlier about the actual crime scene. Mr. Abadi asked you questions about where you found certain things. Do you remember that?
Yes.
And you answered questions about where you found those 7.62 shell casings, right?
Yes.
But you didn't actually find those casings, did you?
No, I did not.
Those photos, you weren't there when they were taken, right?
No,
You never saw where those 7.62 casings were.
not physically, no.
So when you say you found them, you didn't find them. Someone else did.
I said they were found. I'm not sure that I said I did.
Okay. When did you learn about those casings?
Later on the same day that the murder happened, I was at the office when I got the call.
Okay. And when you spoke with Mr. Mitchell and Mr. Uten, were you aware of those casings?
As I recall, it was around the same time. I don't remember exactly the sequence of events, but I spoke with them later on in the morning. It was sometime around the same, a lot of things were happening at the same time, that we got the call about the shell cases. That's one of the reasons I did not physically see them, because I was busy at the office. So I asked the responding officer to collect them and supervise them. But I don't remember the sequence of when exactly they came in.
Okay. Would it help refresh your recollection to see a copy from your trial testimony?
Sure.
I'm sorry, not your trial testimony, the last proceeding, several proceedings ago.
Okay, sure.
All right, I'm going to direct your attention to page 1076 from the prior hearing. Also turn to page 1078 if that's helpful as well.
Okay. All right, so what's your question again?
If when you spoke with Mr. Mitchell and Mr. Uten, you were aware of the 7.62 shell casings.
I was aware that they described to me 2 shooters, but I don't recall if I knew about the shell cases at that time. I may have, I don't remember.
You said that they described to you 2 shooters?
Yes,
Okay. You've got a transcript in front of you, so you've testified about this before, correct? This matter?
yes.
Okay. And you don't recall attorneys asking you at length whether anyone besides Ms. Smith mentioned 2 shooters?
I read here that they were asking me about that, yes.
Okay. And your testimony was that Ms. Smith was the only person who said there was 2 shooters, right?
Yes. That's what it says here.
I mean, when you,
Wait, before we get too far down here, let's make sure we got the right context.
if you want to flip to page 1100.
No, let me read these first.
Okay.
On page 1076, as I recall, they were asking me about my interview with Ms. Mitchell. And I had mentioned to her that I had 2 sets of shell casings. They were trying to determine if she.
Okay. Well, I don't need you to testify about what someone else was trying to do.
So what I'm saying is context matters. In this particular instance, I was describing my interview with her, and in the process of the interview, when I was confronting her with the evidence, I told her that I had 2 sets of shell casings.
Yes, I understand that.
You said page 1100?
Yes, sir.
Okay.
So having reviewed that page, Mariah was the only person who said there was 2 shooters, right?
According to that transcript, yes, ma'am.
That was your sworn testimony under oath, right?
That's what I said. Yes, yes, yes.
All right, so that was the truth that you said it then, right?
Yes.
Mitchell and Uten, they told you about not 7.62, but a weapon which would have fired larger shells. Is that right?
Yeah, they described a long gun coming out of the breezeway. Yes.
Okay. And when you were speaking with them, that was not consistent with the scene as you had seen it, right?
Again, I don't remember exactly when I got all the information about the shell casings. So at that point, I was getting his statement, and I took it as he gave it to me.
Did you not previously testify about the shell casings? I did not know about it when I interviewed Mitchell and Uten.
Okay, well, if my recollection was that then, I don't remember that now. If I didn't know about the shell casings then, if that's what I said, then that's what I said.
Okay. But you didn't confront them with what at that time would have been their testimony inconsistent with the scene, right?
No.
Okay. And they both told you one shooter. The number of shooters they told you was not the same as Miss Smith, correct?
That's the same question, just worded differently.
We've already been through this.
I'm gonna overrule that one.
Bernard Mitchell described the shooter coming out of the breezeway, and also the shooter when he was going around. He was right beside he described the person right outside the car shooting in the car.
So that would be
Dreads and a hoodie.
So that would be he described to you two shooters, based on what you just told me.
Yes, based on my just reviewing my interview with him the other day.
Okay. All right, I'm gonna have you take, so you don't recall testifying that Mr. Mitchell actually never said anything about two shooters?
I got a sneaking suspicion you're going to show me that I did, but as I sit here, I don't recall that, no.
You were able to review your interview with him, correct?
Yes, I did.
Okay. You still have that transcript in front of you?
No. Oh, is this it?
Yes, sir.
Oh, okay.
You could take a look and see if that helps refresh your recollection about whether he told you there were two shooters.
It may or may not refresh his recollection, but I'm going to object to hearsay with Mr. Mitchell. I'm going to object to hearsay.
This is impeachment of what the officer previously said.
I'll let you ask about whatever he previously said.
Do you have a page or an area that I need to look through? Exactly, it's a long interview.
No, sir.
How many pages are we talking about?
Can't see, maybe about 20. I can't see if that's right. It could be more. You know what? We can come back to it. We'll probably have a break and you can take a look and get back to me.
Okay, sure.
Cool. So when you went out to the scene at the time, you were looking to speak with other witnesses, correct? If there were any.
Originally, when I first got to the scene, yes.
Okay.
Yes.
You were trying to speak with as many people as you could, right?
Yes, I did.
Okay. And you had access to the cab reports and the 911 calls, correct?
Yes.
Okay. And you had access to the 911 calls themselves, correct?
Eventually, yes, I did.
Okay. And anyone you spoke with, you would have put that in your report, correct?
Not, yes, most of the general information. I don't necessarily put all the details, but yes.
Okay, but like their name, right?
Not always. If they don't wish for the name to be included, if I can exclude them, I will.
Fair. But you never spoke to the 911 callers, did you?
No,
Even though you had their name and contact information, right?
that's right.
Even though you were aware that one of them wanted to speak to the police, right?
If I was aware of that, I would have spoken with them.
All right. I'm going to approach you with what has already been previously admitted into evidence and marked as states 1NN Nancy Nancy.
Okay.
Okay. And that is one of the cab reports you've reviewed, correct?
It appears to be a CAD report from the case. I can't say I reviewed it, but this seemed to be from the case, yes.
So you didn't review the cabs, or you did?
Well, I look at it, I verify that it's got the right address on there, and if there's any information as the case progresses, and if I need to get back in touch with anybody like a 911 caller, I would do that.
Okay. So you didn't see the.
And I would use the CAD report to get that number
Okay.
and name. In this particular case, I didn't see the instance to it. Didn't need it.
You didn't need to see the person who wanted to speak with you?
I wasn't aware of that person.
So you didn't review the cab?
I looked at the front page. I didn't read every word. No, ma'am.
Okay. So you didn't listen to the 911 calls?
No.
Okay. So if you're trying to speak to as many witnesses as you can, why wouldn't you speak to the 911 caller who wants to speak with you?
Again, I didn't get the word that they wanted to speak with me, or I would have. My plate was pretty full. I talked to a lot of people when I did a lot of work that day.
Oh, okay. You were too busy.
Yes, I was busy.
Okay. So when Mr. Mitchell and Mr. Uten, no, let me back up. The photos of the 7.62 shells, you didn't take those, correct?
I did not.
Okay. Were they just sent to you? Is that right?
Yeah, they were included with the report. Yes.
Okay. And so is it from those photos you pieced together, say 10 NN that you've drawn a line on? Thank you. 10 NN, you drew this line, correct?
I did.
Okay. And this earth image or whatever it is, that accurately depicted the apartment complex as you observed it, correct?
That's correct.
Okay. So, and the line on the left side where it starts, that's your belief, that's where the 7.62 shell casings were.
That's correct, yes.
All right. I'm going to put up on the screen for you what has been admitted as 59 NN. I don't know if it is the share screen. Thank you. All right. So looking at 59 NN, what is it you see next to kind of that entryway, exitway by the sidewalk to the building?
Well, I see a satellite dish and an AC unit.
Okay, AC unit. And then you were standing at that AC unit looking at the parking lot. What is to your right? We have a line of bushes.
I'm turned around here. I don't understand what.
If you're standing next to that AC unit with the AC unit on your right, you're looking at the parking lot. Do we have a line of bushes there?
Yes.
All right. Could you flip back to 10 NN? So looking at 10 NN, officer, you said it was consistent. What happened to that line of bushes?
They're not there.
Okay, what happened to the AC unit?
It's not there.
So how is that possible?
Well, when I got the information from the officer, Bob memorialized what he told me, what he found. He said it's by the Y building. I was assuming that Y building was where I indicated right there.
Oh, okay, so
on
you
the
just
map.
assumed that.
I did, yeah.
Okay.
It's in the same complex. Picture with the shell casings is in the same complex. I think it's in the next building back in that little courtyard.
Okay. But so you didn't go out to the scene and see where those 7.62 casings were, right?
I've said that a couple times.
So you can't say for sure actually that 10 NN is even where those were found, right?
That's correct.
Okay.
I can say they came from the complex, but
Fair.
exactly where in the complex, I don't know.
Fair. And with this image, I'm going to point you to, that corner right there, right?
Yes.
That's where Ms. Smith indicated one of the shooters, correct?
I don't recall that.
Where do you recall she said the shooters were?
She said, if my recollection is correct, she saw somebody walking out of the breezeway.
Here?
Yes. I believe, yes.
Okay. So all those casings should be right there.
Yeah, but the buildings are very similar in design, and there's two sets. So there's breezeway that goes through both sets of buildings.
Okay. So they're very similar. So
it's easily confused is what I'm saying as far as locations, because the buildings look very similar.
okay. So you may have been easily confused, right?
I was confused, yes.
Okay. And Ms. Smith, during the earlier parts of her interview, she had only talked about one shooter, right?
I recall she said she saw someone with a long gun, and she heard shots. I don't recall if she indicated whether there's more than one shooter or not. I don't remember that. Should I refer
Okay.
to something?
So what earlier on in the interview, or when in her interview, I think you talked about, she said some things which weren't consistent.
Yep.
And then you consoled her.
Yes.
And then she was more consistent after that, right?
Yes.
So when was it that she began telling you, back this up. At what point between those did she go from one shooter to two shooters?
I know when she described to me, she said she described the two guys that she was with, and she described each one of them having a different kind of weapon. I recall that, but I don't recall if she stated that she saw anybody shoot. She just stated she heard shots and ran.
Okay.
Saw both of them with guns, but I don't recall if she said she saw them shoot.
My question was, when in her interview, before or after the consoling?
It was after the consoling.
Okay. Because before that, it was only one shooter, right?
I knew that story she was telling me was crap, so I really wasn't paying much attention to it.
Okay.
So I don't remember what
Okay.
she said.
And it was between what was the consoling? We'll go there.
What was what?
When you consoled her,
Mm-hmm.
what do you mean by that?
Well, I'm a husband and a father. I've got a daughter. I just spoke to her in a fatherly tone, assured her of her safety, and calmed her down and encouraged her to tell the truth.
Okay. But she didn't start doing that until after she was told to, I think, sing her ass off, right?
I don't recall if that was said or who said it.
You don't recall that?
I'm not saying it wasn't said. I just don't remember who said it. Yeah.
Okay. And there were discussions during that interview about whether she was implicating herself, right?
I don't recall.
Whether she could be going home or not?
I don't remember that.
She wasn't concerned with, or didn't seem as though she was concerned about getting in trouble?
She was concerned about getting in trouble, yeah.
Okay. And so I want to back it up. She came in, she's telling you a bunch of things, they're not adding up. You console her, and then she is telling you something consistent with the evidence, right?
Yes.
Okay. But that part didn't happen until you were the first one to bring up that someone had a rifle, right? As opposed to just a small gun, right?
I indicated that there were two types of shell casings, a rifle round and a small caliber.
Okay. Before that, she had not described two types of rounds, correct?
Like I said, I haven't seen that interview in quite a while. I do not recall.
Okay. You're the one who brought up a second person there to ambush, right?
I described two types of shell casings indicating that it was two shooters, yes. Implication there is two shooters.
Okay. So you made that implication and then we had two shooters, right?
Yes.
Okay. What more did you do to confirm what she was telling you?
And what, do you have an example that you'd like me to answer? Because she told me a lot.
Right. She told you about different things that Mr. Mitchell did or Mr. Uten did, right?
Yes.
And those weren't consistent with what you learned from them, right?
Yeah, they were fairly consistent.
Okay. So when you spoke to Mr. Mitchell, that's when you learned about him putting a gun to her head?
Oh, yeah, she did say that about him, yeah.
Yeah.
Again, that's the story and I didn't believe her, so I
Right.
forgot about it, yeah.
So it would make sense if she's telling you these stories that you would want to confirm them, right?
If it's the truth, yes.
Right. And she told you things about, well, let me ask you. You never went back to Mr. Uten or Mr. Mitchell and asked about whether everyone had been chatting together, like she told you, right?
Oh, no, they described in their interview that they had been texting with the girls.
Oh, I'm sorry. I meant that everyone, the defendants, everyone came out and was chatting together before this happened.
I don't think that came out with Mitchell and.
Okay.
Yes.
All right. So they didn't say it, she did, but you didn't go back and say, hey, this witness told me this. No?
No.
Okay. And you didn't go back and look at her Instagram records, right?
I don't think so, no.
So you couldn't confirm whether she said she'd been talking to the victim every day, right?
Bless you, the victim. No, I didn't.
Okay. You could have though, right? Because you said you got a records or you ordered them, did a warrant for them?
Yes.
Okay. And she told you about a specific type of van that Mr. Ryan's mother drove, correct?
Yes.
You didn't go check and see if she actually had a van like that, did you?
Yes.
You did?
Yes.
And that's in your report?
I don't think so, but I did do it. I noticed it. Let me look. It might be in the report. We went to go talk to his mother.
Mm-hmm. She was cooperative, right?
She was.
You didn't ask to search the van, did you?
No.
That van would have been, based on what you were told, used basically as a getaway vehicle, right?
Yes.
So it could have a murder weapon in it, right?
Yes.
Could have gunshot residue all over the steering wheel, right?
No, unless it was shot from the car.
Okay. Those wouldn't transfer from someone's hands?
I don't know, maybe.
Maybe. But you didn't get a search warrant to check either of those things, did you?
No.
And within just a few hours, you had an address for Mr. Blaylock, correct?
I did.
And you didn't get a search warrant for that apartment either.
No.
So you made no effort to look for what would have been the alleged murder weapon, right?
Oh, that's correct.
Okay. That would have been useful, right? If you had that, that's great evidence.
I've worked 100 murders. I never got one.
Never.
Ms. Abbasi, let's pause for a minute and take our morning break. And if you do, you want him to look at whatever that
Oh, sure.
portion was while we break. Okay. All right.
Sure. He's welcome to. And Officer, I'll hand you your other transcripts and you can look at whatever you need to.
And can I ask you to actually step outside if you don't mind?
Oh, sure.
Thanks. I've just got to deal with another matter. How about you start with whatever it is that you wanted him to actually, that you asked him on the stand about. Okay. I mean, you can give him all of them, but I'd like for him to start with the one that you specifically asked about.
They'll be here.
All right. Okay, so there's been some back and forth about the whole Mitchell, that's his last name, right, thing. And Ms. Abbasi, you said that you kind of gestured in a vague direction towards the holding cell door at the end of the day without mentioning anybody's name, and asked who the witnesses would be tomorrow, which is now today. And the state's answer did not include either of those people. And then, of course, there was some point in time in which the state was maybe going to get Mr. Mitchell, and I don't know what they were going to do, put him on the stand, just, I don't know, as a concession to Ms. Abbasi, maybe. I don't know. Anyway, just FYI, Mr. Mitchell is here and available. I'm just letting y'all know that. And I kind of need to know before the lunch hour, or whenever this next, the witness that's on the stand right now is over with, if he's going to be called. Let's go ahead and call him next so that he can be whatever's going to happen, and then transported away back to where he has been staying before this time.
The issue raised on the defense is his messages would kind of affect what sort of road we went down with the defense. We've already gone down that road.
All right.
The mistrial has been denied. There's no further, I'm no longer insisting at this point he be called. Whatever damage has been done. So working with what we have.
Just wanted to let y'all know. Okay, so then does the state want to call him? If not, tell me now and I'll have him shipped back.
No, I think this line of hearsay questions has cured any sort of issue as it relates to a mistrial and confronting Mr. Mitchell, since she's been able to do it without Mr. Mitchell even testifying.
All right. Thank you. Let's take our break.
Sir Montre, we have a page emoji for all of our members. Y'all, come on. What's going on with the membership, y'all? We have 2 new members today. We have 2. Who will be our next new member? Who will be our next new member? So, yeah, they're shipping them back, y'all. Shipping him back. I saw somebody on X who brought this up. Let's take a look at this. Let's take a look at Tina on X. This is Tina. Hold up. This is Tina. You can check. Y'all can't see, but it's at WAHALENOEND. So I don't know how to pronounce that. But let's see. This is what we brought up. Let's make it big. Get rid of this. This is apparently what Miss Abbasi was referring to yesterday. So let's take a look.
Who?
One of that we've already been discussing with Mr. Lee.
I was trying to find out if the state was going to be calling.
Oh, right. Okay. All right.
We've been discussing with Mr. Lee.
I was trying to find out if the state was going to be calling.
Oh, right. Okay.
Yeah.
Okay.
That right there she does say I was trying to find out if the state was going to be calling somebody. But the judge cuts her off and says, "Oh, right."
Mr. Lee.
I was trying to find out if one of the former co-defendants.
Who? One of
That we've
them-
already been discussing with Mr. Lee.
I was trying to find out how to take the one we call.
Oh, right. Okay. Okay. All right.
Already been
Yeah, it does look
discussing
like she mentions
with
somebody, but the thing is, it doesn't sound like, at least from what I heard, you couldn't hear exactly who she was talking about. We have a new member, Sir Montre. Oh, Sir Montre. Excellent. Thank you, thank you, thank you. And Queen became a member. Thank you. Appreciate it. Y'all are welcome to the team. Ms. Lely says we are the truth sleuths. Truth sleuths. So, as of now, that is where we stand. We're the truth sleuths. It's a bit of a tongue twister, but I guess in order to be a truth sleuth, you have to be able to pronounce it, or at least keep it in your heart. I don't know why it's so hard for iPhone users to give membership. Paula, it's because the iPhone, they want a cut of everything that happens through their app store. And because you open it up this is my understanding, okay? I'm just saying it from my understanding. Because Apple wants a cut of everything that happens through your app store, it's difficult to make purchases on YouTube, because YouTube would have to give like 30% of whatever you spend to Apple. So I think YouTube has disabled some, or maybe much, or even all of these different purchases that you can make on YouTube. They've disabled it because YouTube is owned by Google, obviously. So Google has disabled the purchases that you can make on their platform through Apple's app, because if they were to allow it, then whatever you spent, they would have to give a portion to Apple for using the Apple app. So my understanding is that's why it's easy. So, that's why it's difficult. So you can make purchases, you can gift memberships, but you have to do this roundabout way of doing it. So you basically you'd have to open, what I believe is you have to open your Safari browser and go to YouTube. Basically from your desktop, you're fine. You go to Safari browser and you're good to go. Yes, they charge my Apple Pay $2-ish for $199 stickers. So you saying they charge you over the $199, basically? Miss Lely, you have the workaround instructions. Do you have those? If you copy and paste those, I'll put them in a banner, Miss Lely, so that in the future you won't have to. I'll just put up the banner, the workaround for Apple users. Yeah, so Apple, I believe actually there was a huge lawsuit about that. I don't know if they won or lost about that. So what do y'all think about Miss Abasi? Is she doing a good job? Why does it feel like all of the witnesses who the defense gets to cross? I mean, I don't know how common this is, but it seems like they all have holes poked in their testimony. It seems like they all have holes poked in their testimony. Papa Bear says she's cooking. Okay, so we have some. Y'all, listen. I've said this before. I'm gonna say it again. I'll probably say it a million times. I'm not the guy for the racial stuff. You know, I don't mind you mentioning race on the stream, but let's do it respectfully, everybody. Okay, I don't want this to be a place where we get into a lot of race debates. You can go anywhere in this country. You can go on X. You can go anywhere you want to do a lot of race debate and stuff. So again, I'm not saying we can't mention it. Race is important. Race is something that we do need to take into account. But let's be respectful, okay? Let's be respectful, even if you're expressing a strong opinion. Welcome. Is that Tasha Sue? Got a new member. See, now the memberships are starting to pick up, y'all. Now the new memberships are starting to pick up. I appreciate that. Lawsuit, Epic Games and Apple greed still ongoing. See, yeah, this was an actual lawsuit. Apple has really cornered the market in a sense. Thank you, Miss Lily. She has done very well for her experience. However, she went all the way in on some of the questions. There definitely has been multiple times where I felt the defense held back or avoided, or they just didn't drill down on certain things. Brian Steele didn't drill down on something, was it just last week? And I was like, man. Oh, yeah. Was that this week? That was 2 days ago when he was talking to the gang expert and he was cross-examining her, and he did not go into how do you find Thug has 500 songs out, and you say he has lyrics that match up with what you believe these lyrics match up with real world crimes or what have you. How do you sit down and listen to all 500 songs and compare them? Do you hire a freelancer in another country or in the United States to go through? And I felt he should have really drilled down on the process, because if a person only has one song, it's easy to sit down and listen to one song. If a person has 10 songs, it's easy to sit down and listen to 10 songs. If a person has 200 or 300 songs, where are you getting? Are you listening to all of them? Are you reading the transcript? How are you cross-referencing? I thought that would have been, even though he did absolutely expose her and all of the defense lawyers kind of exposed her, I felt that drilling down, he could have probably put a nail in the entire lyrics coffin by asking the process that someone would use to review 300 or 400 songs worth of material to try to line something up with the real world, with something that happened in the real world. She was clearly not familiar personally with Young Thug's music. So I would have, I maybe there's a reason why he didn't go there. And, I'm certainly have to defer to him. He's the expert. But I felt that would have been very instructive for the jury to start thinking about that. Yeah, how do you research 300-400 songs to try to line up what he said here with something that's in reality? You could have had a whole 20 minutes worth of questioning on that. Because then, just like they try to establish the truth of this to say, weren't you telling the truth? Remember when Hilton said to Woody had mentioned somebody wearing white shoes, and Hilton's like, well, she is wearing white shoes, right? So that's the truth. So you say, okay, so he said in the song, he said all of these things. Did you research those independently to see if he has a truth-telling pattern in his songs? Then, because he's with Thug, he could easily say, Thug, let's grab some lyrics. I'm gonna bring these up, and I'm gonna put them to her, not for her to interpret, even though he did do a little bit of that. But I'm gonna bring these lyrics up to show that this is make-believe, and that if you have 300, 400, 500 songs worth of material, some things are going to coincidentally seem to line up with real life. So I thought I thought that more could have been done with that, even though he did a very good job. Extremely common, and when these judges see how they are being broken, she interrupts. Somebody said that right now, that, yeah, she interrupted Abbasi's flow. Only Georgia law enforcement because they're corrupt. On race, human race, one race, human race. Yeah, y'all don't mind people bringing up race if it makes sense to talk about, but, I don't want this to devolve into some kind of race thing. Street saying because Fonnie was the only one with the info and gathered a bunch of experts. Yeah, so again, I thought a lot there's a lot of ground that could have been covered with that. But again, he's the expert as to cross-examination, so perhaps there's a good reason. Slow roasting, Abbasi. Love Paralegal, good platform. Chat is on point in art. Agreement to shady, corrupt untruths. Free Young Thug. Lil Woody, amen. Yeah, she was timid. They're like she was timid. So, yo, but you know what was funny? The gang expert lady, I know people felt she crumbled. She didn't crumble. I mean, my opinion is she just didn't know stuff, but she didn't have an emotional reaction. When I say crumble, she didn't like turn into a puddle on the floor. She just didn't know stuff. So her testimony certainly crumbled because how could it not? She was not the right person for that testimony. So her testimony was it's straight crumble, but she has like her integrity. She stayed firm while her testimony was just blown to bits. So if I feel like if I'm the jury watching that, I'm just whatever she said is just like nope, because you know, y'all know what though? There's some other things that I think could have happened. There's some other things that I think could have happened. And I don't know if this would have been off limits, but what if Brian Steele or one of them had asked, maybe Mr. Apt might have been the right one to ask this question. And correct me if he did, if somebody did ask this question. But were you prepared to testify on gang culture and lyrics in the past few days after Detective Dennis was removed from the case? I don't know if they could have gone there, but they they walked the line. That would have been a good question. Again, to further have the jury say, oh, so this is just thrown together right now. Roxy Louise went on her work computer. I appreciate it. Yeah, y'all, if you want to join, just go on a PC. It should work on any, I believe it should work on any PC. Rufio Banning, if it were reversed and the white team were replaced by the actual DA and since DA, people will be talking about it. I don't know what you mean by that, but it's possible. If you want to clarify, I'll be happy to address that. What about Bob Marley? I shot the sheriff. Can anyone? Yeah, Donald H. We went over that the other day in depth in our whole conversation about lyrics. Starfish and Coffee, she was a last minute expert and it was pointless to drill her any further. That's quite possible. I'm willing to concede that Brian Steele and the others, what they did was right on point and they didn't need to do any more. The reason why I said that he could have gone further with the lyrics, not for her, but to plant in the jury's mind that there is no reasonable way to search lyrics for lining up with reality when you're talking about hundreds of songs. So you would have drilled her not because you could have gotten more out of her, but because you could have planted that seed in the jury's mind that it's not even a reasonable endeavor to say, I'm going to look at 200, 300, 400 songs to try to see what you're going to find stuff that matches up. Like if you look at 400 Michael Jackson songs, he might not even have that many. But if you look at 400 songs of a person, you can find stuff that matches up with anything in the world because of the amount of content there is. Ross says this trial is a joke. They're losing the weight, I guess, of their words with Waffle and Bull. If they had tightened up, they may have had a better case. I totally agree with you. But let me ask y'all this, and I'm getting to some of the comments. I might have to skip down to get caught up. But let me ask y'all this. Do y'all think that as of this point, we're seeing a week and a half, almost 2 weeks? Almost 2 weeks of very little love. Love does not seem to be in charge. I think this is almost 2 weeks. Are y'all seeing a difference with the prosecution style? I know the personality style is different. So let's not go into, we don't hear her loud voice. That, of course not, because that's her voice. But are y'all seeing a difference in how they present the case and whether the case is flowing better and whether there are less mistakes being made? Or does it feel like, nah, we're pretty much seeing the same kind of flow, the same number of mistakes, etc.? What do y'all think about that? I think Steele didn't drill because he didn't want to turn the jury off. That's quite possible. Quite possible. But Steele Steele and Sharp both have kind of a soft touch approach, where Apt would have been the one who would have turned the jury off because he had very much of the attacking pit bull approach. So if I was going to have somebody go further, it would have been Steele. I mean, Young Thug is his client. He has a more kind of factual, kind of softer approach when you compare him with somebody like Apt or even Adams, who sometimes can feel a little bit, not always. Adams seems like he can, but Adams' voice and his demeanor sometimes is a little bit more, Apt was like the most pit bull of everybody. But Steele, I think, could have pulled it off. But point taken. Y'all, I'm going to scroll down. I'm not going to be able to read all of the comments because I want to get to y'all where you're saying about Miss Love. Miss Love is not there. Miss Love is not there. Are y'all noticing any difference in the approach, the presentation of the case, etc.? My better channel passed away. What is that, y'all? What is that, Miss Lily? So sad. Sorry. My better channel passed away. I'm not sure who is that. I'm not missing. I mean, I'm not catching that one. Love gets no love. Hilton is pregnant. Y'all, people been saying Hilton's pregnant for a while. She could be. If she's newly pregnant, you wouldn't really notice a lot. Prosecution has changed a little. How? Better, worse? There's no different. They still stalling. They seem to have stalled yesterday, for sure. But still the same strategy. Totally agree. Making huge progress. Is that the prosecution making huge progress? Wondering if Hilton is pregnant. People have been saying that for a while. I don't know. She wore an outfit the other day that some people said looked really good. And she didn't look pregnant to me that day. The flow is better, the vibe, everything. Saw the first day she wasn't there. She creates a toxic work environment. I think that is incrementally better. I don't think it's a total 180. They might have gotten 15, 20% better, maybe 25. I don't know if it's enough to really change the direction of everything. Still has that gentleness. Yeah, Still is very polite. If I'm wrong, just tell me. He's very polite. We're Apt the other day, and even 2 or 3 days ago. It was that last week when Adams came out. Adams is kind of like intermediate, but Apt was like full. He was like full on like Pitbull the other day. Honestly, I've been watching this trial, and if I was a juror, I don't understand how any of this correlates to Thug beyond a reasonable doubt. So, is it Tamara or Tamara Mack? Nobody does. In fact, as it relates to Donovan Thomas, Sprinkle he said in his report or in some transcript, he said he doesn't even understand why people think Thug is connected to Donovan Thomas. So this case is bigger than just Donovan Thomas. So we can't just limit our analysis of the Rico to Donovan Thomas, but that's been a big part of this case. And Sprinkle, who was an important investigator in all of this, said he couldn't even understand why people thought Thug had something to do with Donovan Thomas. Think about how important that is. He said, I don't even get it. Like, if he said, I get it, but I disagree, that's one thing. He's like, I don't even get it. So, and he's an investigator. That's major. To be honest, at this point, I feel like the state has implanted jurors for the guilty charge. That's how corrupt Fulton County is. Y'all, if that were the case, if that were to be proven, that would be way beyond any imaginable malfeasance that we've had up until this point. So let's hope that didn't happen, and let's definitely hope that there's no evidence or proof of that, because that would be earth-shatteringly bad if that happened. Still the boss, Superman. You said Hilton's pregnant. pregnant. Who else did? People been saying that Hilton's pregnant. State is making defense chase their tails. Can you explain a little bit? All right, as we continue, y'all, somebody tell me, and I know y'all are going to say nothing. But what would you say thus far is the crime that you feel has the most evidence for it against one of the defendants? I'll say it again. What crime do you feel that you would be the most likely if you had to choose one crime against one defendant? And if you don't want to answer, just don't answer. Okay? So if you don't like the question, just don't answer. But we are talking about this right now. We're talking about if you were in the jury, right? So the jurors have to consider these types of questions. This is real life. So what crime, what charge do you feel at this point you would say, not that you would necessarily vote guilty, but if you had to vote guilty on one thing, if you just had to select one thing for whatever reason, where you have the most evidence against somebody so far, which charge would it be and against who? Okay. And this, we want to try to get to some real facts here. Okay. So if you were like, I'm in the jury, so far, I feel like it's looking the worst for who? That's another way of putting the same question. Who are you scared for? If you want them all to be free, well, who are you looking at like, ooh, I don't know, because they did say this about that thing about this defendant. Okay. Who are y'all thinking? They convicted rapper rated based on his lyrics and gave him 20 or 30 years, I believe, in the 90s. Yeah, that I don't believe on convicting based on lyrics. You can learn so much from watching court cases, human behavior. Yes, totally agree. All right, y'all, I'm gonna skip down. Which rapper, or not which rapper, excuse me, which defendant do you think is in the most jeopardy for what, based on everything we've seen in the trial today? I'm gonna skip down. Anybody? Nobody's gonna take the bait on this one. Nobody's gonna take the bait. Lil Rod. See, that's the low-hanging fruit, Ken, because Lil Rod is already in prison serving time. So that's kind of the low-hanging fruit. Woody, also kind of low-hanging fruit. He's not on trial, but I can see why you say that, even though I'm not necessarily co-signing it, but a lot of people have said that. All right, Miss Lily, let's see if we can. All right, let me pull this up. I'm going to put this into a banner. Is anybody going to take the bait? Is anybody going to take the bait and give me a real answer? Which person who's currently on trial is in the most danger right now? Thank you, Miss Lily. I'll put that banner up shortly. Which person on trial is in the most danger right now? Lil Rod. Yeah. Okay, so he's already serving time. So is he really in danger? I guess from the perspective of he might get an appeal, so Lil Rod, because he has a so-called eyewitness. Lovey says none. Shannon. Okay, Lex, you're the first person that actually gave an answer. Lisa said the same thing. But for which charge? Okay, so Shannon looks like he's in danger, but for what? For which charge? Yak, which charge, y'all? I would do a poll, Gemini, but it would be difficult because I don't want to just get a name. I want to get such and such for the such and such charge. That's really what I'm hoping to get. All right, y'all, we back. No sound yet. If not Rod, then Yak. For which charge? Shannon, for which charge, y'all? That's what I'm asking. Which charge? Shark's client. Shark's client is Stillwell. Weinstein's client is Yak Gotti. People are saying Shannon, but for which charge? What is Shannon or yak, but what did they do? What are they being charged with? All right.
What were the warrants you took out for Mr. Ryan? What were those warrants?
For murder.
The only person who ever gave you any indication that Mr. Ryan knew Mitchell, Mr. Uten, the victim, anyone in the car, was Mariah. She's the only person who said they knew one another, right?
That you confused me a little bit. Say that again. Say it again.
The only person who said that Mr. Ryan knew Mr. Uten, the victim, Mr. Holmes, Mr. Mitchell, only person who said they knew each other was Mariah, correct?
I don't recall that.
Did you look at your interview?
Well, I'll be honest with you, I did, but I forgot what you asked me for to be looking for in there.
Okay.
Maybe it's a question. Ask me each person at a time. So Mariah, you're saying Mariah said she knew Mitchell.
Mariah told you was the only Mariah indicated, whether through this or something else, Mr. Ryan had some contact, knew the existence of Mr. Uten, Mr. Mitchell, Mr. Holmes, right? You never went to any of them and said, hey, do you know this guy?
No.
Okay. And they never, gave you any names saying, I think it was this person, or I have a problem with this, nothing.
They who?
Mr. Mitchell and Mr. Uten.
They said they did not know who shot at them.
Had no idea.
That's correct.
And didn't ask them if they, had any problems with Mr. Ryan or Mr. Blaylock, right?
Yeah, they're correct. Yeah.
Okay. And Mariah, she never told you anything about being locked in a basement, did she?
I don't recall that, no.
Okay. And she didn't tell you anything about Mr. Blaylock attacking her, did she?
Other than when Mr. Blaylock. Oh, no.
Okay.
No, not that I remember.
All right. And so based on the evidence you had, the person who fired the 7.62 was tall, right?
I was described, he was described as being tall, I believe. Just
All
a
right.
second, let me double check it. Just a second.
And I can get you a transcript of your interview with Mr. Uten if that further helps.
I bet you can. Let me see. Yes.
Okay. So Mr. 7.62 is tall. And based on all of that evidence, was your conclusion that Mr. Blaylock was the one with the 7.62, right? Page 18?
Page 18. Of what? Which one am I looking at?
Your report.
Well, if you got a page 18, you're doing better than me. I got 17 pages.
Oh.
Okay, wow. You got more than me. Okay, I see what you're referring to, yes.
Yep. So final conclusion you came to based on everything you reviewed was that Mr. Blaylock had the rifle.
That's what I wrote, yes.
Gotcha. All right, so we have rifle rounds, and then we have all these other casings from a smaller gun, from a 9mm, correct?
Yes,
All right. And those casings were found very, very close to the vehicle where the victim was, correct?
there were casings on top of the car, yes.
Okay. And casings on top of the car, you don't know how they got there, did you? Or do you?
I didn't see them be placed there or fall there, no.
Okay. Did you speak to the EMS, the emergency services people who would have been there responding?
They were gone when I got there.
Okay. So you're not sure whether they had to move anything to get to Mr. Holmes?
It was obvious that the hat we found on top of the car was placed there by someone.
Right.
I don't know who. But I guess it's plausible that somebody would say, hey, there's a shell casing, let's put it on top of the car.
Yeah. So they wouldn't want to lose it.
Don't know why they do that, but yeah.
Okay. So you discussed with Mr. Mitchell and Mr. Uten whether they had guns, correct?
Yes,
They both had guns, right?
yes.
And you never asked them if they shot, did you?
Mitchell said his gun was empty.
Okay.
Uten, I don't recall ever asking that specific question.
Right. You didn't ask him what kind of a gun he had, right?
I don't recall
Okay.
asking him.
You asked him what happened to it though later, right?
Yes.
And he indicated to you that you should.
All of this is hearsay. What Mr. Whoever indicated to whoever.
Sustained.
Okay. Did you have an occasion to either you yourself or have somebody go looking in the woods for a firearm?
Wasn't me, but yes.
Okay. And beyond that, you did not have any follow-up to tracking down those guns, right?
That's correct.
All right. And your reason for that, you previously testified, was you had no reason to, right?
I had no further leads. Once we tried to find them and couldn't, based on where they said they put them,
Okay.
there was nowhere else to go.
So you had no reason to try and find out whether Mr. Putin was the one who fired all those 9mm.
Say that again?
So you had no reason to try and figure out if Mr. Uten is the person who fired all those 9mm.
Right, I didn't try.
Because if he did, that would be your second shooter, right?
Your Honor, objection calls for speculation.
Sustained.
You, at some point, had an occasion to review Mr. Mitchell's Instagram records, correct?
Again, I'm not a computer guy.
Far later.
I allow other people on the team examine those. I trust them in what they can do because they're a teenager is better than me on that stuff.
Yep.
So I looked at the report or what was given to me. Did not do a deep dive. No, ma'am.
No deep dive. You didn't look at them.
Say it again.
No deep dive. I mean, you did not look at them, right?
I don't recall if I did. Yeah.
Okay. So you never did any follow-up with Mr. Mitchell about him shooting back, did you?
No.
But you learned that at some point he said he did, right? Or they did.
Yes, I did hear that. Yes.
Thank you, Detective.
Oh, you're welcome. You didn't get any of this stuff back?
Are there
That's all yours. You're welcome.
other defense counsel with questions for this witness?
Good morning, Detective Hogan.
Just check the time. Good morning. Good morning.
We've met before, but my name's Max Shard. I represent Shannon Stillwell, okay?
Okay.
All right, and the case that we're talking today does not involve Shannon Stillwell at all, does it?
Not that I know of, no.
Okay. I just wanted to ask you one question on Cross. You were asked about testing a car, the inside of a car for gunshot residue.
Right, yeah. I remember that.
And you responded that it would not make any sense to do so unless a gun was shot from that car, correct?
That would be the most obvious reason to do so, yes.
Okay,
Test it
so
for that.
if a gun is shot from inside a car, if your investigation leads you to believe that a gun was shot from inside a car, you certainly would test for gunshot residue, correct?
If there was any question that a gun was used inside the car, so if there was an allegation that it was, and
Yep.
then there was reason to believe that it wasn't, we needed to prove that a gun was used in the car, then certainly we should process the inside of the car for gunshot residue.
Okay, when you say process inside the car for gunshot residue, what does that mean?
Well, we asked the ID unit. I've watched them do it several times. They have a Q-tip, and they swab areas, and they preserve that Q-tip, which gets sent to the GBI crime lab. And then they do their analysis, their whiz bang stuff over there to say if there's any presence of gunpowder, I guess is what it is.
And we're talking about microscopic particles,
Yeah,
right?
if you shoot a weapon anywhere, if somebody shot in here, the residue would be however tiny, microscopic, but it would be here on everybody, everywhere. Yeah.
It would go all over.
Yeah, it goes everywhere.
Okay, and you would ask the collection team, we'll say, to the crime scene technicians, I guess is the formal term, correct?
Yes.
You would ask them to collect from the different areas within the car.
That's correct.
Are there any specific areas that you would have them focus on?
Generally let them do their job. They know more about that stuff than me. I ask them to process it and I allow them to do it.
Okay.
So wherever areas they are. Another, the GBI has been a little more stringent on their testing of that. They're getting away from gunshot residue because of the fact it goes everywhere. It doesn't really prove anything.
Okay, so the concern when they're going away from it is not that it gives false negatives, but it gives false positives.
Right. So, for example, if you're a gunshot victim, you're obviously a gunshot victim. Guys that in the past I know have tried to test them for gunshot residue. Well, that's kind of silly because they are a gunshot victim. They're going to have gunshot residue on them. Also, the fact that if they're in a room such as this or other people, and somebody shoots, and then that person gets away, but somebody else is alleged to be the shooter. Well, if he was in the same room, he's going to have gunshot residue on him as well because it goes everywhere.
So it sounds like what you're saying, if you get a positive result from gunshot residue, it may be unreliable for proving what you're intending it to prove.
You don't necessarily have to be the shooter if you were in the room when the shot went off.
But if you get it, but from what I'm understanding, if you get a negative, that's still a reliable result. It's just the positives can mean different things.
Yes.
All right, great. And in your experience at times, you said you defer to the experts on the collection method. Have you known them to remove different parts of a car for further testing for gunshot residue?
Yes.
Sustained.
I can approach it. It is going to be relevant.
All right, I'll give you.
And I'm just going to ask one more question. Is
Okay.
one of those parts that the experts remove at times the headliner of the car?
Yes.
Okay. Thank you. No further questions.
You're welcome.
Any other defense? Go ahead.
Good morning.
Good morning, Mr. Steele.
How are you?
I'm great. Thank you.
I'd like to ask you, in your work, have you ever had the need or the opportunity to ask for and secure surveillance cameras from businesses?
Several occasions, yes.
Okay. Can you tell the ladies and gentlemen jury, in your experience, have you ever had a surveillance camera operation where it would be a specific period of time that was captured? The images were captured by the surveillance camera.
Sure. Every system's different. There are some, from my experience, some common denominators. Most surveillance systems capture a certain period of time. That's generally around 2 weeks. And after those 2 weeks time period, it stops. You can kind of imagine that you're shoving the video into a tube, and as it comes out, there's just so much space to capture and to maintain. So as you capture more video, it starts falling off the backside after 2 weeks. So for example, if 3 weeks ago there was a crime that we became aware of, and we needed to try to get the video, we call if it's past that 2 week time period, the video is no longer accessible. It's been deleted. It's been overwritten and it's gone.
So in your example about the 3 weeks, so a video can hold up to 2 weeks of information, is what you're telling the jurors in our example.
It's kind of a general rule, Brian. But there are systems that capture and they keep them for longer periods of time, but those are expensive to maintain, and that's pretty rare that we have, but they're out there.
So if, just hypothetically, if we start on day 1 and the surveillance equipment can hold 2 weeks, so on day 14, from day 1 to day 14, it's all there if it's all working correctly. That's what I hear you say.
Yes.
I'm going to object to relevance.
It goes back. Now, on day 15, so day 14 ends, now it's day 15. Are you telling the jury that in your experience, day 1 is now gone, so now we'd have from day 2 to day 15?
That's my experience, yes.
Okay. Have you ever, tell the ladies and gentlemen jury, on day 15, so day 15 starts, all day 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 are gone?
Without a catastrophic failure of the system, I have never heard of that.
Thank you. Thank you, Your Honor.
Anybody else? No question. All right, redirect.
Detective Hogan, do you recall Ms. Abbasi asking you about your interview with Ms. Smith and how she, I guess, about how she described the long gun? Remember her asking you about that?
Yes.
Do you remember her specifically asking you about the use of the term rifle?
Yes.
And do you recall, based on your interview, Ms. Smith was only able to describe the gun as a long gun, correct?
Yes, she was not well versed in.
You can answer the question.
She was not well versed in guns. She was using pretty generic terms. Yes.
Now, I want to bring your attention to something that Ms. Abbasi just, one of her last questions, she talked to you about how Ms. Smith just kind of described or said how Mr. Ryan or somebody would know any other parties. Remember her asking you about that?
Yes.
And do you remember what Ms. Smith's response was, or conversation with you was about how Mr. Ryan knew Mr. Mitchell?
Your Honor, I'm going to object to this. It was not the question. The question was whether anyone besides Ms. Smith described him knowing one another.
I think she opened the door as to how.
Go ahead.
Do you recall?
Of how Ms. Smith knew Mr. Mitchell?
No, about how the question that Ms. Abbasi asked you was about how Ms. Smith described to you and talked to you about how Mr. Ryan knew Mr. Mitchell. Do you remember having that conversation with you? And if looking at a copy of the transcript would help refresh your recollection of your interview with Ms. Smith.
Sure, man.
I want to direct your attention to page 93, where the minute marker is 2:18:21.
And Your Honor, I'm going to object to this being hearsay. We're not impeaching her.
What are you going to ask?
What she said. I mean, that counsel opened the doors when she asked the question as it related to the conversation that the detective had with Ms. Smith about how the parties knew each other.
So are you refreshing his recollection as to what you said about it?
That's correct, Judge.
I'm going to permit it.
Your Honor, the question was about whether anyone else described them knowing one another, not what she said, how they knew each other.
All right, I'm going to allow it.
I can ask the question again, Detective, after you've reviewed.
Yeah, you're gonna have to. Give me a second. Okay, I'm with you.
Okay, so in reviewing page 93 of the transcript of the interview with Ms. Smith, can you tell the jurors, is your recollection refreshed as to what Ms. Smith indicated or told you about how Lil Rod or Rod and Mr. Mitchell were familiar or knew each other?
Yes.
And can you tell the jurors, what did she tell you?
She said that little Rod told her that BJ took his gun, Mitchell took his gun.
Now, I also want to talk to you about a question that Ms. Abbasi asked you as it related to describing, as you spoke with Ms. Smith, that this was an ambush. Do you remember her asking you about that, using the term ambush?
I remember using that term. Can you tell me where to look? I don't recall it in the interview.
No, what I'm asking you is during your cross-examination, Ms. Abbasi had asked you some questions as it related to you describing or using the term ambush. Do you remember that?
Yes.
And can you tell the jurors or describe to the jurors why your investigation and through your investigation, tell the jurors why you called it an ambush?
It wasn't a robbery. The shooters never approached the vehicle. They were lured to a certain spot.
Your Honor, I'm going to object to him testifying as these are actual facts. He can say what he investigated, what he did or did not
Sustained.
find.
So I'll rephrase the question. Can you tell the jurors what in your investigation drew you to characterize or classify this shooting as an ambush?
It wasn't telegraphed. It was sudden. They snuck up from behind and
I'm going to object again.
Sustained.
Same thing.
I'll move on. I want to put up State's Exhibit 10NN. Well, before I move on, and as she's putting up the photograph, based on you said you were in homicide for how many years?
10 years.
And you said you've worked in law enforcement since you said 1987.
Yes,
How many years is that?
a lot. 36, 37.
And can you tell the jurors, based on your training and your number of years of experience, well, let me ask you this. Before you worked in homicide, did you work cases that also involved shootings, but no deaths?
Yes.
And can you tell the jurors, based on your number of years of experience and your number of cases that you've worked that involve shootings, what the term ambush means in relation to your investigations?
Something that's sudden, unexpected, where the victim in that situation is pinched in or in a small area that he's hard to get out of or he can't get out of. Sit and duck kind of a thing.
Okay. Now, you see the photograph in State's Exhibit 10NN.
Yes.
Can you tell the jurors, is that drawn to scale?
No.
And can you tell the jurors, did you intend that photograph to, or that drawing to be an exact replica of the scene?
No.
What was the purpose of using State's Exhibit or drawing State's Exhibit 10NN?
It was just a way to kind of demonstrate what my theory was at the time when I created it.
And in your drawing, can you, well, I want to take you to State's Exhibit 18NN. Now, in State's Exhibit 18NN, can you tell the jurors in this photo and you're actually being at the scene, can you tell the jurors how many breezeways are in the building that we're looking in front of right there?
Just one.
Okay. And in your drawing, how many breezeways were depicted in your not to scale drawing?
One.
Okay. And I want to show you State's Exhibit, I think it's 17NN. Yes. So do you see 17NN?
Yes.
Can you point to the jurors in this different angle of the building, where on this exhibit would the breezeway be? Would it be on the left-hand side, the right-hand side?
The sidewalk leads to this off camera right here.
Okay, and then you see where on the right-hand side of State's Exhibit 17 and the building kind of intersects or meets with another building. You see that?
This here?
Yes.
Yes.
And I want to show you State's Exhibit 59NN. Now, in this exhibit's 59NN, can you show the jurors where in that exhibit are the shell casings that you described previously that were found in that area of the crime scene?
They're indicated with the yellow placards.
Okay. And in comparison to or in relation to your not to scale drawing in State's Exhibit 10NN, did you place red dots on that photograph to depict something similar?
Yes.
Okay. And when you were putting the red dots on State's Exhibit 10NN, did you put exactly 15 or What were the dots there to represent?
They were there to represent the shell casings.
And were they there to represent the shell casings, the general area where they were found?
That's correct.
And was in reviewing your drawing, States Exhibit 10 and N, is where you generally put the red dots consistent with where we saw the actual shell casings found on the crime scene?
When I created the drawing, that's where I thought they were, yes.
Now, while on scene, let me ask you this question. How long was law enforcement generally, if you know, on scene that night or that early morning at the scene of the shooting?
3 to 4 hours, maybe a little longer, I guess.
And in the time that you were there, did anyone approach you who had called 911 to speak?
No.
Now, Ms. Abbasi asked you some questions as it relates to how many shooters Ms. Ms. Smith described. Do you remember that?
Yes.
Can you tell the jurors, after the initial part of your interview that you described earlier with Ms. Smith, did she consistently, when she began, after you confronted her with the physical evidence, describe the fact that there were always 2 shooters?
Yes.
And can you tell the jurors, during that interview, was it you or was it her who placed nicknames in relations to those 2 shooters?
It was her.
And before Ms. Smith told you that, did you have any idea of the nicknames of who she said the 2 shooters were?
I did not.
And do you remember during that interview, Ms. Smith describing Mr. Uten and Mr. Mitchell running from the blue Charger?
Yes.
And can you tell the jurors, at any point during her interview, did she describe to you that as they were running?
Your Honor, I'm going to object to this as leading.
Sustained.
I'll withdraw the question. But I do want to ask you, Ms. Abbasi asked you about, let me ask you this question. Through your number of years as a law enforcement officer, have you received a number of trainings as it relates to firearms?
Yes.
And through your work with the Atlanta Police Department and the other law enforcement agencies you worked with before that, can you tell the jurors, are you familiar with a revolver?
Yes.
Okay. Can you tell the jurors, how is a revolver different from, let's say, a 9mm handgun or pistol?
Namely, there's several big differences between a 9mm semi-automatic handgun and a revolver. Revolver is self-contained. It has a cylinder that's in the middle of the gun. When you, it's either double or single action. If it's a double action, when you pull the trigger, it rotates the cylinder and at the same time pulls the hammer back. When the hammer falls as the next shell casing comes up into the barrel, it hits the firing pin and it shoots the projectile out of the front of the weapon. Biggest difference there is there's no shell casings that come out. The operator can open the weapon and dump the shell casings out, but it doesn't automatically eject them. Semi-automatic, 9mm, when you pull the trigger, it's a very similar action, except there's no cylinder. There's a spring that when you pull the slide back, a shell or a projectile with a shell is lifted slightly up from the clip. There's a clip that catches the projectile and puts it in the barrel ready to shoot. And then when you pull the trigger, a firing pin goes forward, projectile goes out the front. The slide automatically from gas pressure gets pushed backwards. The next shell casing is lifted up by a spring. It ejects the shell casing out, usually to the right, and then it goes forward, picks up the next projectile and shell casing to go into the barrel, ready to shoot again.
Okay. Now, in the vehicle, the blue Charger, can you tell the jurors were the defects that you observed in the car in the front or in the back of the vehicle?
Back and side.
Okay. And were there any, I guess, defects in the front of the vehicle?
Don't think so, no.
Okay. And is the defects being found in the back of the vehicle consistent with the vehicle being backed in or parked with the back end closest to the breezeway and the front end kind of closest to the access road?
Well, he said consistent with, overruled.
The damage that I saw was consistent with it being attacked from the rear and from the driver's side.
One moment, Your Honor. No, I'm further at this time.
Very quick, Your Honor. Go ahead. Detective, when you were speaking with Mr. Mitchell and Mr. Uten, you were trying to figure out if they had any idea why the shooting would have occurred, correct?
Yes.
And you addressed with them whether either of them had stolen anything, right?
Overruled.
I did.
Okay. And you had no indication that that would have been the reason here, right?
I tried to figure out with Mr. Mitchell, especially of the motive for what happened. Wasn't successful in speaking to him about that.
And Ms. Smith's statement about Mr. Ryan having stolen a gun, what did you do to vet that statement?
Mr. Mitchell stole a gun.
I'm sorry. My apologies. What did you do to vet that statement?
Nothing.
You said no?
I didn't vet it.
Okay.
I just took it.
Mr. Abate asked you about whether after Ms. Smith began talking about two shooters, whether she remained consistent about that. And you had no reason to press her and suggest otherwise, right? Because that was your theory, right?
That's correct, yes.
Thank you.
All right. Thank you for your time. Well, I guess I shouldn't have assumed that no other defense attorneys had recross. All right. I just happened to be correct. Okay. All right. Thank you for your time. You're excused.
Thank you, Judge.
And this seems like a good time to break for lunch. So we will break for lunch until, I think we've probably got some work to do during lunch. So I'm going to give the jurors until 1:30. All right, we need to deal with the Wooney Lee evidence. How long do you think that's going to take?
It should only take about 15.
All right, why don't we just do that before we break then? And I'm sorry, did y'all get to the point of forwarding
Yes.
the document
Did I forward it to you, Ms. Percival? Yes.
this morning? Yep, there it is. Okay. All right, so I've got that open. So if you can start directing me to which items are at issue. This is an, okay, Instagram. Is that
Yeah,
right?
yes, Your Honor. And I'll say most of the items in this packet will probably only come in if I have to impeach Mr. Lee. So we can definitely go through it, but just to set the stage, Your Honor, about what the items in here are.
Okay, so is everything that's in here we need to litigate? Is that what it is?
Yes.
Okay.
I'll begin pages 1 and 2. So let's start with 1. Page 1 appears to be a conversation. Mr. Lee is the SlimeLife Shawty. This is a conversation where he says, get somebody to buy my Switch. The next page is a photo of a firearm. I'm not sure how that suggests any sort of illegal activity whatsoever.
Your Honor, the fact that he has access to a switch in and of itself is illegal to have a switch for a firearm, Your Honor.
Have y'all charged him with that?
No, Your Honor. And for the first page, he has not been charged with the switch. And so we won't enter in page 1. Page 2 or page 3, Your Honor, which is Mr. Lee with a firearm, Your Honor.
Again, are you talking about the hand?
The hand, yes.
Can you establish that that's him?
It's his Instagram record, Your Honor. And it's something that I would ask.
No. If that's the best you can do, that's just a picture of somebody's hand holding a firearm. So that is not going to be permitted unless you ask him, is that your hand? And he says yes.
And that's why I started around that most of this is for impeachment because it would depend on the questions that I ask of him, whether or not this becomes relevant. So that's why I started.
I mean, I guess you can present him with it if he said, if you for some reason are able to ask him, did he ever have a switch? And he says no, you can, without showing the jury, present this. And if he says, oh yeah, that's me, then we've got one thing, but okay. Moving on to the next item.
Page 3, Your Honor. I don't know how Mr. Lee is involved in this. I don't see his screen name on here, so.
I'm not sure which page you're calling, page 3. Page
Well,
3 I
the
have
third page of this document, which is page
4.
17 and or page 2313.
Yeah, we're withdrawing this page.
Okay.
Page 2314 is a photo of, this time it's a leg for the gun.
Your Honor, it would be the same position as the first one.
Next.
The next one, page 5, which is the top Instagram page number 24836. The majority of this conversation is from author FOEVAKT. That would be hearsay. I'm not sure under what theory it would be admissible. It seems to be talking about business and a song.
Your Honor, we're going to withdraw this one.
All right. How about page 6?
I would defer to other attorneys if they have any objection to page 6.
Your Honor, I object unless there's a better, or some foundation. I heard what the prosecutor said, that they would not
Attempt to use it unless they lay a foundation or impeachment, but I don't know who these speakers are, except I assume that SlimeLife Shawty, SHAWTY, is the witness. But other than that,
Right.
I would object. I don't know if it falls under any type of hearsay exception.
The first post on June 4th of 2019, the witness who's testifying says the YFN expletives are at your house. And then a couple lines later, he says, just stay out of their way, bro. Too much going on. I'll come light that bitch up if they play with you. So considering that we put testimony in about the mother of Mr. Bennett's home, who is a member of that same YFN group that was shot twice, we've been discussing this back and forth rivalry quite extensively. So the fact that he's talking about explicitly stating the YFN group and he's going to come light it up in reference to shooting either at or towards those people, I think it's quite relevant, and he's testifying in the stand. So any questions or explanation he wants to give for that, he most certainly can.
So what about the other part of the conversation, though? Are you not offering that part? Gonna redact that part?
So, Your Honor, this is a back and forth conversation that he has with this other individual. And so I don't know what specifically, I mean, the bottom three, I don't know what specific line that defense is stating is not needed for the context of what Mr. Lee stated here.
Well, certainly the last bit of it isn't needed, but I mean, not since all that X has been happening, we don't know who this is, and that is indicative that stuff's been going down.
Yes, Your Honor. And the state, what I just read and what's highlighted is what the state, that's why we included this.
Okay, and I'm asking if you're going to redact it, because if you throw that up on the screen, I know that the highlighted part is what you're highlighting, but the rest of it is easily visible.
Yes,
so
Your
are you
Honor.
going to redact?
We can redact it and keep that just the username, so it doesn't appear that he's just speaking to himself.
Okay.
And we will take out where he says everything else he says. It's that's perfectly fine, Your Honor.
All right. Page 7.
Yes, Your Honor, page 7, this is going to be a combination. We have a hearsay within hearsay. We have Mr. Lee asking who Fat was talking to. Not sure the relevance, because I don't know who Fat is. They might ask questions which make it relevant, different conversation. But the response from someone who's not testifying is what that person heard. So we have hearsay within hearsay. The next statement is also from this other person who I'm not familiar with who the speaker is. Mr. Lee's response is ambivalent, just say no more. And there's not any further conversation that I see would be relevant.
What's the state's response?
So, Your Honor, this specific exchange, it's very predicated on what Mr. Lee responds, his response is on the stand. If he says, just like the post I just referenced before, if he says, I've never heard of YFN, I have no problems with them, I'm actually quite friendly with them, they're not opposition to me, I hang out with them weekly, then these kind of threads could become relevant, where they're saying, I just heard he was with Slime, he told him he was with YFN, and then the person, again, not Mr. Lee testifying, says that those people are ops, and then he responds, say no more. That in conjunction with like the one we just spoke about, I don't know the exact question we would ask Mr. Lee, but none of these conversations, if an improper question is asked and the court sustains the objection, you will never have the predicate foundation to introduce this. And so I do think it hinges very much on how his testimony.
I think that
Your
before
Honor.
you think it's appropriate to use this, y'all need to approach, because I am having a hard time envisioning how
Yes, Your
this
Honor.
would be appropriately used.
Yes, Your Honor.
Okay.
The next page, Your Honor, is going to be page 8, and a conversation between Slat Quay and Mr. Lee. Again, I think we have hearsay. We don't know who Slat Quay is or what his possible involvement could be. They're talking, it sounds like, about something which happened in the past. I'm not sure how that would come in as any hearsay. It would be, if anything, spilling the beans, not furthering the interests of the gang, if that's even the exception they're trying to use. I don't know.
You're right. I think that falls in the same line of argument that this conversation will fall into that same line of what Mr. Atkins just articulated. Your Honor. Page 29, Your Honor, would be, I think, in line with the same articulation that Mr. Atkins just did for the page before. It's the same individual. It's the same conversation. The same two people in conversation.
It would be to potentially establish that, yes, he did know who YFN were, and that was significant to him in some way.
Yes, Your Honor.
Well, that's potentially a better example of it than the one above. Talk into your mic. Talk into your mic and talk to me.
Was talking to you, Your Honor.
Okay, because you're gesturing over at them.
I know, but I believe this is what I referred to the other day with regard to the person that is identified as Slat Qua, not Quay, but it's Slat Qua. One has not been identified, but it is certainly no one in this courtroom, and I believe that the state will elicit that. This is my understanding, and I'm looking at you, Judge. It's my understanding that that would be the testimony. If there's anything else, I want an opportunity to.
It was my understanding that the state and the defense were going to enter into a stipulation that any reference to a qua here or wherever it comes in this Instagram, there was a stipulation that it wasn't any of the people nicknamed Qua or Quay in this courtroom. Have y'all not done that?
Judge, that's been my understanding as well.
We're-
However,
We're still working on that.
All right, well, sounds like we might need to get to it before Wooney Lee testifies.
I agree.
Your Honor, myself and Mr. Harvey had spoken a short while ago where asking this witness, this is his thread of who is this? And then I do not know what his response will be at this moment, but I do not expect him to say it is Mr. Nichols or Mr. Huey. And whoever he says, if he says, I don't know who that is, you can ask him, is there anyone in this courtroom here today? And if he says no, I think it will be crystal clear that that was what me and Harvey were, we hadn't finalized it, but that was what we were discussing. The state's not trying to insinuate.
Discuss
it's
it with
anyone in the
Mr.
courtroom.
Matthews also.
Yes, yes, Your Honor.
If y'all come to an agreement, that's fine.
Your Honor, I will.
And why don't you let me know what that agreement is before Mr. Lee testifies?
Your Honor, Mr. Rubin, Mr. Lee's attorney is here. I will ask Mr. Rubin and we'll have that answer before lunch, by the
Okay.
time we come back from lunch.
And Your
Going
Honor,
to ask the attorney what the answer to that question is.
So he
gonna
can
be?
ask his client, that's Mr. Lee's attorney, so we can get the answer of who Slack Quay is over the
Okay,
break.
and then what if he says one thing to his attorney now and then he says another thing on the stand? Are we going to have another specter of putting an attorney on the stand?
No, Your Honor,
Not.
I believe that we have been in communication with each other. So I don't think that result
I'm not
will
sure
occur.
that that's going to resolve it, but if the state and Mr. Matthews and Mr. Harvey come to an agreement about that, that's fine. Y'all let me know.
We will.
Okay, next.
Your Honor,
So is there another objection besides we need to make sure that everybody knows who this is or isn't the slack qua?
I do, unless it's
Okay.
coming in under 248807 D2E. All that Mr. Lee, according to this document on page, all he says is you all got into it with them. Everything else would come from this other person. So that's my objection as well. That page really is not very illuminating on what Mr. Lee is doing to further the interests of the alleged conspiracy.
So it would be, as I understand the state's position, it would come in to impeach Mr. Lee if he claims not to know who YFN is. Is that correct?
Yes, Your Honor.
Okay. And so do you need the entirety of it?
On a different page anyway.
This is, I'm looking at page 1397, the highlighted portions of 1397.
To the court on page 854, which I think is 2 pages forward or above. It's Mr. Lee. It's identified as Mr. Lee's Instagram account, and it says YFN ends be by your house. So I don't see why we would need it set, on another page.
A different one. Oh, that's true. Okay, so.
The state's position remains the same. This will become relevant depending upon the question. So this might not come in at all. And so what would the court like for us to answer?
So if there is already something in, Mr. Steele makes the point that you actually have Mr. Lee on page 854 of the Instagram record talking about them YFN ends. And so that would establish that he knows who they are. And so you don't need the others. So that's true. All right. And if you think for some reason one of those others is going to be relevant, again, you're going to need to approach before you use it.
Yes, Your Honor.
Because it shouldn't be needed for the reason that y'all just offered, considering page, whatever it was, 854. Okay. All right. And then what is this? What's on page 9?
I'll defer to Mr. Steele for the remainder.
All right.
It looks like there are notes, internal notes written over the document. I would not want that shown to the jury.
Yes.
We don't intend to introduce these notes. We're actually going to pull the actual thread. And I believe that was communicated in the email that we sent. But for brevity's sake, we wanted to show defense counsel where the language we're speaking of, but this is actually in Mr. Lee's Instagram return. So we'll find the actual, we'll have the
Okay.
actual pages of.
But what we need to be looking at is just the thread.
Yes, Your Honor.
Okay. And is there objection to the thread?
No.
Okay. All right.
If a proper foundation can be
All right, and then I just got another email forwarded about Wooney Lee exhibits. These are pictures, maybe posts from somewhere. Is there issue about these? Do we need to litigate these? Do y'all know what I'm talking about? States 36, 37 through, I don't know.
This is just the PowerPoint of the exhibits we plan to introduce during Mr. Lee's testimony, Your Honor.
All right, is there an issue, is there an evidentiary objection to 36 through 46, NN, and then 4Y?
And most of these, Your Honor, were in the Wooney Lee folder that we went over a few weeks
Yeah,
ago.
I mean, if we've already litigated it, great. I'm just asking so we don't.
Did it a few weeks ago, but as far as 36 NN, 37 NN, and 47 NN, those are the issues that I brought up on behalf of Mr. Stillwell. Those involve Mr. Stillwell, and I brought them up yesterday morning.
Okay.
But as far as anyone else is concerned, these are not things that have been litigated, except the ones that I brought up yesterday.
Okay. So does anybody else have any objection to any of these items?
Your Honor, I was proceeding on the state's email, which was sent two days ago. This is what we need to review for Wooney Lee. So I've not had a chance to go through all of these.
Y'all are just too much, honestly, all of you, or most of you, not all of you, but a lot of you.
Your Honor, to be clear, so when we made the witness boxes from 1 through 30, 31 through 60, and 61 through 100, for the, there may be a photo here that, you forgot to put into this witnesses folder, but all from discovery. So when we're creating these, like the exhibit PowerPoint, some of it includes exhibits that are already admitted in the trial itself. It's literally the PowerPoint in order of how the state's going to ask direct questions of this witness. So there shouldn't be any surprises with what's in this PowerPoint in terms of, I don't know what day or week it was that we went through, but I know that there was a moment where we got through all of them, where the court would say, does anyone have any objections with this witness? Does anyone have any objections with Mr. Sprinkle, with Agent Burney? And we went through number by number. And of course, if an objection is raised, this honorable court will hear it from any party. But, when we say we haven't litigated or have litigated, in the state's minds, when these issues are brought up, does anyone have an objection on the floor for this witness in the exhibits the state has indicated that they may use with that witness? If there's no response.
All right, well, take the lunch break and look and see if you have objection, and can we come back at 1:15? Yes.
And I can speak to one, just so everyone knows. I know I have an objection now. I didn't realize it was in this PowerPoint, but it was something that was recently, the state recently indicated that they plan to use, which is number 12. That's a screenshot.
I don't know what you mean by number 12.
Number 12 on the PowerPoint. It's 46, slide 12,
Okay.
46
NN.
And that's just a screenshot. I believe that to be a screenshot of the beginning of a 15-minute video. And I believe that video is titled something like A Night with YSL and 4L. I've watched that video. I've reviewed the video. It's basically a group of young men at a music studio and in the parking lot outside the music studio, and they're kind of interviewing each other, and I guess it was released as a promotional type thing. But I don't know why that 15-minute video would be relevant or admissible.
Yes. I can email over the different timestamps that are the most relevant portions of this video. It's not the entirety of the 15 minutes, and I'll do that before I leave court.
So are you saying you are only planning to play
certain portions of the video?
Certain little distinct parts of it?
Yes, and I'll send that over right now.
Okay, do that right now. And then when we come back at 1:10, now we can take it up. No, I'm not. No. All right, so anything else we're gonna need to deal with? Oh, so the limiting instruction, if nobody has anything else to add, does anybody have anything else to add on that limiting instruction that I'll read before Mr. Ryan's conviction is entered?
Well, I don't know as to whether we made a number one or number two decision.
Yeah, I decided it on my own because
Oh,
nobody
okay,
got
well-
back to me. I picked number one.
That probably
So,
would have been my pick, but
all right.
I
good.
want to reiterate, though, that I agree with Mr. Steele's position that ultimately neither one of them eliminate the confusion from, boy, we can use some of this against some of the people, but we can't use some of this against some of the people. So I want to reiterate that
Okay.
and just reinforce that as well.
All right. So I have, at this point, I mean, I can send it back out, but let me just do that real fast. And I haven't changed anything with regard to, let's at this point just focus on the Mr. Ryan one. Let me get that over to Ms. Persfield so she can get it over to y'all. But I've taken out the reference to overt acts numbers or overt acts at all. Because when I started trying to craft something that would explain, hey, this is to overt acts, but that's not all you have to, find if you're going to find, when you're making your determination on count one, I realized that it is not really just to overt acts anyway, that it could be taken into consideration in their determination of whether they think anybody was conspiring to engage in a pattern of racketeering activity. And that just goes down a whole, I don't know, wormhole, black hole, I don't know what, of having to stop and give the final jury instructions now, which I'm not going to do. So I'm just saying, count one. Yes,
Your
sir.
Honor, on behalf of Mr. Stillwell, we appreciate the court's efforts. And this is a difficult situation, and we are just, for the record, joining with the thoughts of Mr. Steele and with Mr. Harvey, that a jury instruction is not
Not
going to be
enough.
is
Okay.
not enough. But I just wanted to place that on the record.
I mean, I assume everybody's joining in
Okay.
that objection, and that's fine. I've looked at a lot of different federal circuit case law involving RICO cases, and it appears that even when a conviction of a co-conspirator comes in, as long as a limiting instruction is given, there's not a confrontation clause problem.
And I just feel the need to bring this up at some point sooner rather than later. There are convictions of Mr. Jimmy Winfrey, my client, Mr. Stillwell, and I believe Mr. Nichols that have come into evidence.
Right.
We brought up these issues previously with the prior judge, and we were not given. We asked for them not to come in. We asked for limiting instruction, and we were not granted those things. So I don't know how we're going to cure that for those.
So I mean, I thought that we had discussed the Winfrey one, and I said I would just, at the end, when I remind them of all of the things that are only for certain purposes, do that. I didn't know that anything of Mr. Stillwell's had already come in without a limiter.
They have, and I believe Mr. Nichols as well.
Okay. All right. Well, then I will add those two to the Limiter I'll get at the end. And again, they're not supposed to be deliberating until the end anyway.
Okay, so when you're saying at the end, you're talking about
The-
jury instructions.
My jury instructions, yes. All right. See y'all in a fairly short amount of time.
All right, people. So we're on lunch for a few. I'm just gonna run it back, y'all. I'm just gonna run it back to the beginning of the day. Gonna run it back. So enjoy. Enjoy. Just gonna run it back. Keeping an eye on the trial. And when we're back, we're back. Oh man, if I had a cowboy hat, I would throw it on right now.
Good morning, Your Honor.
Not. All right, y'all.
On
I'll run it back.
paragraph, it's in the alternative wording for Mr. Kendrick. It states, hold on, I've lost my place.
And honestly, I'm looking at it now and it may not even be 100% applicable. That second sentence in the alternate wording, I had just noticed that in the other guilty plea limiting instructions, that was more the language. So I was throwing that in for y'all's consideration as to whether anybody would prefer wording of that type to the couple of paragraphs above that. But yeah, I mean, whether another person has been convicted of the same charges isn't necessarily applicable anyway.
So, and my concern is that the honorable court's not addressing. Yes, I understand that something could be used against. I'm just using his name, but Mr. Kendrick, not against the others. But
right.
But then it says that you can use the other evidence, and there's no instruction that's only if the jury finds beyond a reasonable doubt that one or more of the persons entered into a willfully and knowingly. And
right, but we're talking about overt acts. I mean, they're going to have to. That's another step or portion of what they're going to have to decide, and obviously they're going to get full instructions at the end of the trial. So I'm not going to get into here's how you're going to consider all of these different parts of the RICO count.
I do understand, but as a listener, I guess, for a juror, they don't even get to decide the acts unless they first find it. They could do it any order they want, I guess, but they first find that there was a willful and knowing joinder of the conspiracy.
Sure, that's a part of what they're going to have to find as to each defendant before they can convict anybody.
And I'd like that language in any instruction, because otherwise, let's assume that this trial ends, the state rests in December. That's approximately a month and a half, maybe 2 months from right now. Meanwhile, the jurors are being conditioned, in my words, from the honorable court's instruction that, hey, yeah, we can use evidence against everybody except certain evidence. So I'm going to realize that this is against everybody before there's been no instruction to my knowledge in this entire case that they have to first find that there's a conspiracy, that a person joined the conspiracy. So
they're not supposed to be deliberating until the end of this case, the close of all the evidence, all of the jury instructions. So there isn't a danger of that.
okay, well, that's my problem.
All right.
Because
Well, I'm not going to give them a full kind of mid-trial mini instruction on how to consider RICO. They're not
Okay.
supposed to be doing that yet.
Okay, I'm not trying to say a full instruction, but just a line, maybe. I put it in.
I mean, I can say, I'll give you further instructions later
on
how to consider all of this.
and whether a conspiracy even exists or a person joined a conspiracy. That's what I'd like, because I do find, yes, I understand that they'll be instructed later, but I do find that it is jurors should have some context of this instruction. This instruction standing alone seems like it's already, that there's a suggestion. I'm not saying the court's doing it on purpose, by the way, but there's a suggestion that other evidence can be used against everybody. Well, that may not be true.
I'm not, I'm only saying it as to if the state presents evidence aside from the guilty plea as to overt acts 55 through, or I'm sorry, 56 through 59, and then aside from Mr. Ryan's trial conviction as to overt acts 79 through 81, which, I mean, they're certainly doing that for the murder of Jamari Holmes. They're doing it right now. So if I mean, I guess I don't believe that it is broader than what this is saying, which is specifically as to those enumerated overt acts.
Now, I would like something, if you, ladies and gentlemen, find, based upon my instructions that will come at the end of the case or at appropriate time, that one or more of the people on trial knowingly and willfully joined a conspiracy, then go into something about, then you may not use the guilty plea or verdict, whichever.
All right, well, I
against anyone
appreciate
else.
that, but I don't think that's necessary,
Okay.
and I don't think that this misleads them into thinking anything at all
Okay.
wrong, really. Okay.
And
So,
I still believe my original that the evidence shouldn't come in at all, because I'm struggling with the instruction. So,
all right, well, I
with that
think
being said.
in terms of if anybody would prefer the language, you may not use this conviction in your consideration or deliberations against any of the other defendants in this case. It is not evidence of anything against these other 5 defendants. Each defendant has a right to have his guilt or innocence determined by the evidence presented against him, not by what happened with regard to a criminal prosecution against someone else. That's one version. The alternate version is you are not to consider the co-defendant's, whatever it is, conviction as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of, charges or something. I don't know what that language is, but any preference as to which of those two the court uses? No, nobody cares. Okay. Well,
either one. and
I'm
like the-
definitely going to give one or the other of them, because if I don't give one or the other of those, then it will be reversible error in the event that there ever is a conviction in this case, which of course would be ultimately a benefit to your clients to build in reversible error. But I would prefer not to do that, because the court's job, to the extent I can, is to avoid any error at all, much less reversible error. So I'm going to give one or the other versions of that language. Does anybody have a preference as to which version of that language the court will give?
Your Honor, can we, since I have a preference, I still maintain my objection. I don't think it's reversible error if you keep out these pieces of evidence, and that would be my preference.
No, I don't think so either, but that's also not fair to the other side.
Can we just huddle for a minute so we may have
And
a split?
y'all don't have to tell me right this instant. I just need to know before the conviction is going to get introduced, which may be sometime today. Yes. Okay.
And if they're huddling now, once they're finished huddling, we just have another announcement to the court.
All right. How about announce, and then if they want to huddle, they can huddle.
And good morning, Your Honor.
Good morning.
The state does intend to call Mr. Lee this morning.
Okay.
He will probably be our third witness this
All
morning. I know we were, Miss Abbasi and I were supposed to speak very briefly. After they're huddling, we can have just 2 minutes to speak.
Well, I may have them huddle later
Okay.
because the Winnie Lee stuff's more pressing, because you can you can tender the conviction, in any order.
Yes, Your Honor.
So on the Wooney Lee evidence, is there any objection that still needs to get hashed out?
Yes, Your Honor.
All right. Okay, and then if so, where's the easiest place for me to find the
Your Honor,
evidence?
if I may, there's something we wanted to address first.
Okay.
Your Honor, I've got some members of the defense side here taking a look. Our understanding, and if it turns out to be wrong, it turns out to be wrong, was that the state was undecided yesterday as to whether they were going to call Mr. Bernard Mitchell. I know at the lunch break, Mr. Hiles was on the stand. His text messages had already been admitted. We went back to speak with him. The state went back and attempted to speak with him. So at that point, my understanding was it was still up in the air. I can be wrong. My understanding was it was still up in the air. Per Your Honor's request, we had discussed as many things ahead of time as possible. The discussions with the state were, and it was very clear for both sides that we were not going to be objecting and not asking this court to litigate Mr. Mitchell's Instagram records because the state was going to call him. Yes, with them coming in, there were portions that we intended to use with the understanding that that is what would come out in terms of evidence. His messages would come out, so we would want another section in there. If the first section is in there, we would want the second section in there. But he's certainly not our witness. The evidence he presents is not a theory of the case that we would have brought to the table. And so now the state does not want to call him. And I think we're faced with a confrontation clause issue because we relied in good faith on our discussions with the state. We didn't go through and take the court's time to say this is conditionally admitted based on this happening. So we simply relied on what they represented to us. We had the evidence, came in, it was read out. I contacted the state last night to say, hey, I'm not sure what you want to do about this. We feel in a position that we are forced to ask for a mistrial. We really don't want a mistrial. We'd like to be able to rely on what we were told. And like I said, we're checking to see if there was something definitive on the record. But if Mr. Mitchell is not testifying, then we feel we have no option but to ask for a mistrial.
Would the state like to be heard on that?
I guess the state's response, Your Honor, is that the state, after the lunch hour, indicated to
Talking to the mic, pick one up maybe.
the state after the lunch hour indicated to the court, as well as counsel, at least for Mr. Ryan, indicating that we were not going to call Mr. Mitchell, basically because he told not only the state but defense counsel that he wasn't going to say anything when he came onto the stand. That was the same thing that was told to us by Mr. Uten. And my recollection is that it was an either or is what the understanding was. It was we were going to maybe call either Mr. Uten or Mr. Mitchell. And yesterday we decided neither. So I don't know how there could be a confrontation issue that's being claimed today. If we decided to put Mr. Uten up yesterday and not Mr. Mitchell, the records would have still come in the same fashion without Mr. Mitchell testifying. More importantly, before any message came in as it related to Mr. Mitchell, the state indicated to defense counsel that we were not calling Mr. Mitchell. We indicated that to the court as well. And
I don't remember y'all indicating anything to the court until the end of the day, y'all. But what I was told by the deputies was that the state had very clearly said they can be transported back. We are not calling either of them. And that was at or right after the lunch hour that I was told that. I asked yesterday morning, is this an either or? And yesterday morning, the state was definitely indicated, it might be one, it might be the other, it might be both. We don't know yet. We still need to talk with everybody. And then we just went on with the trial, and they didn't, after lunch, they went back because y'all had made that determination, and you certainly communicated that to the deputies with regard to transport. And you are making the representation that you also let the defense know that? Did y'all disagree that the state let y'all know they didn't intend to call either witness?
Excuse me, at the very end of the day, I had inquired to the court, said, discuss what's going to be the order tomorrow. And I
Right.
said, well, Mr. Mitchell, Mr. Uten, checking, Mr. Kokomo took a look, and before lunch, what was represented to the court said, who are we going to get to? And they said, we may not get to him today. So
That was before lunch.
that was before lunch, and then we came back in and everything was published.
And everybody not everybody, but counsel for Mr. Ryan and counsel for the state spoke with, I guess, Uten and Mitchell over the lunch break.
We went back, he didn't want to speak with us, that's fine. We went separately from the state.
Right.
We didn't discuss anything with the state about who would or wouldn't be called at the lunch. And I don't believe before we started in the afternoon. That's not my memory. The announcement before lunch was we may not reach him today. They spoke with him. Obviously, at the end of the day, I still thought they would be called.
My recollection is after lunch, I was sitting there. Ms. Abbasi said, so you're not calling Mitchell? And I said, no, we are not calling Mitchell. That's my recollection before Mr. Howes began testifying after lunch. And we didn't call Mitchell. And the messages came in unobjected or not objected to. And there's been no conditional admittance of evidence that's been permitted
There has not.
or agreed to by any of the parties during the trial of this case, at least the time that I've been here. So it's my indicator, be the state's opinion that any objection to the messages that came in are waived at this point.
Your Honor, our response is, we have difference of memory. That's fine. It is what it is. If the state knows they're not going to call him going into it, I don't think it's fundamentally fair for them to publish and then say, ha, you missed it. I don't think that's good faith. As far as, no, we didn't conditionally admit it because we've done everything we can, at least for Mr. Ryan, to avoid taking up the court's time. This is what it was. We all agreed. We all understood. So that's how we proceeded. And now here we are, and we're stuck in a position we don't want to be in.
Well, I'm not quite sure what to do with this. I have a representation from Mr. Abadi that the state communicated to defense counsel that they were not intending to call Mr. Mitchell or Mr. Uten, and that was communicated prior to Mr. Hiles' afternoon testimony in which this evidence came in. And Ms. Abbasi, you're saying, well, that it's not my recollection, but I could be wrong. That might be. So
I will not say my memory is perfect. I have no memory of having that conversation after lunch. I'm not going to say, Mr. Abadi's. I can't promise you my memory is 100% accurate. And I'm certainly not getting up and saying that Mr. Abadi's lying. I'm not going to do that. But I have no memory of that conversation at all. And, as I said, I brought up at the end of the day, what's the order of the witnesses? When are Mr. Mitchell and Mr. Uten coming in?
I don't remember that.
I had brought it up when we were asking about witnesses because I didn't know if the sheriff needed to bring them over. And that's what was coming up.
Are you saying that you on the record asked when Mitchell and no, you didn't?
That was at the very end of the day. We were just
Amongst counsel?
I believe Your Honor was on the bench when we were discussing just who are we getting to tomorrow.
Yeah, I asked who we were getting to tomorrow. I don't recall you saying, when are we getting to Mitchell and Uten?
Well,
I don't recall the two of them being mentioned at all at the end of the day.
I know I asked the state at that point, oh, you're not calling him? No. And at that point, the evidence had already been admitted.
I'm asking you, did you make that statement on the record?
I don't believe so.
I
We can
don't
check the
either.
record, but I don't think so. I think the last statement on the record was we may not get to them today.
I don't recall that statement on the record or off the record. This is all a surprise to me this morning that now there's some debate about it because everything I knew post-lunch yesterday, although through the sheriff's office, not through the state or the defense, was that a decision had been made and communicated that neither of them was going to be called. I mean, can't really do much else with I don't see a basis for a mistrial. So we need to deal with Wooney Lee's evidence. And y'all are just going to have to communicate or put more things on the record or something if you want to avoid misunderstandings in the future.
That's fine. We'll litigate everything forward.
Or just put on the record your understanding.
Yes, Your Honor.
So if the understanding was these will come in if Mitchell testifies, just say, we talked about all of this and we don't have any issue as to, X, Y, and Z. And these things we've agreed are going to come in if Mitchell testifies. And then there'll be a record of it and everybody will know what they're dealing with.
I mean, I guess the state can make the suggestion. I mean, we can call him and the state will have no questions for him and then defense counsel can cross him if that will solve the issue.
I mean, at this point, he might have yet again been sent back, even though my staff was making Herculean efforts this morning to try to get him over because somebody wanted him. At the bench, y'all said, nope, that's fine. We don't need him. And by y'all, I mean you, Miss Abbasi, said, that's fine. We don't need him. If y'all aren't calling him, fine. So we just communicated to the sheriff's office, they don't need him. I don't know where he is at this point.
Okay. And Your Honor, Mr. Kokomo checked at the end of the day. I did inquire for the court, who do we need tomorrow? And gestured over to the door. And then that's when Ms. Love said, we've talked about it and we're not calling him.
All right, well then, that's even more of a record against your recollection.
I guess I don't understand. There would not have been any reason for me to ask about whether people were coming from the back after the evidence had already come in if I knew he was appointed to be testifying.
So you're saying you pointed towards the holding cell doors?
Right, asking about witnesses for tomorrow.
All right, well, that is no record upon which to grant a mistrial. So let's get to the Wooney Lee evidence.
Yes, Your Honor. We sent it.
What are we doing on the Slack quad?
Sent the email on yesterday at 9 a.m., Your Honor.
To whom?
Well, you know what? I don't think Ms. Percival is on it, so let me forward it to Ms. Percival. I'm sorry. We're forwarding the reduced.
We're just trying to get the whatever evidence we're going to litigate now up.
All the attorneys should have received it yesterday at 9 a.m.
Right, I'm just saying the court doesn't have it.
Yes,
so.
I just forwarded it.
Can counsel approach for a minute, please? We've got the jury and they've been waiting for 20 minutes already. And I just think it's not considerate of any of us to litigate things that they can't hear and just make them sit around. So we'll just do y'all have to take somebody out of order, you have to take somebody out of order, but I'm not going to have them wait anymore. Call your next witness and we'll get to the Wooney Lee evidence when we can get to it. Okay. All right, I'm going to get the jury out. Who's your next witness going to be? Okay. Thank you. Go ahead.
Sure. My name is Al Hogan, ALHOGAN, and I'm a detective with Atlanta Police.
Good morning, Detective Hogan.
Good morning to you, sir.
Can you tell the court how you are currently employed, sir?
I am a detective with Atlanta Police. Currently, I'm assigned to General Investigations out on Fulton Industrial, but prior to that, I was a homicide investigator for about 10 years.
And Detective Hogan, can you tell the jurors how long you have been employed with the City of Atlanta Police Department?
I have been certified police officer since 1987. Had a couple of different jobs with the sheriff's departments and the air marshals, but anyway, I landed in Atlanta about 15 years ago.
And you said you had been a police officer since 1987. Prior to working with the City of Atlanta Police Department, where were you in law enforcement?
I started in the jail in Fayette County, was there for a few months. They put me on the road, was certified then in 1987. I worked as a road deputy in Fayette County. I was promoted to detective, worked undercover narcotics locally, and then I was assigned for a good many years, 10 years or so, to the DEA task force at the Atlanta airport. We did drug interdictions there. In between there, I spent a brief period of time as a federal air marshal. This was before 9/11, and that job wasn't for me, so I came back. And that's when I went on through with DEA and then eventually landed in Atlanta about 15 years ago.
Now, you a few minutes ago told the jurors that you were assigned with the homicide department for 10 years.
Yes,
And can you tell the jurors, were you assigned with the homicide unit here with the City of Atlanta Police Department back in February of 2019?
I was, yes.
And can you tell the jurors a little bit about, I guess, how you're assigned specifically to any homicide case that you're working here in the City of Atlanta?
It is the luck of the draw. We're all in a rotation. There's a big board in the office. There's about 17 of us that are in the rotation, about 6 of us that work cold cases. At the time I was in the rotation, and your name is on a magnetic strip with a label on it, and everybody's name's in a row or in a column. As murders occur, the person from the top catches the murders. He's the leader, he or she's a lead investigator, and they go to the bottom, and everybody moves up. On this particular day, I was at the top.
Okay. And can you tell the jurors on February 23rd of 2019, were you dispatched or called to come out to the location of 50 Mount Zion Road?
Yes, I was.
And can you tell the jurors what was the reason you were dispatched to that location?
There had been a homicide, a criminal homicide, what they suspected to be a criminal homicide, and they asked homicide to come to work the case.
And is that address 50 Mount Zion Road? Is that here in the City of Atlanta, Fulton County?
It is. It's in Southeast Atlanta.
Okay. And when you, I guess, can you tell the jurors, we've heard about different zones that are within the City of Atlanta. Which zone does this location fall within?
Zone 3.
Okay. And the Zone 3, does that include the area of like Cleveland Avenue?
It does, yes.
Okay. Now, can you tell the jurors when you arrived to the incident location, can you kind of describe for them what kind of property it was? Was it a business? Was it a residential location?
It's an apartment complex.
Okay. And were you the first to arrive on scene?
No, sir.
Can you tell the jurors? Now, with not being the first to arrive and being, I guess, assigned as the lead detective because you're number 1 in the rotation, can you tell the jurors a little bit about the first things that you do when you interact with other first responders who arrive before you, other officers and detectives?
Sure. So they, just by the act of being there and doing their job, they've gathered some information that may be interesting to me or help me with my investigation. So of course, I get there, observe how things are laid out. They have delineated the crime scene and what they think the crime scene is. So they mark that out with yellow tape, trying to make that a pretty big area. This particular one was a fairly big crime scene. So I could see that when I pull in, and then I speak with the 2 officers that are watching the crime scene log. I speak with the general investigator who has started the crime scene drawing. I talk with the ID technicians that are there that are, and I assist them and make sure that any evidence that I see on the scene that I'm interested in or like for them to gather or document, I make sure they do that. And I just try to glean as much information from what they have from them so I can help me further my investigation.
Now, after speaking with other members of law enforcement who are on scene before you, can you kind of describe, I guess, the layout? You said that this was an apartment complex or a residential complex, a little bit about the layout of the complex as you first observed it when you arrived.
Yeah, it's a large complex in 2 phases. There's a Mount Zion Road. Obviously, it faces Mount Zion. The address is 50 Mount Zion. Then there's a phase, I'll call it phase 1, which is in the front that's up closest to Mount Zion. There's a creek that runs behind that phase 1 is a creek. So there's a bridge and an access road down one side of it. I think it's the east side of the property that goes past over the creek. And then there's a large recreational area, a big grass field. and then the playground for kids. And then the second phase is in the back, but there's only one way in and out to get to the second phase. And it's in the back of the property across the creek. This crime scene encompassed all of the access road to get to the phase 2, and all the way up into a pretty good portion of phase 2 where the road runs up into the parking lots, the access into the phase, the buildings in the phase 2.
So in a second, Detective Hogan, we're going to put up State's Exhibit 11NN, which was previously admitted into evidence.
Yes, sir.
Can you see it on the screen?
I do.
Okay, so do you see at the top of State's Exhibit 11NN, there's, I guess, a red line that's drawn. It's right by where the time is, where it says 9:33 a.m.
Right there, you're talking about?
Yes. Can you tell the jurors, is that building that you can kind of barely see at the top of State's Exhibit 11NN, is that the first phase or the first building of the complex?
That's correct, yes.
And then do you see in the middle of State's Exhibit 11NN, it looks like something, looks like a brown kind of something that's separating the grass in the middle of State's Exhibit 11NN?
Right here.
So in the middle of State's Exhibit 11NN, you see trees, and there's this.
Oh, that's the creek. There's the bridge.
And then it's the area you described, I guess, where the playground and things, the recreation area.
It's under here, under the trees, back over here.
Okay, so it's towards the, I guess, the left side, kind of middle of State's Exhibit 11NN.
That's correct, yes.
Okay, now you described to the jurors briefly about the second phase or the second half of the apartment complex. Do you see that phase in a State's Exhibit 11NN?
I do. It's this phase here.
Okay. And can you tell the jurors what areas in State's Exhibit 11NN, if you can see it, I guess, were pertinent to your investigation in relation to the crime scene?
Immediately when I pulled up, I parked in the parking lot up here, if you can imagine the phase, because that Mount Zion Road would be up here. I parked my car outside the crime scene tape and walked in. I checked in with the crime scene technician. Immediately I could see that there was a blue car resting against the fence, and I think there was a big rock there it ran into right here, where there was some stuff on the ground and stuff on the car. And as I walked up, of course, that's going to be pretty interesting. It's not supposed to be there. So as I walked up, I saw that it was part of the crime scene. There was blood in the passenger seat. There were bullet holes in the car. There were shell casings on top of the car. Items of clothing were on the ground and on top of the car. And then as I walked further past, I could see there were some tire tracks that were through the grass here, beside the building here, as well as more shell casings that were kind of scattered out in this area over here. And then they had crime scene tape stretched out across here and across there to deny any access into the crime scene.
Now, you talked about crime scene tape and things of that nature. When you arrived, had the crime scene been fully secured?
Yes.
Okay, can you tell the jurors a little bit about how that's done and why that's done?
Yeah, well, we're trying to preserve evidence. Everything in there may have something of value to us that we could use to further investigation. So obviously we don't want anybody to tamper that either on purpose or by accident. So we try to protect it. We try to make it as big as the officers that responded made it as big as they thought they needed to protect everything that I just described to you. The shell casings are easily kicked or moved. We don't want to touch anything that may have DNA or fingerprint evidence on it. There's just lots of things we need to try to protect so we don't damage our own investigation.
And Your Honor, can I approach the witness?
Yes, you may.
I want to show you what's been marked as State's Exhibits 48NN through 67NN. If you'll just flip through those, have you had an opportunity to go through those prior to your testimony here today?
I've seen them before, yes.
And as you're flipping through them, I guess, what are states exhibits 48 and through 67 and N?
These are all crime scene photographs from the scene.
And do I guess the photographs in states exhibits 48 and N through 67 and fairly and accurately depict the crime scene, 50 Mount Zion Road, when you arrived on February 23rd of 2019?
Yes.
Around at this time, the state would tender what's been marked the state's exhibit 48 and N through 67 and N.
Those are admitted.
Now, you talked about the area of, I guess, where you said it was a blue vehicle.
Yes.
And
Indicated by Ms. Hilton in that
Okay.
email. And on behalf of, I've discussed with Mr. Steele, we don't have any objection. I don't want to speak for anyone else. But I didn't see anything that we object to.
Okay.
In those specific
Anybody?
times,
As to those specific times, which Ms. Hilton, that's all y'all intend to play for that one video, 48 in or whatever it was. Okay, anybody else have objection to those specific times? In 48, I think it was, I don't know, I could be making that number up.
I think it's
Whatever the
46
video
November,
was.
November.
It's 46.
46, okay. All right, I'm taking the silence as no one has any objection to that. How about any of the other exhibits that are contained within this Wooney Lee?
Yes, Your Honor, page 5, 40 November, November. Just have an objection unless they can lay the foundation because Winnie Lee is tagged, but I don't know who tagged him.
What is this a picture of?
It's a picture of him sitting in the courtroom during Mr. Ryan's trial.
45?
No, 40 November, November, page 5.
Oh, page 5. 40, okay, sorry.
Your Honor, we actually redacted all of the other content that was actually on this post because I believe Mr. Lee will say that is him while he was sitting in the courtroom. This was during Mr. Ryan and Mr. Blaylock's initial trial of the murder of Mr. Holmes. And our initial understanding, and he has said something different today, was that he was in court when the witness who testified yesterday, Ms. Smith, was testifying and sent her a brain emoji and a rat emoji. And so this was evidence of him being in court.
Okay.
However, he has said to me today that he was not present during her testimony, but this does show that he had actually went to court that day. So things have changed just slightly, given his testimony, but at one point he was in court watching that trial, and essentially he sent these emojis to Ms. Smith. And so someone captured him on video and tagged him in it along with the tag. The post also reads "free little Bali, free little ride." We've taken those parts out of it because the individual who posted it is not.
All right, I'm not following, I follow what this is a post of, but I'm not following why you're going to be using it. Or I don't understand what you're saying, because you're talking about his testimony and his statements changing. So what do you mean?
So
why would you be how would this come up at all?
To show that this was a photo of him in court.
Okay.
When we believe when the witness was testifying, and based upon what Ms. Smith advised us, I believe, or matter of fact, his phone was taken on the day that the posts were made. So Mr. back in 2021, during the trial of the case, we believe that Mr. Lee was present in court.
When
While
was
in
the
court,
testified? Yes. And that while in court, he sent those emojis?
he posted those emojis. We believe he sent them while in court. He posted those emojis. Whether or not Ms. Smith was on the stand is something he's saying. He never saw her on the stand. That's what he is saying. What we know is he was in court when those emojis were posted. Whether or not she was on the stand or not, we don't know. But he was present in court, we believe, when those emojis were posted. And so this was just proof of the fact that he was sitting in court in or around the time that these subsequent messages that are coming after this post were posted.
How are you? This is a picture of him in courtroom 7E, apparently.
Yes.
How are you proving that it is during Mr. Ryan's trial? Am I missing something?
He is a part of our,
Are you going to be able to establish when this picture was taken?
Yes, I believe he will admit that he went to the trial and saw the trial
Okay.
himself.
And which
I believe he
case,
will admit that.
why will
that's-
you need this picture?
to show proof of those things. The same way we have a responding officer who goes to
Okay.
a scene.
So you're going to put it up and then say, is this you in court during the Ryan Blaylock trial?
Yes.
Okay. And I guess if he says no, he says no. Okay. So in terms of the objection, then
If they lay the foundation.
I'm
that-
not sure what you mean by if they lay the foundation. So they're going to present it to him and say, is this you in court during the trial? And he'll either say yes or he'll say no.
Right, if he puts himself there, but the date and the time that they're saying, then that's this foundation. But if he doesn't, I don't. If he says no, then it shouldn't come in because he didn't lay the foundation.
I agree. Okay. So that's that one. What else?
And then the next one. 41 Nancy, or November. That's just a screenshot of his Instagram.
41. Okay. Hang on. Hold on. All right. And so what is this? A relevance objection?
Correct.
Your Honor, so for 41 and this screenshot was taken along with 42 and 43 and on the day that we learned of the emojis being sent to Ms. Smith. And so this captured that this was his Instagram account direct messaging the witness, Ms. Smith, with these emojis. And so 41 NN, 42 NN, and 43 NN established that.
So that would be.
I am sorry that I am not following you, but are you saying that day in court, his phone was confiscated and screenshots from his phone were taken?
So we learned about the emojis being taken.
Thank you.
Our office then went to his actual page and they were able to, excuse me.
Okay,
Let me
you said
confirm.
something about his phone having been taken, but
His phone was also taken in court, separate and apart from being able
Okay.
to capture the images from his Instagram page that showed him communicating with the witness.
All right,
And I
so walk me through what on 41 NN shows him communicating with Miss Smith. And I'm sure this is me just being from a different generation than the Instagram generation, but.
And I misspoke. So 41 NN, when the witness reached out to our office, she screenshotted 41 NN, which is his page. Then she also screenshotted 42 NN to show the individuals who are following her, which it shows Mr. Lee's Instagram handle. And then she also screenshot and sent to us 43NN, which is the actual direct message he sent, which is of the brain,
Which is what?
an emoji of a brain. He also sent an emoji of a rat, but that emoji was deleted prior to the witness being able to screenshot that as well.
Okay. And so how are you getting these things in?
As a part of his plea agreement, one of the things he admitted to was the fact that he sent the emoji. So this is just proof of that fact that he sent them.
So how are you getting the first two in then?
Because this is
He
his,
admitted that he sent a screenshot of a brain.
yes,
Is
Your
that-
Honor.
Okay.
And a rat
so
emoji.
If he denies that on the stand, you'll show him this and is that what you're saying?
No, if he admits or denies, this is just proof of it the same
Okay.
way of
All right, so then I guess I understand 43NN and I guess 42NN.
because this is her page. So you have to be able to show that.
How are you going to show this is her page?
So
But that would have been something you asked her while she was on the stand.
Her Instagram records are
So,
blessed auntie.
on,
What?
Her Instagram was blessed auntie or blessed auntie. That's what the ADA Hiles testified to.
that was her Instagram in 2019. The trial was in 2021. So she changed her Instagram.
But how are you going to show that this is her Instagram?
He admits to who he sent it to. So he is admitting that he sent this brain emoji, which is but from SlimeLife Shawty.
I'm not asking about 43NN. I'm asking about 41 and 42NN. I'm sorry to not be clear about that.
So 42 and then shows that he is someone on her page.
How is this her? How are you going to show this is her page?
Her pictures are at the top of the page, Your Honor. That first picture is the young lady who was here yesterday.
Is that just how everybody's Instagram looks? They have pictures of themselves at the top of the page. And so everybody who's young knows, oh, that's so-and-so's Instagram?
Yes.
Or can you post whatever you want at the top of your page? Or could somebody else have posted her picture at the top of their page?
No.
I mean, it doesn't. I mean, I could pull up a picture of Elvis and put it. I mean, I actually don't know that.
Your
'cause
page.
I think I probably could
So this
find my Instagram and put a picture of whomever I want on there.
The-
But I don't know that.
So
Of course,
Your
correct.
Honor,
You can put whatever
right.
image you want to on your page.
So how does this establish? How are you going to be like, okay, see, this is her
This is her
page.
Instagram story. So at the top of this story are pictures, Instagram videos or pictures that she posted on her story, which lasts 24 hours. So there's 1, 2, 3, 4 images on the top of 42 NN. When you actually, you can't see it as well on here, but when you have it on the screen, you can zoom in and that is her.
I mean, I believe that's probably a picture of her.
So then what she sent to us is a screenshot of her Instagram stories and she could see who was viewing her stories at the time.
Right. But you didn't ask her yesterday when you had her, hey, are these two screenshots that you sent us back in the day from your Instagram? So how are you going to establish that this is from her Instagram?
Your Honor, I think circumstantially from the fact that he's going to admit that he sent it to her, that he is on 42 NN, you see an individual with the same vanity name that he has viewing her page, that there's pictures of her at the top of the page, and then 43 NN showing the slime, showing his same vanity name with the brain emoji.
What
I
does
believe
41 show at all?
41 is simply to show that this was his Instagram page. SlimeLife Shawty is Mr. Lee's vanity name. So this is just the front of his.
All right, we already know that. Don't we know that from some other witness already? So do you need,
We know that SlimeLife Shawty is Winnie Lee, but the individual is taking the stand, so we can.
fine, you can say, is this your Instagram page? And I guess you can ask him if 42 is her Instagram page that he followed. But if he says no, then I think you're stuck with that answer. Okay. And then 43, sort of the same thing. Okay, what else?
That's it on behalf of Mr. Ryan, Your Honor. Thank you.
Anybody else with any objections to any of these in this compilation?
Nothing further from Mr. Williams, Your Honor.
Okay. Nobody else. Okay, are we ready for the jury?
Yes, Your Honor.
Yeah. Question. Y'all didn't want that witness shown, and you're about to put up a picture of her.
We're not, Your Honor.
Okay. Let's get the jury in.
Your Honor, Dr. Sullivan is next. We're just trying to find where she is. We did tell her to be back at 1:30, so if we could just have.
Okay, well then she should be back because it's 1:34.
So we're trying to make contact with her, Your Honor.
I feel like this trial is too complicated for human comprehension, y'all. This trial is too complicated for human comprehension. I don't think there's a human out there who could totally understand this trial. That's going to be my contention. Clizzle, thank you, sir, for another. I believe you're a sir, but thank you, sir. If I'm wrong, correct me, for another super chat before the break. Imagine the jury comprehending. I don't think the jury, even if they were trained lawyers, would comprehend this. Some of them, some juries will understand some parts, but I don't think anybody would understand the whole thing. Yeah, I would. I'm not gonna lie. I would be spaced out at least 60% of the time. I'll be spaced out at least 60% of the time, y'all. I will be spaced out. Yeah, I know. So I have taken this on, but like some of what I mean by understanding it is, imagine how many limiting instructions they're going to get Rob, Tyler. Imagine how many times they've been told to forget what you just heard.
Will he be arriving soon?
Yes, his attorney went to go get him.
Imagine how many times they've been told to forget what you just heard. Imagine how many times they've been told that this applies to that person, but not to these other people. Imagine how they're going to get jury instructions. They're going to get a bunch of different instructions about what evidence can be used against who and all that stuff. Not to mention the fact that they're not rewatching any of this, so they have to go off of memory. Not to mention the fact that they aren't supposed to be talking to anybody else, so they have to lean to their own individual understanding, not like us, where we can talk about it and help each other understand. They can't go back and find the clip. They can't go back and review the transcript. They can't go back and do anything. Okay? They do deserve it too. I totally agree with you. This should be an associate's degree. They should get honorary degrees from some community college or university. Is this the detective we're waiting for? I thought we were waiting for a detective. All right.
Wunnie Lee, Wunie, last name Lee, Lee.
And good afternoon. How old are you?
25.
And are you employed?
Yes.
What do you do for work?
Music.
And when you say you do music, what do you mean?
I make music.
What type of music do you make?
Hip hop. Hip hop.
Do you have a name that you perform under?
SlimeLife Shawty.
And are you signed to a record label?
Yes.
What label?
Alamo Records.
And when did you first sign to Alamo Records?
2018.
And I should ask, how long have you been in the music industry?
Since then.
Since 2018. Have you been signed to any other label besides Alamo?
No.
Where are you from originally?
Atlanta.
And what part of Atlanta?
Southside. Cleveland Avenue.
And did you go to school?
Yes.
Where did you go to school? Elementary, middle, and if you went to high school?
Cleveland Avenue Elementary School. You said middle school too?
Yes, sir.
Crawford Lawn Middle School. And Carver High School.
Carver?
Yeah, Carver High School.
Carver. After leaving high school, is that when you started your music career?
During high school, like my last year in high school, or like 11th grade or something. I didn't get serious till after high school though.
You said you didn't get serious until after high school?
Yeah.
And that was around that 2018 year we just talked about?
Yeah.
Okay. As you were growing up in the Cleveland Avenue area, did you ever hear of a gang called Rock Crew?
I heard of it growing up. I didn't know if it was a gang or what it was, but yeah, I know what it is.
And how did you know about Rock Crew?
Because they had popular songs.
What were some of their songs that they had that were popular?
I don't know by heart right now.
Okay.
I just knew like there was the music back then.
Do you know who were some of the artists who were with Rock Crew?
One of them, Big Boo.
And was he performing as a hip hop artist?
Yeah.
Anyone else?
Um, mm, it was some younger people too, like my friends and stuff.
Who are some of the younger people?
They locked up or dead.
Do you have names of some of those individuals?
Let me see. My partners who locked up right now, twin, they used to rap.
Do you know their given name or
Their first and last name?
or their first name?
Nah.
Anyone else outside of Twin?
Rudy. He rapped too back then when we was younger.
Anyone else you can think of?
As of right now, yeah, that's it, I think.
Now you just spoke about Big Boo. Did you know his given name?
His real name? No.
And did you have your own personal relationship with Big Boo?
Yeah, when I got older.
Now, did there come a time when you were younger that some members of Rock Crew began calling themselves YSL?
Mm-hmm.
You said, mm-hmm.
You asking me that, or
Yes.
you what?
I'm asking you.
Can you say it again?
Sure. As you got older, were there members of Rock Crew who then became members of YSL?
Yes.
Who were those some of those individuals?
Everybody, because YSL music took off and rock crew music died, or just I don't know. Boo got old, so I don't know.
So who are some of these people? You're saying everybody. So who's the everybody who was a part of the music?
Basically, everybody from my neighborhood.
So everybody from your neighborhood was doing music?
There's a lot of people from doing music from my neighborhood though, but not everybody was doing music though. I'm just saying like everybody in the whole, all the people that were rapping or doing music or supported the music was on some YSL stuff now. Like it wasn't rapping Rock Crew or under that name.
Okay. So tell me some of the people that we're talking about.
Me, myself.
Okay.
My friends who I just told you about. Jeffrey. I can't think of everybody's name.
And what does YSL stand for?
It has multiple meanings.
Tell me some of the meanings.
I say it has multiple meanings, definitions, or what it stands for.
So tell me some of the meanings.
Young stoner life, young slime life, young successful lifestyle. I think that's all I can remember right now.
So let's talk about young stoner life.
Mm-hmm.
When do you distinguish between young stoner life, young slime life, and young successful lifestyle?
You said when? Did I?
Yeah, how do you distinguish between the two? When do you use young stoner life versus young slime life?
Slime part is just like the lingo of it. Like, we'll just call each other or something. You wouldn't call your friend or something like stoner. What's up, stoner? We just say like, what's up, slime or something. So that's how I think young slime life is used. Young stoner life, from what I know, was I'm just say like a way of life as far as music. I mean, not the music, but like getting high or like a hippie or I don't know.
And outside of the music, is YSL a gang?
You said outside of the music,
Yes, sir.
some people treat it like that.
What do you treat it as?
I treated it that way before.
You treated it as a gang before?
Yeah.
When did you stop treating it as a gang?
I don't know. I don't remember. I don't know.
You said you don't remember. And when you say you treated it as a gang, what do you mean?
I don't really know. I never thought about that. I don't know how to answer that.
How old were you when you joined YSL the gang?
Can you tell me what you mean by like join? Like, are you talking about?
What would you consider joining?
I'm saying, like, do you mean join like, because like to get in the gang, you join the gang, like you get beat up or something like that.
How did you become a member of YSL?
My music got popping and I became a known face in my neighborhood, and I started coming around and going to studios and stuff.
So was that how you became a part of the gang YSL, or that's how you became affiliated with the music of YSL?
I'm gonna say that's how I became affiliate of the music of YSL. But as far as joining a gang or something like that, I never like joined. We just all grew up together. There was no time to join or when I joined. We just all know each other from school and grew up together and stuff like that. But I mean, I came around like I forgot, was 2019 or 18, one of those years, when I came around as far as like officially being YSL.
How do you become officially YSL?
Just coming around more and rapping.
Is everyone that is affiliated with, and I'm talking specifically the gang YSL, rappers?
Some people.
So, but not everyone?
Some people rap. A lot of people rap, but everybody doesn't take it serious. Some people just rap just because they want to rap, because they want to follow the trend.
I definitely understand that, but I want to ask specifically, is everyone who's a part of YSL a gang trying to rap or rappers?
Can you say it again?
Sure. Is everyone who is a part of YSL the gang rapping or try to be rappers?
I don't know. I think so. Everybody try to rap.
Is there anyone in YSL the gang who's not trying to rap?
Yeah. I think.
Now I'm going to ask if you know a few people, okay? Do you know Marquavius Huey?
Yeah.
Okay. And how do you know him?
I didn't know his real name until this trial, but how do I know him? Me and his little brother went to school together. Me and his little brother was in the same class, and I always just knew he had a big brother named Quay.
And
and seen him a couple times, stuff like that.
And is that what you called him, Quay?
Yeah, I think that's what his name used to be back then.
Okay. And you said you went to school with his little brother. Do you know how old he is, Quay?
Quay, how old he is?
Yeah.
No.
Okay. Did you ever used to hang out with Quay?
When?
At any time?
Not growing up. He came to the studio with me a couple times. That's it. We never hung out outside of the studio.
When did you start seeing him around the studio? If we're in 2024, how long ago was that?
I don't know. I can't remember the exact date.
And do you see him in the courtroom today?
Yeah.
Okay. If you could just identify him by article of clothing he's wearing.
You said identify what?
But identify him by article of clothing he's wearing.
He next to the lawyer with the brown. I think he got on brown too.
Okay. Thank you. Your Honor, let the record reflect that he's identified Mr. Huey.
It'll say reflect.
Do you know another individual by the name of Quamarvius Nichols?
Yeah.
Or another Quay?
Mm-hmm.
Mm-hmm. Is that yes?
Yes.
And how do you know, how long have you known Quay?
I know him. I knew him longer, I think, since I was a kid. We didn't hang though, but I just knew who he was. I was younger than him though.
And do you have a friendship or a relationship with him?
Not a strong bond, but we know each other.
And do you see him here today?
No, actually. Oh yeah, I see him now.
And if you identify him as well?
I can't see what he got on. He just got the dreads up
Okay.
in the air.
And all right. Is he towards the back of the room, the front of the room, or
To the
somewhere
back.
else? Is he sitting in between anyone?
Yeah, I think his lawyer.
Your Honor, let the record reflect that he's identified.
It's really not, that could be a couple of different people.
There's two lawyers right there. He right there, and there's a lady next to him on the left side of him.
Right now, let the record
All right,
reflect.
it'll say reflect.
Do you know someone named Shannon?
Yes.
And do you call him Shannon?
Yeah.
Okay. Do you call him anything else or just Shannon?
I think I just say Shannon.
No.
I don't know.
How long have you known Shannon?
I don't remember. I don't remember when I met him.
Is it longer than you've known Quay, the two Quays?
No.
Shorter than that?
Yeah.
And what is your relationship like, if any, with him?
Now?
Let's talk about before now.
Oh, we were cool.
Are you still cool now?
I don't know him right now. He's been locked up for a couple of years. What, I ain't supposed to say that?
Disregard that.
And just listen to the question that I ask you, okay?
Mm-hmm.
All right. Do you know someone by the name of Yak?
Yes.
How long?
I got a question.
Do you need to talk to your lawyer?
No, I'm just trying to see. I ain't supposed to say that or something. Well,
Don't worry about it. Just move on to the next question.
all right.
How long have you known Yak?
I don't remember when I met him. I don't know. I don't remember.
Okay. Is it longer than you know any of these other people? The first three people I asked you about.
Not longer than I knew the Quays.
Okay.
I knew them when I was younger.
Okay.
I probably met Yak when I was about 18, 19, 18. When I started rapping seriously.
Next, Jeffrey Williams. How long have you known Mr. Williams?
Like the same thing as Yak.
Okay. And then Rodalius Ryan.
I've known him since a kid.
Are you older or younger than him?
Older.
Do you know how much older you are?
Not exactly. A couple of years though.
And do you have a nickname for him?
I can't hear you.
Do you have a nickname for him?
A nickname that I have for him?
Do you call him something?
Oh, Leroy.
What is your relationship like with, just generally, what is your relationship like? Good, bad, indifferent? What is your relationship like with Little Rod?
Right now?
Just period.
Oh, good relationship.
And do you see Shannon, Diamante, Jeffrey, and Rodalius in the courtroom today?
Yes.
Yes. Okay. Appreciate that. So that's stipulated too.
All right. Do you see Diamante? Just describe him by the article clothing he's wearing.
You said, do I see who?
Yeah, or Diamante.
Yeah.
What is he wearing?
Like a trench coat.
Is he sitting next to
A
him?
yellow, I mean, tan. I don't know what color that is, but a trench coat next to the lady.
Y'all let the record reflect. Is he sitting between two ladies?
Oh, yeah.
Okay.
I didn't see the other lady right there.
Y'all let the record reflect that he's identified Diamante Kendrick.
Okay, the record will so reflect, and I don't know if jury, y'all been explained what a stipulation is. That just means everybody agrees, so you can accept that as a fact. That as to Mr. Stillwell, that this witness knows and can identify Mr. Stillwell.
Did you see Mr. Williams?
All right. And so it is now, you can accept as fact that this witness knows and can identify Mr. Williams.
And then last, Mr. Ryan.
Yes.
And where is he seated and what is he?
In the front row, next to his lawyers.
All right. Y'all let the record reflect that he's identified. Is he sitting on the right side of his
Right
book as
side.
well? Y'all let the record reflect that he's identified Mr. Ryan.
We need to probably do a little bit better than that with the identification.
What is he wearing?
A suit.
All right. And so you can now accept this fact that this witness knows and can identify Mr. Ryan.
Thank you. All right, just a few more people. Do you know someone by the name of Trontavia Stevens?
Yes.
All right. And do you have a nickname for him?
Talking about Slug?
Is that what you called him?
Oh, yeah.
All right. How long have you known Slug?
I don't know. Like 2018 or something, I think, when he got out.
Okay.
I think. I don't know.
All right. Do you know someone by the name of Darius Ford?
Yes, I do.
All right. And when he was living, how long had you known him?
Like all my life.
Did you all grow up together?
No.
Okay. How did you know him all your life?
My brother was best friends with his big brother.
Okay.
And they played sports together, so I always knew him when I was a little kid.
What about Christian McMiller?
What about him?
Do you know him?
Yes.
All right. What you call him?
Christian,
Okay. How long had you known him?
since a kid.
And what about Durante Beebe?
Mm-hmm.
Is that a yes?
Yes.
How did you know him?
We grew up together.
And then last, Demekion Garlington.
Who?
Demekion Garlington.
You asked me how long did I know him?
Do you know him?
I know him. Yeah, I know him.
And how do you know him?
I don't even know how I know him.
And does he have a nickname?
D.
Now, do you have any tattoos, Mr. Lee?
Yes.
And specifically, I want to ask, do you have any tattoos with the wording Rudy?
Yes.
Okay. And who is Rudy?
My little brother.
Is he your biological little brother or someone you call your little brother?
I just call him my little brother.
And your tattoo with Rudy, what, if anything, does it say?
Long live Rudy.
Long live Rudy.
Long live.
And within the Cleveland Avenue area, do some people call themselves the Rudy Gang?
You said there's some people who call themselves that?
Yes.
Yeah.
Okay.
It's not really a gang though.
What's the significance? Tell the jury about a Rudy Gang.
His family made that for him. They're just showing that they for him. Like they doing it for him. I don't know. They just see a game.
Now, do you have social media?
Yeah.
And specifically, do you have Instagram?
Yes.
Okay. What is your IG handle?
SlimeLife Shawty.
How long have you had that Instagram handle?
I don't remember.
Okay.
When I made it, I don't know.
We're in 2024. Did you have it last year?
Yeah.
You know what? Let me ask you a better question. From the time you got into the music industry in 2018, have you had that Instagram handle?
Yeah.
What is your primary purpose of using Instagram?
My primary purpose is just social media. I think I would have had an Instagram whether I rap or not. So just social media.
And have you used IG to post photos?
Yes.
Have you used IG to direct message people?
Yes.
Have you been in group chats on IG?
Yes.
Right. Have you been in group chats or had DMs on IG with Jeffrey Williams?
Yes.
What was his Instagram name?
What is his Instagram name?
Mm-hmm.
Jeffrey. I don't know. What's his Instagram name now? You said what was it then?
Yeah. When you were communicating with him using your IG, what
I think it's the same Thugger.
is it? Thugger or something else?
I think it's Thugger. I think that's his Instagram name right now.
Have you ever used the handle Thugger1?
I think. You said, have I ever used it?
Have you ever messaged him using that handle Thugger1?
Yeah, I think so.
Trontavious Stevens or Tick, did you ever IG him? Or excuse me, direct message him?
Yeah, I think so.
Okay. Do you recall what his Instagram handle was?
I don't remember by heart.
Have you ever heard of the handle _1slug?
Yeah, that probably was it.
Okay. Christian McMiller, did you ever direct message him on Instagram?
I'm not sure.
Okay. Have you ever direct message the Instagram OE5 or O5E and Drive Slim?
Ocean Drive Slim?
Yes.
Yeah.
Right. Was that Christian McMiller?
Yeah.
All right. Darius Ford, did you ever IG or direct message him on Instagram?
Yeah, I think so.
Okay. And was his Instagram at real1_FR?
Yeah.
Okay. And what about Demikion Garlington? Did you ever direct message him on Instagram?
From what I've seen in the indictment, yeah. But I don't remember his Instagram though.
Okay. And then Shannon Still, have you ever Instagram him or direct message him on Instagram? Excuse me.
Yes.
Okay. And do you recall sending here what his Instagram handle was?
Not by heart.
Okay. Have you ever IG'd him on an Instagram handle OG.BOOL?
Yeah, I think so.
Today, have you had the opportunity to look through or look at some of your Instagram records in preparation for your testimony today?
Yeah.
Permission to approach, Your Honor.
You may.
Or Mr. Chart.
This is intense, huh, y'all? This is tense. Cross been eating everybody up, so it wouldn't be a surprise if they eat him up just like everybody else.
I'm showing you what's been marked as 31 NN, 31 NNA, 30 NN, 30 NNA, 32 NN, 32 NNA, 33 NN, 33 NNA, 34 NN, 34 NNA, and 35 NNA. Are these the items that we went over today?
Yeah, you showed me that.
Okay. And were they the items associated with your Instagram account, SlimeLife.Shawty?
Yeah, from what these papers say.
Okay. And y'all, this time say what I did tender, Stacey did with 30 NN to 35 NNA, 30 NN and 30 NNA through 35 NN and 35 NNA into evidence.
Your Honor, may I approach briefly?
You may.
I think our approach counter is off. What are we up to now? This is at least 4. I think we've been off. Has there been any others that we missed? Ooh, y'all, it seems like he initially decided he was not going to be totally cooperative. And then very soon thereafter said, yeah, I'm going to cooperate. Yeah. Skip to the cross already. All right, so we're on 4 with the approaches. Poor little tink, huh? It's tough on him because he had, hold up, got a helicopter going overhead. I don't know if y'all can hear that. It's tough on him because he had to take the stand. Y'all know Gunna didn't have to take the stand. I don't know that there's anything she could have done, Lil Woody. I don't know that there's anything she could have done because she said Mr. Kokomo has looked at the tape and blah, blah, blah. Kokomo helped her out. He gave her the alley-oop. I think the problem was she just didn't have all of everything straight. She kept saying, well, I could be wrong. That was kind of where she let the judge off the hook when she kept saying, I could be wrong, I could be wrong, I could be wrong. If she had been more assertive from the jump, Mr. Lil Woody, I think I agree with you. It could have gone better for her if she had been assertive from the jump. Oh, you did hear the helicopter? Okay. But yeah, it's I would like to see his plea deal. How do you spell it? W-U-N Woony Lee plea deal. Let's see if we can find it. Anybody have a link for it? Let's see if Cat Not Williams, she normally has that kind of thing. Cat Not Williams normally has that kind of thing. And she would have posted it. Let's see. Cat, where's the plea deal? She would have it. Thugger Daily would have it. WUNNIELEE. Yeah, Miss Lily, if you have it, because we need to see what is he facing. Like, what is he up against? By the way, y'all do like the stream, please. Hit the like button. If you're not subscribed, do subscribe. If you want access to all of our fabulous emojis, you can become a member. Certainly would appreciate that. Just waiting to see if we can get. Come on, y'all. How is it that you get? How's it that I don't know what's going on with people with the like button? Yeah, I know he has an Alford plea, but my question, so with an Alford plea, is he facing any additional time? If he has a Alford plea, is he facing any additional time? That's my question.
You're on the state with like 10 to 30 and NNA through 35 and then an NNA into evidence.
All right, those are admitted without objection.
I'm going to approach again. And Ms. Westmoreland, we're getting ready to do that. I'm going to show you what's been marked as State's Exhibit 36 NN, 37 NN, 38 NN, and 39 NN.
I need to keep that.
Yes, you keep it. Did you see those earlier today as well?
Yeah.
Say no?
I said, yeah.
Okay. And first looking at 36 NN, do you recognize the people in that photo?
Yes.
And does that appear to be a fair and accurate depiction of the people who are in that photograph?
Yeah, I think so.
Now showing you 37 NN. Do you recognize the person that's inside of 37 NN?
Yeah.
Looking at 38 NN, do you recognize the person in 38 NN?
You said, do I recognize who?
The person standing next to you in 38 NN.
Yeah, I see him.
Okay. And does that appear to be a fair and accurate depiction of you and the person standing next to you in 38 NN?
Yeah.
And 39 NN, do you recognize the individuals in that photograph, 39 NN?
Yeah.
And how did you recognize? And excuse me, is that a fair and accurate depiction of the people inside of 39 NN?
Can you repeat that?
Does that look or appear to be a fair and accurate depiction of the individuals inside of 39 NN?
Yeah.
All right. Your Honor, this time the state would like to admit 36 through 39 NN.
Those are admitted.
And I'm going to first show you State's Exhibit 36 NN. Who is in this picture in 36 NN?
Me and Shannon.
Okay. And was this photo taken in October of 2020, or was this photo taken at a different time?
I don't know when it was taken. I just see when they posted.
All right. And earlier we talked about Instagram pages. Is this Mr. Stillwell's Instagram page?
I think so.
All right. And can you read for the jury what the caption says?
Fuck the other side. Put them on TV about my
Hold on.
dogs.
You got to slow down because the court reporter is taking it down.
Go ahead and read it. Just read it a little bit more slowly.
Fuck the other side. Put them on TVs about my dogs. Soldier reads bloody teeth, Glock with beam about my dogs. Cause a scene about my dogs.
I'm not kidding. Let me enhance
I'm going too fast.
Yes. Okay, go ahead. Slow it down. I
Where
know
you
you want
want
to
me to
wrap
go
it,
to?
but slow it down.
Where you want me to start at?
You can start from the beginning.
Say it again. F the other side. Put them on TVs about my dogs. Soldier reads bloody tees, Glocks with beams about my dogs. Clear the scene about my dog. If he F with them, you can't F with me. No, he is not my dog. That's it.
No, keep going. Keep reading the rest of it.
The rest of it is not my song.
Okay, so the first portion is your song.
Yeah.
All right. But I want you to read the rest of the post, though, for me.
Even if our position ever come down to being back to back, that's just how we're gonna rock out against whoever with you.
All right. And are there some hashtags?
No slime left behind.
All right. And is that an emoji next to that hashtag?
It looked like a crazy emoji. I never seen that.
Okay. What's the next hashtag?
2 B's.
Do you know what that signifies?
Big business.
All right. And what else does the rest of it say?
Many more blessings and riches, I say.
And is someone tagged?
I don't know who that is. Oh, that's somebody who made some clothes.
All right.
Real feel. I don't know who that is.
Okay. And what else does the rest of the post say for the record?
Thank you for this exclusive ass hat and for this crazy ass one of none hoodie.
And then someone else tagged.
Somebody named Marilyn is totally responsible.
Okay. And when was this post posted?
2020.
All right. Now, the verse that you quoted, your verse, what song is that from?
Dang, I forgot about it. For the sample. Dang, I don't even remember.
Okay.
I really don't. I think, is it What a Love at?
And was that a song that came out before 2020 or in 2020?
It probably came out in 2020.
Okay. And in looking at this picture, do you know where you and Mr. Stillwell were when you took it?
At the studio.
All right. And do you have a particular studio that you used to go to?
No,
Okay. Where was this studio located?
I can't remember by heart, but it looked like geez, I don't remember.
Okay.
Yeah, I don't think I remember.
All right, that's fine. Course indulgence for one moment. Ms. Westmoreland. Do you want to see it? What does no slime left behind mean?
I think that's just what it means. No slime left behind. Let me see.
I'm going to show you what's been marked as 37 in Admitted, excuse
Oh,
me.
that was my mixtape name. That's why he put the hashtag. He was supporting my mixtape.
Your mixtape was No Slime Left Behind.
Yes.
What made you name your mixtape No Slime Left Behind?
Like the No Child Left Behind thing. That's that, in school.
Okay.
I just named it that. No Slime Left Behind.
And when you were talking about slime, who were you? Were you referencing anyone particular?
No, not nobody in particular. No, I just wanted to be different. I just named it that.
I'm going to publish 37 NN. Who is in 37 NN?
OG Boo. OG Boo.
And who is that?
Shannon.
All right. And can you read for the jury the caption?
Read his caption.
Yes.
Said ain't nothing more compatible than a trench. A carbon while in the trenches.
And then is there a hashtag?
Hashtag no slime left behind. Hashtag 2Bs. Life size.
And is there another hashtag?
Free Quay.
Is there another hashtag on the screen?
Oh no.
Your Honor.
It's in this paper
Your
right here.
Honor.
You got me reading.
Your Honor, I have to make a motion.
All right, I'm going to excuse you.
I wasn't looking at the screen. I was looking at this paper.
That's fine, don't worry about it. Can I ask you to step outside for just a minute? And jury.
Anybody want to predict what this motion is going to be? Let's get some motion predictions. This is Miss Westmoreland, I believe, her voice. Haven't heard from her a lot. Anybody want to predict what Miss Westmoreland's motion is going to be?
Please, thank you.
Free. Is Miss Westmoreland's motion going to be the free Quay? Which Quay? Who does Miss Westmoreland represent? Is that Mr. Nichols? Is she back there, Mr. Nichols? Yo, this is a.
Your Honor, we're making a motion for mistrial on behalf of Mr. Nichols. We're not going to be able to unring this bell. Your Honor, this is the exact same issue that while we were at the bench, I brought it up. It was Exhibit 37NN that the hashtag, there was a hashtag on that exhibit that said free Quay, which would definitely indicate to the jury that Quay, has spent time in jail or in prison. The state agreed. We stipulated that they would redact it. And then the state presented, I guess, to the witness the unredacted version, didn't prep him to not comment on it, and he did. And Your Honor, before we had the opportunity for you to preside over us, this happened already again. And I made a motion for mistrial. Now it's happened again. So now the jury has repeatedly heard about Mr. Nichols being in jail, being in prison, and you cannot unring that bell. We would ask.
She gonna say they don't know which Quay it is.
Your Honor, Carter Matthews or Mr. Marquavius Huey, we join in that motion for mistrial. And what's important for this court to know is that 45 minutes ago, there had been a reference to a person being in jail. Now, this witness has identified Marquavius Huey and has also identified Marquavius Nichols. So all the state had to do was ask this honorable court for an opportunity to have this witness maybe step out of the courtroom and go over with that witness that, we don't need to say anything about someone in jail, what have you. That did not happen before. he went on the stand, nor after that first slip up by this witness. There may have even been a document right there on the witness stand that should have been pulled from the state of Georgia from that witness stand so that this could have been avoided. So, Your Honor, we are joining in that motion as well.
Oh, hang on. It's all right. You just didn't know, but we'll let you know when to come back in, okay?
So we join in that motion, Your Honor.
Your Honor, and I just want to briefly add that it is painfully obvious that the state is not prepping their witnesses. You can tell by the way when the witness spoke the first time and he said, oops, am I not supposed to say that? Like, oh, I had no idea, which makes it obvious that the state had not spoke to him, had not prepped them. And this has happened repeatedly. It's happening over and over again, Your Honor, and we're just not going to be able to unring 100 bells.
And finally, Your Honor, Mr. Marquavius Huey, we all have, it's been established that that his nickname is Quay.
Okay, isn't there going to be, I mean, we talked today about, isn't there going to be a stipulation that references to Quay, at least at some points, are not either Mr. Nichols or Mr. Huey? I mean, we did.
Yes, Your Honor, and that's a few things. So one, Your Honor, it was not intentional because we clearly.
Okay, but it was sloppy because I presume he's reading from the document that you handed him instead of reading from the screen.
And we should have instructed him to read from the screen, but.
Or you should have presented him with a document that had that part redacted. It's just sloppy.
The issue came while he was on the stand, Your Honor. So the issue did not come prior to. Ms. Westmoreland walked up to me while he was on the stand and said, I'm going to have an issue with that. Can you redact it? That is when the state became aware.
Then it should have occurred to you, you know what? I'm handing him a hard copy of this document that is unredacted.
But
I mean,
not if there's multiple Quays, Your Honor. If I don't know which Quay that.
Hang on. Can we stop having people come in and out when I've asked the witness to step out and every time the door opens, they can hear what we're talking about? Please, just for a few seconds. I'm not asking anybody who's in here to leave. God have mercy, y'all. Huh?
The state is in charge of the witness, and they're supposed to be guiding the witness to the room.
Who is talking now? Is that one of the bailiffs?
And so that is the point in which we learned of it is we redacted it on here. Ms. Westmoreland brought it up here.
Yeah,
and when
and you
I
didn't read that. I mean, so the
But I
jury
said-
didn't see it, but now the jury has heard it. I don't think it is really that, much of a crisis because there is going to be this stipulation that Quay is not always either of these defendants. So, nor is it obvious to everybody that free whomever is such a quote about who knows, everything these days. And so it doesn't necessarily indicate that whomever Quay spent time in jail or in custody or in prison or anything. I mean, they say it about, Hollywood stars who are in a breakup. It's not so obviously, oh, this must mean this person was in prison. But also we were already saying Quay isn't either of these people. So let's just, and whether this was one of these people or I don't even know who it did refer to.
And we don't know because it's not his post. He was reading someone else's post. So it could be a multitude of Quays.
You talked to his attorney earlier, right?
Yes.
And did you get any kind of an indication? I don't know if this was one of the things you were going to, but it's an issue now. And you said before lunch that you were going to ask Mr. Rubin.
Yes, we did ask.
Do you know at this point whether the free Quay referenced, this wasn't even his post, was it?
It wasn't. And there wasn't an issue until Mr. West. So when I talked to Mr. Rubin at lunchtime, this wasn't something I was going to address with him because it wasn't I did not realize it was an issue. Mr. Rubin found out for me that Slat Quay is not either of these two Quays.
Okay, but this isn't Slat Quay. This is just Quay.
Right.
I know. So why doesn't everybody, well, they don't know how it's spelled. They only heard it. Why doesn't everybody just enter into some sort of a stipulation that the free Quay or the reference to Quay just now isn't either of these people?
I don't know if it is, so it was.
Whether it, okay, so.
Your Honor, the state can enter stipulation that we weren't referencing any, we as the state of Georgia.
Okay, that is not a reference to, if you would prefer that.
I don't know what the poster is referencing.
I don't honestly really care what the poster was referencing. What I'm trying to do is fix your sloppiness so that everybody won't have wasted, 10, 12 months of their lives.
Sunk cost
on this
fallacy.
trial.
I told y'all. Told y'all yesterday.
Okay, do it now.
I told y'all yesterday, sunk cost fallacy.
Don't
Didn't I?
work on that. I'm going to take 5 minutes.
I told y'all yesterday this is the sunk cost fallacy, and she just said it so that everybody will not have wasted. That is the sunk cost fallacy I was talking about yesterday. That is the sunk cost fallacy that I was talking about yesterday. Excuse me. You see, she's trying to keep this trial. We all know it, okay? We all know it. So I'm not saying anything that everybody's not already totally clear on, okay? I'm not. Let me finish this poll in the poll. I'm not saying anything that y'all don't already know. That one it seemed close, y'all, but Judge Whitaker basically said, for me, she basically said right there, if you read between the lines, or it's a reasonable interpretation, not necessarily, but reading between the lines, look, we've been here for a year. I'm keeping this thing on the rails. I'm willing to eat. She even said, I'm fixing your sloppiness, y'all. So Andre, your point from this morning is taken. Again, I think both of our points from this morning are taken. You said that she's biased in favor of the state. I said she's biased in favor of this trial continuing to a jury verdict, and we're both right because the state is the one who is causing this trial to go off the rails. So she has to cover for the state because she wants that jury verdict. And the state is just, I said on Monday, I said before the end of next week, there's going to be another blow up. Here we are 2 days later. And there's another blow up. And this is a major one. Y'all. So, yeah, we've all said it. So, yes, exactly. This doesn't take a legal genius to see. Right? Oh, Cloud Babies, you just missed it. Since we're on a break, let's just go back real quick, Cloud Baby, so you can see this little bit. She said 5 minutes.
I didn't see it, but now the jury.
We'll go back a couple of minutes. What's happening here? Oh, my goodness. All right.
So obviously, this must mean this person was in prison. But also, we were already saying.
Cloud Babies, let me pause it. The witness, Wooney Lee, went on stand, and he 2 times referenced people having been in prison. First time, they let it slide. This is really the 4th time that this has happened in the past few days because the person 2 days ago, the gang expert said that Thug was living a life of crime. So she didn't say he had been in prison, but he was living a life of crime. They let that slide. Now today, Wooney Lee said somebody was in prison. They let that slide. I think it was Shannon. Shannon, he said, I don't have a relationship with Shannon because he's been locked up for the last few years. So they let that slide. That was today. Then he said, free somebody, free Quay. He read this caption on a Instagram post. And so Ms. Westmoreland rightfully calls for a mistrial. And Judge Whitaker's like, look, we've invested too much time in this trial for a mistrial now.
Quay isn't either of these people. So let's just,
And
whether this was one of these
Still is
people or I
quiet
don't even
because
know.
Still is quiet right now because this doesn't have to do directly with his client. Miss Westmoreland and Quay could either be Miss Westmoreland's client or Matthew's client. That's why Steele isn't talking. That's why Sharp
Who it
not
did
talking.
refer to.
And we don't know because it's not his post. He was reading someone else's post. So it could be a multitude of ways.
You talked to
Welcome.
his attorney
Yes.
earlier, right?
Yes.
And did you get any kind of an indication? I don't know if this
There
was
wasn't
one
an
of the
issue
things you
ear-
were going to, but it's an issue now. And you said before lunch that you were going to ask Mr. Rubin.
Yes, we did ask.
Do you know at this point whether the free Quay referenced, this wasn't even his post, was it?
It wasn't, and there wasn't an issue until Mr. West. So when I talked to Mr. Rubin at lunchtime, this wasn't something I was going to address with him because it wasn't I did not realize it was an issue. Mr. Rubin found out for me that Slat Quay is not either of these two Quays.
Okay, but this isn't Slack Quay. This is just Quay.
Right.
I know. So why doesn't everybody, well, they don't know how it's spelled. They only heard it. Why doesn't everybody just enter into some sort of a stipulation that the free Quay or the reference to Quay?
Y'all see this? Do y'all see how she's telling the defense to take an L? What she's saying is, let's just tell the jury that this Quay is neither one of the two Quays here in the courtroom. That's bad for the defense. One, because they arguably deserve a mistrial. And two, because this is yet another stipulation that now the jury is going to have to internalize and believe. Y'all see? And the only reason for the stipulation is to keep this daggone trial going. So really, it doesn't really, it benefits the defense if the trial's going to keep going, but really the trial shouldn't keep going. So this is
Ages now isn't either of these people.
I don't know if it is. So it was.
Whether it, okay, so.
Your Honor, the state can enter stipulation that we weren't referencing any. We as the state of Georgia.
Okay, that is not a reference to, if you would prefer that.
I don't know what the poster is referencing.
I don't honestly really care what the poster was referencing. What I'm trying to do is fix your sloppiness. So that everybody won't have wasted, 10, 12 months of their lives.
y'all, that right there to me, that she just said that on the record, and that is freaking dynamite for this. What I, the judge, am trying to do is fix the prosecution's sloppiness so that this trial can continue. Is that your job, Judge? Is your job to fix the prosecution's sloppiness so that the trial can continue? Y'all, she said it out of frustration, obviously. And everybody heard it. It's on tape. It's on the record. And I don't think that's her job. It's understandable, but I don't think that's her job. I don't think her job is to try to keep this trial on the rails. She literally just said, in other words, let's keep this trial on the rails. Right or wrong, y'all? I think she said it in no uncertain terms. I want to keep this trial on the rails. Now, we can commend that from a perspective of nobody wants to waste 12 months, but you can't commend it from the perspective of she's supposed to be neutral. She's not supposed to be fixing people's sloppiness. She's not supposed to be fixing people's sloppiness. I'm going to play that one more time, y'all, because this is going to go down in history. This is going to go down in history, y'all. When I say history, I mean the history of this trial. Name of the documentary, trying to she tried to fix their sloppiness or whatever. You know what I'm saying? I don't think that this is what she's supposed to do. Somebody correct me if I'm wrong. I'm going to play that little clip one more time.
Mr. Rubin.
Yes, we did ask.
Do you know at this point whether the free Quay referenced, this wasn't even his post, was it?
It wasn't, and there wasn't an issue until Mr. West. So when I talked to Mr. Rubin at lunchtime, this wasn't something I was going to address with him because it wasn't I did not realize it was an issue.
I did not realize. So this goes to what I was saying earlier, that no human can understand this trial. No human. What did I mean by that? I'm saying there's so many moving parts. There's so many defendants. There's so many charges. There's so many pieces of evidence. There's so many witnesses. There's so many everything, that you get this thing and you don't even think about the free Quay part. You don't see it. I'm not making an excuse for Hilton. I'm saying, like, it's ununderstandable in this minute details. So she said I didn't think, but then she's like, I didn't even realize it. Oh, hold up, I went back too far. Let me see.
When I talked to Mr. Rubin at lunchtime, this wasn't something I was going to address with him because it wasn't I did not realize it wasn't.
I did not realize.
Rubin found out for me that Slat Quay is not either of these two Quays.
Okay, but this isn't Slat Quay. This is just Quay.
Right.
I know. So why doesn't everybody, well, they don't know how it's spelled. They only heard it. Why doesn't everybody just enter into some sort of a stipulation that the free Quay?
So why doesn't the defense why don't y'all help the prosecute? Y'all need to understand this question or this kind of suggestion. She's telling the defense, why don't y'all just chill out? Don't worry about this mistrial because I'm not giving it to you. So instead, why don't we just try to limit the damage for what the prosecution just did to your client? That's what she just said.
Or the reference to Quay just now isn't either of these people.
Exactly, LTK.
I don't know if it is. So it was.
Whether it, okay, so.
Your Honor, the state can enter stipulation that we weren't referencing any. We, as the state of Georgia.
Okay, that is not a reference to, if you would prefer that.
I don't know what the poster is referencing.
I don't honestly really care what the poster was referencing. What I'm trying to do is fix your sloppiness so that everybody won't have wasted, 10, 12 months of their lives in this trial.
She probably said that and she was like, oops, shouldn't have said that. Y'all, trial's still not back, FYI. In case y'all wondering. She probably said, oops, should not have let that one out. I'm trying to fix your sloppiness so that this trial can continue. Because frankly, the only thing that the defense wants is for the trial to be over and for their guys to be free without risk of going to jail. If that happened today, they would be happy, right? They don't want to continue. They don't want to continue. You know what? I hate to say it, Miss Lily, but seriously, that would be tough. That would be tough, but it might, that would be hardball. That would be hardball, Miss Lily. I hadn't even thought of that. Y'all, I'm gonna go with a poll. Everybody, this is the new poll. Now, should the defense file a recusal motion for Judge Whitaker? Now, please, y'all. I know how y'all are. I'm not asking you, do you want Whitaker gone? Matter of fact, I'm gonna reword this. Would it be good strategy to file a Whitaker recusal motion? I'm asking you, would it be good strategy? I'm not asking you. I was going to say, should they or shouldn't they? I got rid of that question. So forget the should they, shouldn't they question. Doesn't matter if they should or shouldn't. Well, the should or shouldn't is only would it be good strategy? We want to think about strategy, okay? Or should they stick with Whitaker? Remember, if they file a recusal motion, they're gonna get a new judge anyway. If they file a recusal motion, they're gonna get a new judge anyway. So should they stick with Whitaker, or should they try to get another new judge? This is not a mistrial motion. Should they try to get rid of Whitaker, or should they stick with her? That's really the question. Strategy-wise, keeping in mind that their ultimate strategy is to get all these guys off of all the charges. Keeper and appeal. Miss Lely, you just sent me down this path of, I hadn't even thought about recusal. A new judge won't fix it. We need her gone. Okay, again, Andre. See, our air is saying new judge won't fix it, so strategy-wise, it's not a good idea because you'll just get another judge, and it could make things worse. Andre, you said that we need Whitaker gone, but is it good strategy to get her gone? Okay, not knowing what the next judge will do, not knowing who it'll be, not knowing what their style will be. As we can see between Glanville and Whitaker, there are much different styles between two judges. No, because that can bite the defense in the butt if the motion is denied. Yeah, if she is not recused, you have to wonder, does she remain impartial? I mean, you would be going at her directly. 10 to 12 months. What about defendant's life? Thank you. Thank you. I don't know if they're going to make something out of this, but I feel like strategically, if they wanted to, they could. I feel like strategically, that outburst, I'm trying to fix your mistakes so that we won't have all wasted this time. I feel like you could pair that up with previous rulings and make a case. Now, would it be successful? I don't know. But I feel like it's a reasonable case that you could make for recusal, but is it strategically a good idea? Ashley says, get her out of there. Y'all, give me more than just the yes or no in the comments. The yes or no will go onto the poll. Give me some rationale. Get her out of there. Why? Because another judge would probably be better, because no other judge would want to take this, and this case would just fall out and be dismissed because all the other judges will say no. Get her. Don't just say because she's doing a bad job, okay? Strategically, you're taking a gamble if you request a recusal because you might not get it, one, and if you do get it, you never know who's going to be the next judge or what their disposition is. So give me more than just a yes or no in the comments, please. Let's see here. It's the judge's job to prevent a mistrial. It's her job to find legal solutions to keep the trial moving forward. I see what you're saying, but I don't know if I would word it that way. I think it's a judge's job to prevent a mistrial. I would agree with that, as in give instructions and keep the court under control. I agree with that part. And I think Whitaker's been trying to do the proactive preventative part. But I don't think with this conversation, if you're saying it's their job to avoid a mistrial, even when one seems to be the correct, I don't agree with that part. I don't even agree with the idea that, if you can find another way out besides mistrial, you need to take it, because that other way out might prejudice. And plus there's a cumulative effect where you found so many ways out to keep the trial going. The defendant's best interest is for the trial to be over. So the more times you find a way out of a mistrial, cumulatively, you may prejudice the defendant. So while I get where you're coming from, and on some level I agree with you, I don't agree with you overall on this. So I would depart from the spirit of what you're saying a bit. I can see on our poll, we have 54% no so far, but we're going to keep the poll open. Gemini Rising says, keep her and appeal. Miss Lely says, yes. Miss Lely, give me some rationale, please. Andre, we need a fair and impartial judge. But the thing is, do you know for sure that there exists one of them in the Fulton County Superior Court system? And if that person does or does not exist, if they do exist, if there are multiple of them, they have a randomized situation, a randomized judge selection process. So how do you know you'll get that person? I don't think she's doing a great job, Howard. Strategically, I would argue no recusal. All right, we're back. All right, come on, baby. Okay, we don't have any sound yet. There's no sound on in the courtroom for the moment. She looks mighty relaxed, though. All right, so I'm going to go ahead and end the poll now. Would it be good strategy to file a Whitaker recusal motion? The majority says no. The majority says it's not good strategy to file a Whitaker recusal motion. What is going on with my talking? Majority says no. Sound is off in the courtroom. The sound is off in the courtroom. It's not us. Recuse her based on her own admission. Okay, you get rid of her queen, and then what? And then you get somebody else. You never know who would be. I feel like some of y'all are like, you just want her gone or you want to punish her, but you have to think about your clients. Oh, thank you for this Nintendosa. The movie characters, Tyler Perry would be Glanville, Ben Stiller would be Steele, Lisa Ray would be Love. Okay, Keke Palmer, Hilton, and T.I. Oh, that's where you lost me. T.I. playing Lil Woody. You lost. I was riding with everything you said till you said T.I. 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 is too old to play Lil Woody.
Maybe I'll come up with.
All right, wait, hold on, Matthews. Before you say we have a stipulation, F, Judge, once you ruled on our mistrial,
Right.
on my motion for a mistrial.
Okay, so are you asking, what kind of a mistrial are you asking for?
Your Honor, I believe that we were goaded into the mistrial.
Okay, well, I do not believe that, because if you had seen Miss Hilton's face when that came out of the witness's mouth, she was appalled. And I do not believe that they are purposefully trying to insert error into this trial to make y'all ask for a mistrial so that they can try this case again. I think it is continued, and I am sorry, y'all have, this gigantic, ginormous universe of evidence that maybe if you narrowed down, you would not be making these kinds of mistakes. But I believe that to be a mistake.
Your Honor,
so I'm going to deny a motion for a mistrial with prejudice. That one, I don't believe that the facts bear out. Would you like a mistrial without prejudice?
Dun, dun, dun. Dun, dun, dun. Huddle.
Yes.
You would?
Huddle.
Who else would? That means, of course, that the state would be free to try every one of y'all again.
Huddle. She's calling their,
Just a moment.
She's calling their bluff, y'all. Oh, this is dramatic. She's calling their bluff now. Oh, she on her high horse, y'all. Call her bluff back. Say, yeah, we want a mistrial without prejudice. Oh, snap, y'all. Yeah, thank you. Oh, how did nobody? I'm riding on that one. I'm riding on that one. I got to ride on that one. Definitely. Y'all, oh, she just called their bluff. And I think she's right. I mean, did they goad the defense? No. They didn't do that on purpose, y'all. They didn't do that on purpose. The prosecution is disorganized and I don't want to say overwhelmed, but definitely not on top of their game. So they did not goad them. Goading would have been purposeful. So they didn't goad them into the mistrial motion. So I agree with that. But could this be a mistrial without prejudice? I think so. I think it's cumulative. I think everything that's happened and correct, the state could call this. They could bring this trial again. They probably would. But Gemini Rising, thank you for the $1.99 super chat, I believe. Hold on, let me show you. I guess you had stepped away. I'm about to show you.
Your Honor, I believe that we were goaded into the mistrial.
Okay, well, I do not believe that because if you had seen Miss Hilton's face when that came out of the witness's mouth, she was appalled.
So Gemini Rising, Judge Whitaker just said, I'm certainly not going to give you the kind of mistrial where the state is barred, prevented, prohibited from bringing this trial back. I'm not going to call a mistrial such that this trial can never be called back. Then she says this.
Believe that they are purposefully trying to insert error into this trial to make y'all ask for a mistrial so that they can try this case again. I think it is continued, and I am sorry, y'all have, this gigantic, ginormous universe of evidence that maybe if you narrowed down, you would not be making these kinds of mistakes, but I believe that to be a mistake.
Your Honor,
so I'm going to deny a motion for a mistrial with prejudice.
Okay, so with prejudice means prejudged. Prejudged in this sense means I have prejudged that this situation is done, is over. My judgment will be that you can't bring this trial back up to the prosecution. It'll be a wrap, basically. That's what she said. She's not giving that.
I don't believe that the facts bear out. Would you like a mistrial without prejudice?
So this is where Whitaker is kind of calling their bluff, and now they might have to call her bluff back. She said, would you like a mistrial without prejudice? Meaning this will be over today as of right now, or as of my ruling, whenever my ruling comes down, that yes, we'll grant the mistrial, but the prosecution can file again. Now, many people have said due to speedy trial conditions, Thug might not be able to be tried again. I have not independently verified that, so I'm not going to stamp that, okay? Oh, the mistrial is on. Okay, the mistrial is on the table in the first place, Gemini. I thought you were here. I thought you were riding with us through this. Okay. First, let me just flash you back to Detective Dennis. Detective Dennis was barred from the case because he mentioned Yak Gotti's prison. He was just coming out of prison. That got Detective Dennis knocked out of the case. You can't mention that except under certain circumstances that were not met. Fast forward to Monday. There was a witness who said that Thug was living a life of crime, a felony life. Even though he never went to prison, she said he was living that felon life. There was a motion at that time, I believe, by Brian Steele. That was denied. It was the same kind of thing that Dennis did. Now our gang expert who replaced Dennis said something similar, but motion denied. Fast forward to today. They bring up an artist, SlimeLife Shawty, Wooney Lee, and he mentions that he has not had a relationship with Shannon because Shannon's been in jail or prison for a while. And everybody's like, oh, here we go again. But nobody called for a motion for mistrial at that point. The judge said, look, just keep it moving. None of the lawyers called for a mistrial. Then as the trial developed with the same witness, SlimeLife Shawty, he's reading an Instagram caption, and one of the things says free Quay. Now, there are two Quays in the courtroom. Don't ask me to tell you their names. Mr. Nichols, Mr. Harvey. They're both Quay Marvius or something like that. So that is where Mr. Nichols, Quay Nichols, his attorney, Miss Westmoreland, calls for a motion for a mistrial. So that is what prompted it, because this, according to Miss Westmoreland, and what we've just seen over the past several days, this keeps happening. Okay? So prison was mentioned twice today by the same witness. One, that Shannon is in prison. I don't think they made a big deal out of it because, again, Shannon is also charged as a felon in possession of a gun. I think they realized from the Detective Dennis situation that you're not going to get a mistrial for that because they're going to find out that Shannon, has been in prison either way. But Mr. Nichols, presumably, is not charged with that. I don't have the indictment in front of me. But yeah, so there were two of those within about 45 minutes by the same witness. And so the judge has just said, well, look, you're not getting a mistrial with prejudice. It doesn't look like something that they've done on purpose. But do you want a mistrial without prejudice? Okay. All right. Could Thug get... Oh, so we're waiting as of this. Let me just finish this up. We are waiting to see if the defense is going. So that's why I said huddle. They need to all get together and talk about this. And it might just be that time. It might be just that time that they call her bluff and say, yeah, we do want a mistrial without prejudice. We'll start this thing over. Binks and Ethan. Are those the two cats? Or is that a bird? There's a cat. Anyway, could Thug give bail if mistrial is granted? You'd imagine at least that with the given context of the trial and how long he's already been in jail. I'll be honest with you. I don't know what would happen with Thug if this is granted a mistrial. I've heard many sources say that Thug cannot be retried due to speedy trial. If that's the case, Thug would just be free. I'm not stamping that, though. I'm not stamping that. Also, I would imagine if this is called a mistrial, this is a good question. We have to look into this, y'all, because if it's a mistrial, I'd imagine they'd have to free all the guys until they refile the charges. They might just refile them right away, same day. But it does seem like they would have to, if it's a mistrial, seems like they should just get to go home right away. Because they wouldn't have any, unless they have other open charges for another case. So I would think if they grant a mistrial, if you don't have any existing charges for another case, and this isn't the case anymore, I'd imagine you just go home unless there's some kind of trick that the prosecution could pull last second. So any of the guys who are not facing charges from another type of case might just get to go home. Honestly. Gemini Rising, thank you for the super chats. Definitely do appreciate them, y'all. Definitely do appreciate them. So back to this question here. This is a really good question. And I definitely do think that some of them will probably go home today if this is called a mistrial without prejudice. Some of the guys may be facing other charges who are not currently, they might be on trial for this, but they might have something else out there that might keep them in prison. But you would imagine if they call a mistrial, there would be some kind of process to refile. I don't think the prosecution could do that same day. Not in any, no, because they'd have to do some kind of work. So yeah, I would imagine that whoever doesn't have a trial, a pending case, they would have to be free. They would have to be free. No, they don't have to release anyone. Explain that, Dandelion Bees. If this is a mistrial and this trial is over and you don't have any other pending charges, they would hold you based on what? They would hold you based on what? Yes, because it's been more than 180 days. Isn't YNW jelly? He's facing trial though, I believe. Call her bluff. Yeah, it would be without prejudice, Hair Alchemist. No, they won't free them. They meet the requirements for no bail. Again, y'all, if it's a mistrial, this trial is over. So, you know what? I'm going to chat GPT it. If a trial ends in mistrial without prejudice in Georgia, do the defendants go free that day? We're going to chat GPT this one, y'all, because I'll be honest with you. This is a learning experience for me as well. And we're going to see. Whether or not defendant is released that day depends on the defendant's bail or bond status. If the defendant was out on bond before the trial, they might remain free under the same bond conditions. However, if the defendant was in custody before trial, they will likely remain in custody unless a new bond is set or they are otherwise granted release by the judge. Okay, so according to GPT, y'all, all right, according to GPT, they could potentially remain in custody. According to GPT, they would have to get granted bond by the judge. I don't know why, but how is that? How is that? Is it because the indictment is still open? After mistrial, the case is usually retried at a later date, but it can also be resolved through a pre-doc. I get that part. That's, yeah, of course. After, but it would seem to me that they would have to. So let me say, does the original indictment remain valid? Or does the prosecution need a new indictment? All right, so let's see. When a trial ends in mistrial without prejudice, the thing is that the original indictment remains valid. That's the problem. I thought that they would have to start all over from scratch, but it's not that way in Georgia. The original indictment remains valid, so therefore they can stay locked up. Wouldn't you have to think, though, that a judge would likely be more amenable to releasing them on bond when there was a mistrial due to prosecutorial or due to the prosecutor's case? I mean, this is not a situation where, a juror did something wrong and they have to call a mistrial due to, one of the jurors having done this or that, something out of control of the prosecution. You know what I mean? Let's see. Testing the membership link. Yes, that membership link does work. I am going to have to put that into. Thank you so much, Amy. That does work. I'm going to make a banner out of that. I am going to make a banner out of that. All right. I'm going to put that on our banner. Okay. Go back to the chat. Yet another super chat. People are saying no because Melly, I think those aren't comparable. Thug isn't directly accused of violent behavior. I think bail is likely. Again, this is one of the things where I'm not going to stamp this, but a lot of people have said, and they've said it pretty authoritatively, that Thug would, in this case, due to his speedy trial petition that he would not have to face any new trials if there's a mistrial, even without prejudice granted. That remains to be seen. So thank you again for the new super chat. I definitely appreciate it. So they say Thug would not be able to be tried again. Also correct. A judge can set a bond or whatever they want to do. So we'd have to see what would happen next. I've had this on pause, but we were not back the whole time. I would have to see what would happen next. But can I ask y'all a question? Does the fact that Whitaker ruled out the mistrial with prejudice and then asked about the other mistrial, does that indicate that she's willing to give them that? Because wouldn't it be kind of weird for her to say, I'm not going to give you this mistrial. Do you want to ask for the other one? And then they say yes. And she say, well, you can't have that one either. You know what I'm saying? Alec Baldwin was with prejudice, correct. I did read that the prosecutor appealed that, though. I don't know whatever came of that. I didn't keep up with that. But yes, Alec Baldwin got a mistrial with prejudice. GPT, y'all do use ChatGPT. You cannot trust its information 100%. This is where, honestly, y'all, this is where legal training would help, because it helps you formulate the questions to ask. You don't know all the answers. Nobody knows all the answers. But having some legal background helps you know how to formulate a question. And also in something like ChatGPT, it helps give you a sense when it's giving you information that's just totally wrong. You can say, oh, no, I don't. Like, I've actually gone back and forth on questions with ChatGPT because I could tell that it wasn't giving me the right information. But it really does. Usually, if you know how to ask the questions, it usually does give you really good information. Here we go with the Diddy talk. Bro, mistrial has to be granted because this cannot be cured, and prosecution did it on purpose. So, Andre, she already ruled out doing it on purpose. Okay, so as a legal ruling, it's already ruled on. And she ruled that they did not do it on purpose, or else she would have granted a mistrial with prejudice. So she said, did you see Hilton's face? She took that into account, right? So Hilton was surprised. It wasn't on purpose. So the mistrial with prejudice is off the table. Mistrial without prejudice seems to be on the table, but we don't know. It seems like a bit of brinksmanship that's happening right now. Take the mistrial and they will all go back to jail until they have a bond hearing. They're in jail anyway. I say take it. I say go for it. I say go for it. Because they're in jail anyway. It's not like they aren't in jail. They're in jail. They're going to be in jail for the next 6 months. As long as this trial is going on, which is, estimated to be, let's say, 4 to 6 months. She messed up. That would be Hilton. Who messed up? This mistrial thing is not about the judge. Definitely she messed up when she said she's trying to keep this trial on the rails and fix the prosecution's error. The defense listen, y'all. They have 2 really strong directions they could go. They could go for recusal. They could go for mistrial. They're talking about it. I believe right now they're in a powwow about it. It would seem like a major missed opportunity to not do anything with this besides say, can you give this witness a stipulation or the jury a stipulation? So I think we got another super chat. Binks and Ethan, the judge who denied bond originally was recused, so wouldn't that automatically grant a new bail? I would think they could certainly ask for a new hearing regardless of that point, just due to the fact that this is going to grant a mistrial. You're talking about starting from day one. You're talking about this trial has been going on for 2 years. They've been in jail for 2 years. So if the new trial were going to be streamlined and only take a year, you're talking about waiting for that trial to start, which would be X number of months, and then running the trial, which would be another 12 months. You're already penalizing these people. They've already been penalized and they haven't been found guilty. So I think regardless of the fact that Glanville was recused, they should get a new hearing just based on the fact there is a mistrial granted, if that's what we see today. What do y'all think would have happened if they would have just said yes? Like, she seemed irritated. She seemed to be calling their bluff. Who knows what's happening right now, but that seemed to be a moment. Do y'all get the sense, like I do, that that moment, whatever that was that happened right then, that moment, like the intensity is going down now? I feel like the intensity of the moment is going down now. Danny, I agree, too many mishaps, but another thing we know, without a doubt, I said it on Monday, there will be another blow up before next Friday. I said 2 days ago that within the next 2 weeks, within the next 10 trial days, there'll be another blow up. Now, I'm not saying this like I'm some kind of soothsayer. Anybody could have predicted this because that's the way this trial has been going. But my point is, there will be another blow up within the next 2 weeks, most likely. This is just going to keep happening. They will have another opportunity, but this might be their best one recently. This might be their best one recently. This is probably why she hasn't called a mistrial, because she's unwilling to give it with prejudice. She said it. She said it, Queen. She said, I'm trying to fix your mistake because we don't want to have wasted 10 to 12 months. And she wasn't even on the case until August. So she's been on the case, 3 months? August, September. She's been on the case not even 3 months. Let's say about 3 months. Let's just round it up. She's been on the case 3 months, and she's trying to protect them from having wasted 10, 12, whatever months. For the defendants, it's been years at this point. Do you think some of the jury are planted or paid off? I was saying earlier, Miss Lely, I don't think so. I think that if they found out that were the case, that they were planted by the government, that's pitchfork. That's pitchfork and bonfire level stuff. That's like massive protests with tens of thousands of people in the streets type stuff. If the government were to plant or pay off jurors to try to get a particular verdict, that's unimaginably bad. So I would say I hope not. I don't have any reason to believe they are. I hope not. I don't have any reason. Whitaker already said they can't try them again if this trial ends in mistrial by prosecutors. I would like for you to give me a citation for that. I don't remember her saying that, but it's possible she did. I just don't remember. I would take it. We in jail anyway. Again, did she offer it? Andre, I don't think so much she offered it as she offered them the opportunity to request it. She could still deny it. And that would be very strange for her to offer the opportunity to request something that she's not going to give them anyway. But stranger things have happened. Is that the only way to get away with? Is that the only way to get it with prejudice? The way you get it with prejudice, the most straightforward way, is goading. Goading means they provoked me. That means they goaded me. It means they did something or some things to me or in this trial because they wanted me to ask for a mistrial, or you could even maybe use the word forced. But so yes, for the defense to get a mistrial with prejudice, they're going to need to show or convince the judge that the prosecution forced them to ask for it, goaded them into it, taunted them into it, Taunting might not be a strong enough word, but provoke them into it. So Whitaker's already ruled that out. Go back and show us Hilton face. I don't think we can't remember. We're only seeing Hilton from the back. We're seeing Hilton from behind. Oh, let's see. Let's see if we can. Oh, let's see.
It's all right. It's you just didn't know, but we'll let you know when to come back in.
2020.
All right. Now, the verse that
Hashtag 2Bs. Life size.
and is there another hashtag?
Free Quay.
Hold up. Hold up. Okay, y'all. Let's take a look at the screen. Thank you for that, Ashley. It's a very good suggestion. So we can't see Hilton, but we do hear her say whoop. So we do hear like a whoop. If you listen, she does say whoop, which sounds like she was surprised. It sounds like she was gonna say, no, don't say that.
Hashtag no slime left behind. Hashtag 2Bs. Life size.
Okay, now before he says this, y'all, we can see that it looks like right here. I don't know. Can y'all see I don't know if you can see my mouse. Hold on. Let me move this. Y'all can't see it. Okay, now you can see it. I don't know if y'all can see my mouse, but right here at the bottom, it says size, S-I-Z-E. And in the caption, it says size. And it looks like something was redacted there. I'm pretty sure it was between the size and the little green, looks like a lizard or something. So something was taken out there. That's probably what he's reading. So this is on the screen. We can't see it. So they redacted it on the screen apparently. But they must have handed him something in his hand without it being redacted. Y'all follow me? Well, yeah, she tells him to keep going because on the screen, there's another one that says book and riches. So she's thinking he's about to read book and riches because that's the next thing after 2Bs on the screen. But in his hand, he has an unredacted copy, which also has free quay. We don't see what he has in his hand. We see the screen. The screen does not have free quay. That's removed. But apparently he's reading from a paper that they did not redact, and it has free quay. Then it has book and riches. You see? So we're not going to see Hilton's face, but we will her say, whoop, like, come on, you know. That was on purpose. Then I know she checked the paper for again. It's just massive. I don't want to say incompetence or whatever, but whatever it is. So let's listen.
And is there another hashtag?
Free Quay.
Is there another hashtag on the screen?
See? Is there another hashtag on the screen? We can't tell, Lindsay. And I'm not saying that to dispute you. I'm just saying at this point, with the do y'all feel me? You just don't even know at this point. You don't. There's no. I mean, you just don't know. You don't. I mean, it's like they have so many problems. You know, I'm talking to a family member about this, and I'm like, yeah, you know, I'm actually streaming this YSL trial live all day, every day. He's like, why do people watch that? And I'm like, dude, because it's just so wild. Most people most people are. I was like, you know what? Young Thug is not even a character in his own movie. The characters in this trial is not Young Thug. Young Thug is like, he doesn't have a speaking part in the whole movie. In the trial part of the movie, you know, it's the prosecutors, it's the judge, it's some of the witnesses, you know, those are the people who are like the main characters in this movie. Cammie, thank you so much. I missed it. Can you give me 30-second rundown of what happened, please? Yes, I will. Anybody who joined the stream, I'm about to show you. Matter of fact, I'm gonna show you because we're right there. Hold up. Let me just back up. Hold
So
up.
ain't nothing more compatible than a trench.
Listen.
A carbon while in the trenches.
Listen.
And then is there a hashtag?
Hashtag no slime left behind. Hashtag 2Bs. Life size.
Okay, so he just read the captions that you see at the bottom. There's one missing from the screen that we can't see because we're looking at the screen, but he has a paper in his hand where this hashtag is not missing. So when Hilton asks him to read the next hashtag, which I'm about to play, she thinks he's going to say book and riches because she's looking at the screen. He's going to say free Quay because on his paper, the one that they removed from the version that we see on the screen is still on the paper. When he says free Quay, that implicates, according to Ms. Westmoreland, who is Quay's attorney, that indicates that Quay either is or was locked up, which is bad character evidence, which is a reason for a mistrial. So let's listen.
And is there another hashtag?
Free Quay.
She knew it.
Is there another hashtag on the screen?
See? So she says there another hashtag. He's not looking at the screen. He's looking at a paper that she gave him. So Cammie Phillips, that right there resulted in Miss Westmoreland saying she wants to make a motion.
That his nickname is Quay.
Mr. Matthews, who also has a client named Quay, joins in the motion for a mistrial. They both have a client whose nickname is Quay. So they both have a reason to request a mistrial when this witness, who's Wooney Lee, who is a recording artist, SlimeLife Shawty, he's on the stand. He's the one who was just reading. When he says hashtag free Quay, at the prompting of Hilton, who for some reason forgot or didn't realize she gave him an unredacted version of the Instagram post to read. So he reads the free Quay. We get a motion from Ms. Westmoreland, whose client's name is Quay, for a mistrial. She's joined by Mr. Matthews, whose client is also named Quay. It's another Quay. We have two Quays on trial right now. They both ask for mistrial. Judge Whitaker says, I'm not giving you a mistrial with prejudice. Would you like to request a mistrial without prejudice? Which means that the trial can be brought up again by the prosecution. We've investigated it. I thought originally that the guys would probably get out of prison, but it turns out the new trial would be brought under the same indictment, most likely, or it could. So they would have to stay in prison unless a judge lets them out, but they wouldn't automatically get out of prison. So right now, Judge Whitaker has denied a mistrial with prejudice, but she's asked the defense, would you like to request a mistrial without prejudice? Kind of insinuating that she may be willing to grant that. She didn't say she would, but the question itself seems to indicate that she sees at least some basis for it. So they called a huddle, and they've been in huddle for the last 30 minutes or something like that. And we just been talking about it. They've been in huddle they've been in huddle for, I don't know, quite some time at this point. So Cammie, that's more than 30 seconds, but that's a complete rundown. I think we got another. Clizzle, thank you. Admitting you're not granting a mistrial because of wasting money and admitting to help the state. It's not fair. It's not fair, y'all. That's not fair. Okay? So I'm not saying it's fair. Carl Dorsey, that's a major super sticker. Want to definitely thank you, Carl Dorsey. Are you there? Big thanks, big thanks, big thanks. We're still not back, but I do see some head movement here. Yeah, major key alert. I thought I saw a comment from Carl Dorsey. Oh my gosh, we on the map. We big time now. Yeah, I was looking for a CA or something. I'm like, is this Canadian money? You know, is this like 500, you know, Indonesian ruble? You know what I'm saying? Oh man, this is excellent. I'm gonna have to, Carl. I'm gonna have to give you the stream sponsor. I'm gonna have to put you into the banner along the bottom. Let me go ahead and do that. Appreciate it. Oh my gosh. Thank y'all so much. This is excellent. Let me screenshot this. I'm gonna have to send it to my wife. I'm gonna do a screenshot and send it to my wife. Let her know that people are appreciating. Let's just do the full screen. All right, cool. Carl Dorsey, shoot a message so we can communicate. I mean, I don't even know what to say. That's next level stuff right there. Let me go ahead and put Carl in this as a stream sponsor. I'm gonna put you there too, Clizzle, because you always come with the sponsorships every single day. Help me get some ramen for my kids. You help me get some ramen. Yesterday we got some crab legs. Yesterday we got some crab legs thanks to Clizzles. All right, y'all. So we still aren't back. I thank y'all for thanking me for appreciating this. Y'all, he refunds it. Hopefully not. Y'all know I'm relatively new to this, but I like talking. I like talking. I appreciate y'all. Now we can hear your. Is that music videos? Oh, y'all gonna hear next time you hear my. Thanks to Carl. Next time y'all hear my plate is gonna be a ribeye. It's not gonna be some bacon and eggs. It's gonna be a ribeye. Thank you. That's crazy, y'all. I don't even know what to say. I'm gonna just leave that up for a while. Y'all don't get upset with me, but we're just gonna leave that up for a little while. So what we're doing is we're just waiting to see what happens when we come back, y'all. We're just waiting to see what happens when we come back. We're just waiting to see what happens when we come back. Check Thugger Daily. You know, okay, y'all check Thugger. Let's go to Thugger Daily real quick. Let's go to Thugger Daily real quick. Whitaker makes it clear there's no chance of mistrial with prejudice, but leaves a possible. Yeah, this is what we already know. Yeah, this is what we already know. We knew it was going to be a huddle. Well, I said they should huddle, but it's kind of clear because she didn't want to just ask for that mistrial with prejudice. Y'all, the reason they huddled up, she didn't want to just do a mistrial with prejudice and get that granted. Then that kind of throws everybody else under the bus. So if y'all remember this morning, how I was saying these guys are out for themselves. Again, that's my take, right? But I wasn't 100% correct because she huddled up with everybody. If it was just for her client and she determined this is best for my client, she would have just spoken. But I'm imagining the reason she huddled was because if she says yes and then that mistrial is granted, that's going to affect everybody. Plus, she might have wanted to get some advice on strategy too, right? Or whatever. But so it shows that they aren't necessarily just in it for themselves. The fact that this is, so again, before we go, I don't know how to thank anybody for this. Carl, appreciate it. Reach out to me on X, on Twitter. Matter of fact, y'all, if you're not following us on Twitter, we've been growing, but reach out to us, okay? Making sure we live, making sure we got volume. All right, we good. All right, let's keep going, y'all. Let's keep going. I can't even imagine how the guys are feeling right now. Butterflies in their stomach, I imagine. My exact face. Did you get your page fixed, Miss Sylvia? Did you get your page fixed with well, I'm not Miss Sylvia. I got a strike not yesterday, day before. I got a strike day before due to the song. And yes, it did give a strike due to the visuals as well. But that was 2 days ago. I was struck based on both. I didn't mute. I didn't have enough to mute, so I got struck for both. But I did get struck both based on visuals and audio. Jim Crow comes to mind. God made Carl made God. Y'all listen. That is amazing. I can't wait to show my wife that. She's gonna go crazy. Y'all don't know this, but I'm home alone. Well, not alone. I got my daughters here. They're at school right now, but she's not. My wife will be back tomorrow, hopefully. Keep watching the stream, bro. Look, man, I'm telling you, I got a computer right here. Literally, I have a whole nother. I'm running 3 computers. I'm watching y'all on one. I have a laptop in front of me with the trial on, and I have a whole new computer that I bought like 2 weeks ago over here with the trial on. So we ain't missing it. Trust that. They in the huddle licking fingers to turn the pages. Yeah. I agree. If mistrial doesn't happen, I hope she dismisses the witness and strikes from the record and sanctions and censures the state. You want the jury to know about this. You want the jury to know about this. Hot Boy said, read the replies. The replies to what? I thought the Hot Boy said, what replies, Hot Boy? I saw you say that, but I wasn't sure what replies you're talking about. I thought you just meant the chat. So if I'm not reading the right thing, let me know. What replies am I supposed to be reading? Time is a factor. Jury selection would take too long. Many people have said that about Thug, that they can't get him with the new trial. I don't know. They're working together for strategy. Yes. This is taking longer than I thought. This is a mess. Correct. Head movement. That reminds me of Ronda Rousey. Remember my Twitter password. I can't remember my Twitter password. Password reset. No. Going to prolonged jail time. That's a risk. That's a risk. That is a risk. Wow, so they struck you. Appeal it. I did. Well, I didn't appeal it. I muted and cut out those segments. But that literally took, because of the slowness of the YouTube system, and there were 3 of them I had to do. And every time I cut something, it would process, and that process took hours and hours for each cut. I didn't even get to finish cutting that stuff until the following morning. So I got the strike after the stream. I got the strike maybe about an hour or 2 later. Immediately went to cut the first thing, and I thought I would just get to cut the other 2. It had to process that whole first cut. I didn't get the 3rd cut done until the following day, and I was checking. So at Paralegal Institute. On Twitter, it's at Institute DC. On Twitter, it's at Institute DC. Yes. Connect with me. Everybody who wants to, y'all reach out to me, but especially if you give me a huge super chat. We got to do something for you. Appreciate that. This is taking a long time. Something's really happening right now. You know how many times I thought that and then nothing was happening? 27. So many times I thought, oh man, something's happening. And then you come back and it's like, nothing happened. You got that good Wi-Fi. Y'all, this StreamYard wasn't working for me at first. So I actually ran a hard line. I bought 100-foot long Ethernet cable. And my Wi-Fi router is in. Oh, they're still talking. Oh yeah, they really talking about this, y'all. So my Wi-Fi router is in the living room, and I ran this cable all the way around everything so I can get it here so that my StreamYard wouldn't mess up. State is offering everyone new deals. Man, they need to just let them go. Just nervous pins and needles. This is a decisive moment. Could be. You know what I don't get? This is what I'm not sure about. Are they going to make the motion and then she'll say, please put it in writing or something, or let me, review it and then I'll tell you tomorrow or something like that. You know what I mean? Like, I'm not sure we're going to get an answer from her today if they say yes. So I'm not sure we're going to see. It could be, but I'm not sure we're going to get an answer from her today if they say yes. I just want everybody to keep one thing in mind, though. If they say yes, the prosecution's still going to argue against the mistrial, and that's not corruption. That's their job. So just because the defense asks for it, the way we've seen Whitaker function is she will then say to the prosecution, which they should be working on it. If they are on their game, they should be working on the reason why not right now. And so if the defense says yes, we would like to request it. Don't read what Whitaker said as, I'll give it to you if you want it. She's saying, would you like to request it? That would require a review by her. Okay. But part of that review is the prosecution is also going to make a statement as to why there should be no mistrial. So if I'm not mistaken, I wouldn't be surprised if Hilton is in communication with Love and Abate and whoever else is on point for her office. So the fact that they argue against it is what we should expect. Okay. That doesn't mean corruption. He never misses when they come back. No, I'm on it. We on it. I wouldn't say I never miss, but very rarely does a missing happen, y'all. I want to see this as much as everybody else. I mean, the defense is winning. Yeah, so like one of my computers is doing its thing. Okay, there we go. If it is a mistrial, the state of Georgia will refile their case. None of them are getting released. This is a RICO case. Yeah, we went over that. That's probably correct. I was incorrect thinking that they would be released immediately, but I was soon corrected. I do think they would have a reasonably strong argument to get released. Because this would be, again, from the prosecutors. This would be on the prosecution. If this had been a juror issue that the prosecution could not necessarily control or being responsible for, then I think it's different. If one of the jurors had brought in a newspaper and showed all the other jurors that Glanville was recused and now we need a mistrial, I think you have a stronger case to keep everybody locked up. But when it's the prosecution that keeps messing up and the prosecution that just messed up this time, I think you have a weaker case, though maybe not a weak case, but it's not as strong to keep them locked up. Inform the jury and keep going. The problem is when I said the jury needs to know, I don't think they're going to tell the jury. The thing that was on the table is a stipulation. The stipulation is basically to say the Quay discussed in the free Quay hashtag is not the Quay over here in court, and it's not the Quay over there in court. That's it. Thugger Daily. Oh, okay. You want to see what people are saying? Okay. I got you. Let's go back to Thugger Daily. Y'all don't worry. I do have... Oh, here we go. My bad.
All right. Ms. Westmoreland.
Thank you, Your Honor. May we approach?
You may.
Sorry, y'all. Oh my gosh. That is crazy. Let me update our approach counter. We're on number 5. Oh my gosh. Mistrial counter 2, approach counter number 5. Let's go over to Thugger Daily. Let's go over to Thugger Daily and look at the replies. You got 111 replies right now. Don't worry, y'all. I have the trial on. I will know for sure when they come back. Let's make it bigger. All right. Oh my gosh. Thugger be on it. Thugger must have that good. Some kind of. I'm gonna have to ask him. Can they actually try? See, this is what I was talking about. People keep mentioning this speedy trial thing. Okay. Thugger says to be determined. I think yes, but the state will be in a huge time crunch. Others disagree with me. So this is what I was talking about, y'all, where they keep talking about can Thug be retried on a mistrial without prejudice due to the speedy trial petition that he made. Thugger says TBD. I think yes, but the state will be in a huge time crunch. Others disagree. We'll open up that discussion when we get there. But reading the statute, it seems they'll have around 2 months to start jury selection. So it's nobody knows. Okay. Let's see what other people have said. Let's see what other people have said to this question. It's kind of a big question. So that's what Thugger said. Would this be a change in circumstances that could also grant bond awaiting a new trial? Answer is yes, it could. Anything could be. Whether it would or not, we don't know. Speedy trial just means you have a right to a trial starting quickly. It doesn't have anything to do with the length of the trial. They will not be able to find a jury. All of Fulton County is tainted. That's a good. So they don't waive those rights. I don't know, but how is this the defense's fault? That's what I was saying. They can 100 choose to do this again if it's without prejudice, not Thug or Shannon. See, people, so this is like part of the folklore of this trial at this point. This is part of the folklore of this trial at this point as to can a mistrial without prejudice result in Thug not being able to be charged again. Clizzle, so basically if you make a face, then it wasn't on purpose, so the state can be sloppy as long. You know, couldn't we all agree, basically taking trial is not back. Trial is not back. This is a trial. We're live. Look. Trial's not back. They came back for 5 seconds, Miss Lely. I don't know if you're I don't know. But we're not back yet. We'll just leave it here. People are nervous. I get it. They're antsy. But back to your question, Clizzle. You do have to ask the question if the accumulation of many accidents or mistakes equals one thing done on purpose. Like, what is the prosecution's true incentive to stop making mistakes if they don't risk the most severe penalty, which is a mistrial with prejudice? Couldn't we say, y'all, that after you've made 20 mistakes that could have resulted in a mistrial without prejudice, that might warrant one mistrial with prejudice? Love is not in the in the courtroom today. By the way, Clizzle, thank you for 2 more super chats. Again, Carl Dorsey came with the big guns, 500. Clizzle, but Clizzle's been on it today. He's just been peppering me with 5 here, 5 there. Let's give a shout out to our new members, Roxy Louise, Robin Dolphin, Sir Montre, welcome, sir. Queen been riding with us every day. Good to see you are a member now. Is that Tasha? I think that's Tasha Sue. We have had a bunch of supers. Clizzle's given a bunch. Gemini Rising has given a few. Binks and Ethan has given a few as well. So y'all just want to, again, always keep coming back to the thank you for that. Yeah, we have a really good thing going on today. Marley Bay, exactly. Make a mistake once, cool. Same mistake more than once is no longer a mistake. This is the 4th time since Thursday. No. When did they get rid of Dennis? Was that Thursday or Friday? I think it was Thursday. This is the 4th time since Dennis, which I think was Thursday. Antoinette, honestly, what you've missed. And don't forget, this is the 2nd mistrial motion today, y'all. I know I got a little pumped right there, but this is the 2nd mistrial motion today. And when you go back and watch the video of the circumstances surrounding the 1st mistrial motion, when you go back and watch that video, you will see that the attorney actually, okay, now we're coming back. No, we're not.
For the day.
What did she say? What did she say? That's it, y'all. She just ended court. No, they aren't back. They aren't back, y'all. I'm gonna back it up. YouTube is, yeah, done for the day. I'm gonna just let that play one more time. Yeah, she did in court, Andre. I'm gonna just let it play. It doesn't really give me the option to pinpoint the moment. But yeah, they just ended the stream. I'm just gonna let it replay. No, I don't think she said it's the jury because the streams went off. The streams went off. Well, Miss Sylvia looks like she's still sitting in court right now. But Law and Crime ended their stream. Why is Miss Sylvia still sitting in court? I'm gonna let y'all hear this, and then we're gonna go to Miss Sylvia because she's still sitting in court.
For the day.
Yeah, that wasn't dismissing the jury because she just walked out. So that is I don't know what happened. We'll talk about it though. What site Paralegal be on? This is YouTube. That was my phone. Scam likely. Oh, Nah, buddy. YouTube don't have any. At least I hope not. Yeah, y'all, we got a cliffhanger. Law and Crime has left. Yeah, no, everybody left the building. I was just coming to Miss Sylvia. Oh, you don't know who Miss Sylvia is? Well, that's it, y'all. So it's over. It's over, y'all. So that's it. Looks like she's packing up. Thank you for Miss Sylvia. I guess I'll see y'all tomorrow. Have a good night. Oh, hold up. Y'all can't blame me for whatever YouTube puts up there, y'all. Please, come on. Y'all can't blame me for whatever YouTube serves to me. All right, y'all. Have a good night. We will see if there's a mistrial mañana. There's a mistrial motion on the floor right now, and we will have to wait and see tomorrow what happens. That's what happened today. There's a mistrial motion on the floor. Yeah, everybody left the building because it's over. Yeah, it's over. So, y'all, I'm going to go ahead and wrap it up. This will give me a little time to do some other things. Love y'all. Yeah, love y'all. Thank you, Andre. Thank you, the new mods, Patron, Gold. Thank you, Miss Lily. Thank you, Amy. Thank you for everybody who sent a super chat today. Clizzle, new members. Just going to do a quick rundown. Clizzle came through big time today. Gemini Rising, multiple times. Binks and Ethan, multiple times. Cammie Phillips. Carl Dorsey came in like Hercules today. So I thank y'all. I'm going to go ahead and wrap it up, y'all. See y'all back mañana. Appreciate y'all. Have a good night.